my lord, is very unfortunate. Much of.
My lord, I am for the petitioner. Please, your lordship. My lord, the case was started under many sections, including 419, 420, 406, 409, 120B of the Indian Penal Code, 7 and 13 of the Prevention of Corruption Act. And now the charges have all carteled down to only 419 and 420 of the Indian Penal Code and sections 7 and 13 1D of the Prevention of Corruption Act. That is, if the charges are somehow even proved, the maximum punishment can be for 5 years for the Prevention of Corruption Act. The allegation is that the complainant,
in custody?
I am in custody for 1 year and 7 months. Why I am removed for bail? I'll submit only 2 points. The complainants alleged that her father has given the petitioner a sum of rupees 30 lakh to aid her in getting the bar license. That time, the petitioner being a police personnel said that he has connections with higher authorities and he will help him in getting the bar license. He took 30 lakhs. The petitioner was first arrested on 17th of May 2023. Thereafter, on 18th of November 2023, the petitioner was released on interim bail by the jurisdictional court till 14th of December 2023. That on condition that he should repay 50% of the alleged misappropriated sum within 14th of December 2023. The petitioner failed to do so. He was again taken back into custody on 14th of December 2023. Till that time, he is in custody. After his rearrest on 14th of December 2023, the petitioner prayed for bail before this honorable court. That is at page 26. When this honorable court was pleased to reject the petitioner's prayer for bail, and if your lordship kindly comes to paragraph 5 at page 27, this honorable court directed that the learned trial court to expedite the trial to the fullest extent possible and conclude the same at an early date, positively within a period of 1 year from the next date and of recording of the evidence. This order was passed on 21st of August 2024. Now, thereafter, what has happened, the changed circumstance, page 15, if your lordship kindly sees. Right now, the petitioner's wife has been diagnosed with cancer. The petitioner's wife has given a demand draft of rupees 15 lakh that was accepted by the de facto complainant. That is at page 15 and 16. That was for 15 lakhs. And rest 15 lakh, the wife of the petitioner, who is a cancer patient, has given by way of a post-dated check. The checks are dated of 31st of August 2025 of the rest 15 lakh. That is at page 17. After having this 15 lakh in demand draft and the post-dated check of the rest 15 lakh.
15 lakh demand draft was received.
Received.
And post-dated check is
15 lakh. Another 31st August 2025 by my wife. Now, my lord, if your lordship kindly comes to the last page of the petition, the very last page. The very last page of the brief, the annexure, the certified copy. My lord, that is the affidavit which has been, this is the page, my lord, the affidavit page. The last page of the certified copy, my lord. The de facto complainant has made an affidavit before the concerned jurisdictional court that if the petitioner is released on bail, she has got no objection. Such no objection was also recorded. If your lordship kindly comes to the order dated 30th December 2025, order number 41. My lord,
Yes.
there also the de facto complainant has stated that she has got no objection if the petitioner is granted bail. Now, my lord, till the time my prayer for bail was rejected, till now, only W1 has been examined out of 12 witnesses. Charges were framed on 23rd of April 2024. My lord, admittedly, if
It was rejected on 7/5.
7/5
Bail petition was rejected.
by the concerned jurisdictional court. My lord, concerned jurisdictional court, it was rejected. Now, my lord, now admitted position is that out of the 30 lakh that was alleged to have been received by me, 15 lakh has already been given. My wife has been diagnosed. Excellent. My wife has been diagnosed with cancer. She has given a post-dated check of 15 lakh more. If the charges are somehow been proved, my lord, my punishment will not, my lord, will be till 5 years, which can extend to 5 years because the charges are now only under 419, 420 and 7 and 13 of the Prevention of Corruptions Act. Now, my lord, what I am humbly praying, if your lordship kindly consider that I am in now custody for 1 year, 7 months. My lord, 50% of the sum has been paid already. My lord, this is the condition, if your lordship kindly considers.
Yes.
Lordship, by an order dated 3/7/2023, this matter got transferred from investigation from Newtown PS to CID. And CID have investigated this matter. Now, your Lordship, the petitioner is the constable. Please, constable, your Lordship.
Yes.
Now, I want to state before your Lordship, the huge amount were taken from the de facto complaint. It's okay in one part. And the second part is that a huge amount has been refunded from the several other persons also. There are statements there, bank statements there, 164 statements are there.
No, we are concerned with this case. Okay. So
They are interconnected. They are the relative of the complainant.
no.
They are known person of the complainant.
No. So far, the other persons are concerned. If there are other cases instituted, that those cases will continue. So for this case, the trial is going on.
This case,
Yes.
the
So
evidence of the complainant not completed yet.
evidence of the complainant not complete.
Not completed.
How many witnesses to be examined?
12.
12.
12. And maximum years of punishment in prevention of corruption?
5 years.
5 years.
5.
And I am in custody for 1 year, 7 months from December. And before that, I have already been in custody for 5 more months.
Please,
406.
My lord, 419, 420 charges framed
if
under
you,
sections 419, 420 and 7 and 13, 1B of the Prevention of
if
Corruption.
your Lordship kindly see the bank statement of the petitioner, huge amount has been credited.
Madam,
He's a constable. From where he is getting
Madam,
huge
more
amount.
than 2
Lakh
years,
rupees, 68 lakh has been credited
my lord,
in his account.
more than 2 years, my
But
lord,
then
I have
he is
suffered
getting all this account.
incarceration.
He is defrauding everybody.
My lord, more than
Prevention of Corruption Act is there.
my lord, more than 2 years, I have suffered the incarceration.
This person,
I have
this
my lord,
complaint is related in huge other persons are also related in this. And 15 lakh he has, is okay, he has, by check he has given. And what about other
by
15?
demand draft.
By demand draft. What about other 15 lakh? He won't pay, I know that, because he has defrauded other many persons.
My lord,
He is a habitual offender.
my lord, if that post-dated checks get bounced, my lord, they will again file 138 against my wife.
And Lordship,
That is a undertaking, my lord, by the wife. She is a cancer patient. I have annexed the documents also.
and there is one person,
This case-
Rizwan,
Case
Lordship,
ID is which
there is
one?
one-
24/2023.
there's a supplement.
Okay, the same case ID.
Yes.
Same case.
And my lord,
Key. Part 2. Lordship, there is one person, Rizwan Ahmed. You have completed your submission, please let me give.
Yes.
There's a
I have
person, Rizwan Ahmed. He is related to this person, petitioner. In his account, 48 lakh rupees this petitioner has credited. From where he is getting all this money? Being a constable? No, 30 lakh is not the factor here.
That is sections 7 and 13.
7 and 13.
7 and 13 of the Prevention of Corruption Act,
Case that you have
punishment is-
cases.
punishment is from 3 months to 5 years.
419 and 420.
419, 420. Charges are only under
Evidence
those
of the victim not completed yet.
Learned advocate for the petitioner and learned advocate for the state are present. Learned advocates for the parties. Produce the materials in the case diary. Learned advocate for the
Not this stage, your lordship.
submits that the petitioner is in custody for 1 year, 8 months. And earlier the petitioner was granted interim bail.
My lord, more than 2 years, because earlier I was in
Not more than 2
custody.
years, 759 days.
Earlier, the petitioner obtained interim bail, but
I'm sorry.
as he could not make payments to the de facto complainant, his interim bail was cancelled. It is further submitted by the learned advocate that earlier the petitioner was implicated under different sections of the Indian Penal Code, but the charge sheet is submitted under section 419, 420, section 7 and section 13. 419,
Exit fixed on 25th
420 of the Indian Penal Code and section 7 and section 13 of the Prevention of Corruption Act 1988.
No, my lord. Charges were framed under those sections.
Okay,
Charge sheet was under many sections. Charge sheet was under section 419, 420, 406, 409, all.
But charge was submitted.
Charge was framed on
Under section 419, 420 and section 7,
23 charge
section
orderটা দেখো
13 of the Prevention of Corruption Act. তাহলে 419
Under section 406, 409, 419, 420
charges framed.
419
charges.
490
Charges date
420
হচ্ছে 23
of IPC.
charges
And section 13 of Prevention PC Act 1988.
জানি আমি
Learned advocate
এখানে
draws
বলছিলাম।
attention to draft of rupees 15 lakh already issued to the de facto complainant by the wife of the petitioner and a post-dated check. Learned advocate submits that the wife of the petitioner is suffering from cancer, and considering the part payment made and the period of detention, the prayer of the petitioner for bail be considered. Learned advocate for the opposite party state objects the grant of bail and submits that the bank account of the petitioner will show receipt of different
না ওর নাম দিতে পারো না।
amounts from different persons, and this aspect is also to be investigated. Upon perusing the materials of the case diary in connection with this case, and upon considering the period of detention with regard to 1 year, 8 months, although the trial has already started and de facto complainant partly examined, it would not be proper to observe anything with regard to the merits of the case, but it is necessary to consider as to whether the petitioner should be granted bail. In order to consider as to whether the petitioner should be granted bail, it is necessary to consider some judicial pronouncements. এবারে প্রথম থেকে ওটা দিয়ে দেবেন, ঠিক আছে? এই জায়গা থেকে অরবিন্দ থেকে না, সবটা নয় কিন্তু ওই অরবিন্দ থেকে যে টিক মার্কারটা আছে, হ্যাঁ ওই অবধি, তারপর পরের আর একটা আছে, ব্যাস ওইটুকুই। Upon considering the facts of the case and the period of detention, which is 1 year, 8 months, and the fact that the case involves examination of 12 witnesses, and at present, the examination of one witness is also not complete, and there may be a delay in the trial. In the interest of justice, the petitioner should be granted bail. I therefore allow the prayer for bail made by the petitioner. The petitioner be released on bail with two sureties of rupees 10,000, one of which must be local, subject to the satisfaction of the learned trial court. The petitioner, upon being released, shall attend court on all dates fixed and shall not meet the witnesses of this case and shall not do anything prejudicial to trial.
I'm grateful to you.
Lordship, may I recorded my submission?
Yes, recorded your objection.
May present. My lord, an amorous relationship turned into a case of initially 354 and thereafter, my lord, 376. My lord, the ambulance driver alleges that while he was passing through the going out of the hospital in a hiding place behind the hospital, a person was seen with a woman pulling her hand. Subsequently, the person apprehended the present petitioner. The present petitioner was, my lord, taken into the police station. A case under section, my lord, old section 354, 354A, 354B, and 511 was started. After recording of the evidence of the 164 statement of the victim, my lord, case under section 376 was lodged. The victim is aged about 36 years, petitioner is aged about 47 years.
Yes. देखिए এটা
This is the 164 statement of the victim. পিটিশনটা গেল কোথায়? এই পিটিশনটা দেখুন তো চলে গেছে নাকি ওখানে পড়ে আছে? হ্যাঁ।
Charge sheet has been submitted, madam. 65 days in custody.
charge sheet submitted under which section?
376.
376 by 511 or
No, no, 376 along with other sections, 376 is there. Initially, case started under section 354, 354A, 354B, and 511 of the Indian Penal Code. But new section is 74, 75, 76, and 62 of the BNS. And subsequently, my lord, charge sheet has been submitted along with other sections. Section
yes, what
376.
is the statement? 164 statement?
164 statement
No,
of
no,
the
this is the
victim lodged-
victims.
Yes.
And
lodged
the
in
the
CCH
witnesses
yes,
160
yes, 16, 18. 16 and 18.
the witnesses 164
So the amorous
61,
page.
16 and 18.
relationship, my lord, caught red-handed in a backyard of the hospital in a hiding
To
place.
hard
This is
even
this
cut-
161. I am
Yes, yes.
164.
There is no other 164 statement.
Yes, where is the medical examination report?
No, not there.
How long you are in custody?
65 days.
Medical name.
So charge sheet submitted under 74, 75 and 76.
Yes, 376.
And earlier it was 354 and 354A.
This one. 74, 75, 76, 354, 354A, 354B of the Indian Penal Code.
So medical examination is refused.
Well, refused.
কিছু নেই আর কি বলবো এটা
Learned advocate for the petitioner and learned advocate for the opposite parties state are present. Are learned advocates for the parties. Peruse the materials in the case diary. Service upon the de facto complaint is complete.
Service? Yes. What's it? Return.
So service is returned. So
It
it's
would not be located.
so it's better you serve again.
It is directed to serve.
So, okay, learned advocate for the petitioner and learned advocate for the opposite party are present. As the service could not be effected upon the de facto complainant, let the state serve the,
Yes. এটা ডেটা রেকর্ডেড হচ্ছে
and it has returned,
না না সার্ভিস
let the state cause service upon the de facto complainant. Let this matter appear on 10/6/2025.
Madam. And Dostar.
Yes.
My service complete in this matter.
Yes,
Next matter.
item 10.
10. But this case is of a different nature. This is of two steps are there. One is 420, 419, 406, 468, 471, 120B of the Indian Penal Code, and another part is 376. A 36 years old lady says,
I
Bro.
was directed to start copy of the de facto complaint. I have start.
Bolbo. Now, my lord, there are two parts of the story as I have stated before your lordship. The case goes like this: a 36-year-old lady says that her child wanted a job. For that purpose, the present petitioner, my lord, posing himself to be an employee of Tata Steel, told her that I will arrange for a job for your son, and for that matter, from time to time, he took, my lord, around 7.5 lakhs from this person, from this lady. Now, the second part goes like this: that while she was, my lord, while she was allured to give this job for the son, she was taken to a hotel. She was at Jamshedpur. She was ravished over there by the present petitioner, and as such, this present case was initiated. Now, my lord, if your lordship sees the 161 statement of the hotel owner, hotel manager, the name is, my lord, hold on. The name is, my lord, Rajkumar Ghosh. Lordship would find that the hotel manager says that though there is a register, but there is no, my lord, the entry of the present name of the present petitioner over there. As such, my lord, the case of the victim lady about the allegation of rape is, my lord, was an absurd one. Now, my lord, I was not taken into police custody, and nothing was recovered from my possession with respect to the forged document, with respect to the forgery part. But I am in custody for, my lord, about 8 months. It is 8 months for 5 months. I'm in custody for 5 months and 27 days, and my lord, after a delay of 8 months and 23 days, the present case was registered against me.
Yes, give the case.
Kindly see the FIR first, thereafter I shall rely on 164. That's the first page 2 of it, page 1.
Yes.
Petitioner is the principal act.
So this is the first affair regarding that fraudulent representation and taking money.
And along with rape.
That is
Middle portion of that is the FIR, my lord, part is
yes, page 3.
page 3, my lord. My lord, page 3 first paragraph, গত 17/5/2024 তারিখে আমার জামশেদপুরে ট্রেনিং হওয়ার কথা বলে এবং আরো সাচ একটা কোথায় গেল, এই যে আই এম সরি, my lord, page 2 লাস্ট প্যারাগ্রাফ। 1 নম্বর আসামি হোটেলের বাইরে পাইয়ে আমাকে একা পাইয়ে জোরপূর্বক সাচ। Page 2 last paragraph is with respect to rape. And, my lord, in the medical report, she does not name me.
Now, lordship, kindly see, I have marked 2 other cases on the FIR. Lordship, kindly see the last.
No, these are the other cases which are in which the petitioner is involved. Yes, now with regard to 164 statement.
164 at page 38.
Page 38. Oh, 38 is the request.
Lordship, may I find it out? Flag mark must be there.
Oh, flag mark.
It's 38.
No, 38 there is no 164. Yes, 38 there is one. But there are 2 page 38.
বলুন কোন কোন কেস নিয়ে বলছো দ্রুত, এক্সট্রা দুটো কেস, কি কি কেস? আচ্ছা আচ্ছা, এই মানুষই দিকে আমি করছি আমাকে ভালো ছেলে পেয়ে, নিরীহ তো আমি তোমার মতো।
her son and another person, they were paid for making Xerox.
After 8 months, 8.5 months, he
Okay,
wrote,
where is the medical examination report?
yes, madam.
See page 28. That is another graph just before that.
Yes.
Yes, madam. History, Lashul, can you see the column history? Fourth line. জোর করে একজন. She knew me very well, but she did not name me. Whether this is a case of 420 or this is a case of 376.
বলেই যাবি মাইলরকে দেখতে দে।
আচ্ছা বলছি না।
Now Lordship will kindly come to his antecedents at page 125 and 131. Last two flats.
One 125.
Lordship.
No, this is a complaint by another person.
Yes.
No, that's a different issue. I'm
Yes.
Similar type.
yes. No, that
I am on bail on this matter.
that case will be pursued by you definitely.
Definitely.
That you will
Definitely.
prosecute that case.
Similar type.
But there is no 376. But
No,
here
no.
in this case is 376 is there.
And she is not.
He said that provide me some money, I shall give.
That is something different.
Tata Steel.
That is something different, my lord.
The other cases,
My learned friend is trying to jump.
there are several cases. How many other cases are there? I don't know.
I am on bail unless and until I am convicted on this matter. If you, my
You
learned
don't
says,
bail on this.
yes, yes.
Sudhakar,
Yes,
please
yes.
satisfy the court, then you are on bail.
Sorry? You satisfy that. কি কথা বলছি?
Several cases are there. If my lord wants to.
But 376?
Yes, any statement of that hotel manager?
Yes, my lord, is there.
Which page?
আমি কেসটাও বলে দেবো। রাজকুমার ঘোষ।
Let's see, may I find it out?
রাজকুমার ঘোষ দেখো।
Hey, you don't have the
Supplied copy, my lord. Thereafter, let my learned friend see, my lord. In the meantime.
Because if several cases, dupe the persons for giving job in Tata Steel.
কোথায় কোথায়?
He has taken crores of rupees. That is the allegation.
নেতারা নিচ্ছে তখন কি হয়?
Cases of similar nature.
And my lord, charge sheet, my lord, if you are.
charge sheet submitted under which section?
My lord,
Charge sheet submitted?
a charge sheet are submitted under section 420, 419, 406, 376, 465, 468, 471, 120B, 34.
You are in custody for 5 months.
5, yes, my lord, 5 months, 27 days.
The habitual offender.
সবাই দাদা একটু এখানে।
Yes.
And two other accused persons still now have got.
না না না
Yes.
In this case, any other accused person on bail in this case?
They are absconding.
মানে out of
A learned advocate for the petitioner.
but three
and
have been
learned
enlarged on
advocate
bail, one is in I am in custody.
opposite party are present.
Sonali Bibi and
Are-
Chandan Das.
That তোমার
Learned
instruction
advocates
কত?
for the parties peruse the materials in the case diary.
চন্দন দাস
Learned
is
advocate
absconding,
for
both
the
other have.
and
না 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 সোনালী বিবি on bail.
that
I'm on bail.
his
On
client
bail.
is falsely implicated in the instant case,
Will not mislead the court.
and the
Understand?
complaint in the instant case was lodged
Like Mr. Court.
after 8 months from the date of the alleged incident. Learned advocate submits that the allegations made against his clients are not maintainable. Yes,
Statement is there that money has entered into the account of this petitioner.
learned,
Allegation is of cash. He is saying of my lord
Yes.
bank statement.
learned advocate for the
বলছে
opposite party submits
সে দিয়েছে বলছে
that the petitioner is a habitual offender
বড় লোক ডিফেক্ট
in cheating people, and there are other complaints against the petitioner. And it is further submitted that different amount has been credited to the petitioner's bank account.
Huh?
Upon perusing the materials in the case diary and upon considering the facts of the case, although it would not be proper to observe with regard to the merits of the case, but it is necessary to consider as to whether the petitioner should be enlarged on bail. In order to grant bail to an accused, it is necessary to consider the nature and seriousness of the offense, the conviction which the accused will suffer in case of the sentence which the accused will suffer, in case of conviction, the chance of abscondence and tampering of witnesses. In the instant case, with regard to the offense under 376 IPC, this court has perused the statement under section 164 CRPC and the medical examination report and the statements of the hotel manager where the alleged incident took place. Upon perusing the statement under section 164 CRPC and considering the fact of delay lodging of complaint and the medical examination report, this court is of the view that as there is no reasonable apprehension to abscond, the petitioner should be granted an opportunity to remain on bail. Thus, I allow the prayer for bail made by the petitioner. Hence, the petitioner be released on bail with 2 sureties of rupees 10,000 each, one of which must be local, subject to the satisfaction
এসিজেএম হলদিয়া
of learned SCGM Holdia. The petitioner, upon being released, shall meet the officer in charge of the concerned police station twice a week and shall not meet the de facto complainant and the persons acquainted with the facts of the case and shall attend court on all dates fixed.
I'm grateful to your lordship.
Your Lordship, I'm for the de facto.
I'm for the state.
May it please your lordship.
So for the petitioner,
Ma'am, for
Sir, my lord, this is the
or for the state,
state. All parties,
De facto complainant, Your Lordship.
all parties are there.
yes.
No, that essentially under section 6 of the Protection of Children from Sexual Offences Act, my lord, the petitioner before your lordship, my lord, he's aged about 56 years. My lord, he is supposedly the landlord where the victim and the mother along with the family used to reside. My lord, the petitioner, your lordship may kindly mark, is in custody for 2 years and 3 months.
No, the case is from
Of 2016, and my lord, I have been arrested on 7th of February 2023.
no,
That-
but why were you absconding in all
My
that?
lord, charge sheet was submitted, but I was on the strength of I was not, there was no indication in the charge sheet that I was absconding. In the charge sheet, my lord, because your lordship, the cases of a different nature, if I can come one by one. But as of now, I am in custody for 2 years, 3 months. I was arrested on the 7th of February 2023. My lord, first point before your lordship, my lord, before I go into the merits of the case, is my point of Article 21. That an under trial prisoner, my lord, how he is being kept without a trial. Lordship may kindly takes up, my lord, first, page number 9 of my application.
Yes.
My lord has seen, my lord may marks it. Order dated 17th of March 2023. My lord, this is the order on which charges have been framed at page number 9. So charges were framed on 17th of March 2023. My lord, marks the date. Now, subsequently, my lord, your lordship will see all the orders. Your lordship can see one after the other. The witness did not turn up. PW1 being the victim girl, the witness did not turn up. Finally, your lordship may kindly takes up page number 22. Your lordship can see all the dates. Your lordship can have it from me, my lord. The witness did not turn up. PW1 did not turn up. From the next date fixed, that is on and from, my lord, 2nd of May 2023 till about 14th of August 2024. That is at page number 22. My lord, seen it, my lord?
Yes.
So, my lord, for about 1 year and 3 months, my lord, the witness did not turn up. My lord, subsequently on 14th of August 2024, my lord, PW1 is examined. And on the same day, she was cross-examined. Now, your lordship sees from thereafter. Once again, till date, no witness has turned up for PW2. Till date. One after the other, I've shown. There are 11 witnesses in this particular case.
What is the last order?
Last orders, my lord, I'm handing it over to your lordship. Last date was fixed on 12th of March. I'm sorry, my lord, this was a photograph of the order which I had. My lord, we had, right now it is a vacation bench, we could not. But the state has it, my lord. None of the dates witness has turned up, my lord.
12/3/2025.
Also witness did not turn up.
Thereafter,
My lord, thereafter also witness, your lordship may ask the state, still date the witness has not turned up. Now, my lord, over here, first and foremost, my lord,
how many witnesses are there?
11 witnesses are there. This is my chart sheet. I'm handing over the chart sheet to your lordship.
Merit of the case.
My lord, over here, my lord, this is, my lord, if the state has some, my lord, decorum as far as the petitioner is submitting, my lord, they should not interfere in bringing your lordship's court to the merits of the case
Yes.
when Article 21 is up to the merits of the case.
Now-
My lord, I'm coming, my lord, on the touchstone of Article 21 first. So your lordship is seeing, my lord, I am in custody for 2 years, 3 months, where after 1 year, 2 months, PW is examined from the date fixed for the examination, and then again from 14th of August 24 till date, is not examined. Not examined till date. Now, my lord, they are so eager to bring your lordship to the merits of the case. My lord, they will show, I am showing it to your lordship, my lord, I will show the merits of the case. Lordship may kindly takes up page 7 of my application, PW1's evidence. They cannot go. They are showing the case diary, my lord, 164 they'll show. I'm showing the evidence.
Page 7.
Page 7 of my application.
Yes.
But this is what they will show. I don't want to place it.
Yes. What do you want to
Yes, Lord.
suggest?
Lordship, see, goes to my lord. I don't, my lord, wish to, my lord, place it. My lord, that is in itself, in a nutshell, my lord, that is the merits of the case which they are trying to show. Is that this victim girl was ravished, my lord, by the petitioner. Now, your lordship, what they will not show, my lord, let them, my lord, first produce it before your lordship. The first page, my lord, is the medical report of this victim girl. Well, let them show the medical examination report of this victim girl.
That is there in the case diary.
Well, let them show that page, my lord. And then your lordship matches it with these allegations which are there. Insofar as the merits of the case goes, whether the medical legal examination which has so been conducted by the investigating officer is substantiating this particular evidence or not. Whether the medical report is substantiating the case or not.
She was 3.5 years old.
Okay. Anything else to submit on the points of law?
My lord, points of law, this is first point, my lord, the medical report, whether it is substantial. That is my entire, my lord, this is a case of Protection of Children from Sexual Offences Act, where she says that there has been insertion which is done, as far as what I can understand, from her PW1. Or rather, the main backbone of this entire foundation would be the medical report, whether it substantiates or allegations. Because she was a child of about 3.5 years to 5 years age at that point of time. She has said that 5 years in her evidence. In a PW1 evidence, she has said she was for 5 years. So whether the medical report substantiates her allegations or not. And secondly, on the touchstone of Article 21, which is above the merits of the case, that I am being undetained without a trial, witnesses are not turning up.
Question is, the case is 2016, but why have you submitted?
They have submitted, my lord, they have submitted charge sheet only in the year 2019. For 3 years, they have invested. This is my charge sheet. That they will not show, my lord. This is the charge sheet. See the date.
I'm nothing to hide.
There is charge sheet has been submitted after 3 years.
Your lordship, she was 3.5 years of age at the time of the incident.
Now, my lord, I am in custody for 2 years, 3 months. My lord, I am leaving everything aside. Today, my lord, if a person is being detained without trial, my lord,
Your
today
lord,
without trial, no witnesses are turning up. Why no witnesses are turning up? Lordship will seize the medical examination report. Prosecution is not being able to produce the witnesses, despite direction of the trial court. That is one thing they will not say, my lord. Article 21 is above that.
your lordship, a child of 3.5 years was ravished at that age. Your lordship, the mental trauma she had gone through, your lordship now kindly considers. And the
7 years.
and the examination and the cross-examination of the PW1, that is a victim girl, is concluded, your lordship. Your lordship,
PW2 is the mother of the victim girl who is not turning up. On 7 occasions, she has not turned up. Madam, may kindly see the medical examination report, whether this is a genuine story or not.
Half
Years
years old girl, but
no, she will not make up stories.
See, that is the basis on which, my lord, a person is being kept in custody. She will not lie. Very shocking. A presumption under criminal law that she will not lie.
47 is the 161 statement. 47 is the 161. Yes, 164. Yes, well,
56.
Mother of the victim.
But they are not showing the medical report.
He stated page 36.
no, this is the de facto complaint statement. The victim girl's 164.
At that age, well, at that time of
She was 3.5 years.
3.5 years.
So she could give 161 statement, she could not give 164 statement at that age. This is the submission of the state.
Your lord,
Oh, in POCSO cases, usually it is recorded. If she is able to speak, because 3.5 years, she is able to speak.
Madam, may kindly see the medical ones, madam.
এটা ঢুকিয়ে দিন।
Able to see.
Madam, may kindly see the medical ones, madam, whether that this is substantiated or not.
Yes, page.
medical.
No, medical
Medical.
exam. Yes, this person was arrested or he surrendered?
Arrested, your
My lord,
lordship.
arrested. For 7 years
He was absconded.
Then, my lord, arrested in the year 2023.
From which place?
That is why I have the warrant of arrest. I'm showing the
Where's
place of
memo
arrest.
of arrest?
Yes. I have the memo of arrest, my lord.
One memo of arrest.
Just see. I'm grateful for that. My lord, this is the arrest memo. Lordship sees the place of arrest. My lord, the backstory is evident from the cross-examination of PW1. Landlord and tenant. They are the tenants, I am the landlord. I don't want to make any more submissions, my lord, on that aspect, but I'm restricting myself. Lordship sees the place of arrest. I'm grateful for your lordships, my lord.
Your lordship, may I point out two things?
Yes,
May I point out two things, your lordship?
yes.
Firstly, which I have stated earlier, she was 3.5 years old at the time of the incident. Secondly, this question is I am asking to myself, if the person is not guilty, why have you absconded for 7 long years? Thereafter, he got arrested. I do not have the memo, the venue from where he got arrested, but this is the fact that the prosecution has submitted the charge sheet in the year 2019. All right, but he had absconded for 7 years. That also remains a fact.
My lord, today, if I can give one response to this, my lord, may kindly takes up page 8 of my application once. My lord, may kindly takes up. My lord, your lordship asked a very pertinent question to them. Why did you not record the 164 of the victim girl? Correct, my lord? Now your lordship will see when the girl's 161 statement was taken. Lordship, may kindly takes up page 8 of my application. After 1.5 years, when she was 5 years old, at that point of time, the 161 of the victim girl was taken. Lordship, may kindly see page 8. Page 8, my lord, the third last point. It is true that I was 5 years old when the police interrogated me. My lord, it is the cross-examination part. Has your lordship got it?
Is it not possible?
It is true that I was 5 years old. My lord has got that place.
Yes.
It is true that I was 5 years old when the police interrogated me. So, my lord, 161 of the victim girl could be recorded, 161 was not recorded. I am leaving that aside. My lord, the medical evidence, my lord, does not support the victim's case. That is the second point. My lord, the third aspect in this particular case, my lord, is that I am in custody for 2 years, 3 months without a trial. Witnesses are not turning up. PW2 till date has not turned up. My lord, the only place in which they are trying to prejudice, my lord, is that I have been absconding for 7 years, yet the arrest memo shows I was arrested from my place of residence. My lord, this is a case which smacks of other elements also, my lord. The person is a landlord and these persons are tenants. My lord, POCSO case is a very easy case to fasten on any human being against whom there is some form of a dispute. My lord, this is one of such elements. Otherwise, why are they so afraid to go for a trial, my lord? I'm asking this question to myself. Why is PW2 not going and proceeding with the trial? If they are so sure about the facts of the case, I could have been convicted by now. But there are other elements over here. I'm being kept without a trial, my lord, in this case. In a case of protection of children from sexual offences act. But I'm ready and willing to reside outside wherever they reside.
The neighbor statement was going to be
And 11 witnesses are there.
Page 7.
Page?
Page 7 and 10. 7, 10, 11.
Page 7.
7,
10, 11. No, 7, my lord, there are two statements. The second part, my lord. First part is the mother, second part is the Bada people. And page 10, two witnesses, my lord. They had no committee, my lord.
This is, my lord, 161 statements. They don't turn up.
Bada people, my lord, they had no enmity with either of these parties.
Parties are not turning up for trial, my lord.
Page 7, 8.
7, my lord, 10.
7 and 10.
There are two statements. One in the bottom and one in the...
They are not turning up for trial, my lord, and I'm being kept in custody without any reason.
7 years he can abscond, my lord.
So that is why 7 years I have to be in custody before I pay for bail.
Yes.
But that is the only ground. 7 years. On the merits, there is nothing. Medical evidence is not there.
Learned advocate for the petitioner, learned advocate for the state, and learned advocate for the de facto complainant are present. Third, learned advocates for the parties. Peruse the materials in the case diary. Learned advocate for the petitioner submits that his client is not involved in this case and the allegations made against his clients are not maintainable. Learned advocate further submits that his client is in custody for 2 years, more than 2 years, but till today, only one witness have been examined. It is also submitted by the learned advocate that the medical examination report of the victim girl will not support the case of the prosecution. Learned advocate appearing for the state draws attention to the statement of the neighbor, statement of the de facto complainant in the 164th in the statement under section 164 CRPC, as well as the medical examination report. Learned advocate for the state submits that the petitioner was absconding for a long period and his bail prayer should be rejected. Learned advocate for the de facto complainant also submits that the victim girl was only 3.5 years age, and her statement could not be recorded. Upon perusal of the medical examination report, now upon perusal of the materials in the case diary, it appears that the statement of the victim girl was not recorded under section 164 CRPC, and the victim girl was examined after a period of 1.5 years from the date of the incident. Upon perusal of the statements of the neighbor and statements of the de facto complainant in both once under 164 CRPC as well as section 161 CRPC, there appears some contradictions, but at this stage, no observation should be made with regard to the merits of the case. But it is necessary to consider as to whether the petitioner should be granted bail, as he is in custody for more than 2 years, 1 month, more than 2 years, and at present only one witness have been examined. In this regard, it is necessary to consider some judicial pronouncement. We Arvind pronouncements. ওই জায়গাটাই Arvind কেজরিওয়ালের ওই জায়গাটা দিয়ে দেবেন। Upon considering the fact that the petitioner was arrested on 7/2/2023, it further appears that he was arrested from his place of residence, and there is no prayer appearing in the case diary where the IO sought a warrant of arrest against the petitioner. Thus, the case of abscondence of the petitioner and ignorance of the willful abscondence of the petitioner cannot be observed at this stage. As the petitioner is in custody for 2 years, 1 month, and at present 11 more witnesses are to be examined. 11 more witnesses, 12 witnesses total.
11.
10 more witnesses are to be examined, which may take a considerable period. In the interest, and it is found from the records that the witness have not turned up for a period of 1 year. This court is of the view that in the interest of justice, the petitioner should be granted bail. Thus, I allow the prayer for bail made by the petitioner. The petitioner, upon being released, the petitioner shall be released on bail with 2 sureties of ₹10,000, one of which must be local, subject to satisfaction of the learned trial court. The petitioner, upon being released, shall meet the officer in charge of the concerned police station once in a week shall not meet the de facto complainant and the victim and shall not enter into the locality where the victim girl resides without leave of the trial court. The petitioner shall also attend court on all dates fixed.
But to the satisfaction CJM Barasat,
I made it to the satisfaction of the learned trial court.
trial court will be special POCSO court.
Whatever it is.
Deep brigade.
ওই যেটা
Deep brigade.
My lord, I am for the petition. My lord, the allegation is under section. That the allegation is under section 302. I am aged about 21 years. My lord, I am praying for bail only on the ground of violation of this honorable court's direction and on the touchstone of Article 21. My lord, if your lordship kindly comes to page 9 of my application. My lord, my prayer for bail was rejected when on 16th of October 2023 with a direction upon the trial court to conclude the trial within 18 months. That is within 1 year, 1.5 years. My lord, till that time, my lord, till now, even after the completion of 1 year and 6 months, my lord, the trial has not yet been concluded. I am in custody for about 3 years and 6 months. My lord, 18 out of 31 witnesses had been examined. And my lord, when my prayer for bail was rejected, it was observed that since one of the vital witnesses was yet to be examined at that time, my lord, the prayer for bail was not allowed. By this time, my lord, that vital witness has also been examined.
How many
PW10.
witnesses are yet to be examined?
My lord, 18 out of 22 are yet to be examined. And I'm in custody for 3 years and 6 months. My lord,
No, 22 are yet to be
examined. Examined 22, others only 3 are there. Rest of
31
is there.
charge-sheeted witnesses.
Not any more lordship, only 3 are there.
And my lord, 1 year and 6 months has already
31.
passed. I am renewing my prayer. My lord, 2 friends, they were standing. My lord, there was a hot altercation. The incident happened at the spur of the moment. The petitioner is aged about 21 years. My lord, he is a young boy and my lord of tender, my lord of this age. My lord, may kindly considers that when this order of this honorable court was communicated, even
How many are in custody?
6 months. Only on the touchstone of Article 21, my lord, I am renewing my prayer for bail. And my lord, there was no pre-motivation as well. If your lordship sees PW10, I have annexed. He was a vital witness who was that time to be examined. My lord, he has categorically stated he was a vital witness. PW10. And my lord, the order, the petitioner was arrested on 28th March. Dharao. My lord,
Out of 31, 18 witnesses have been examined.
my lord,
Yesterday and today is fixed for the evidence. Evidence is completed, lordship. PW 21 and 22. Only 3 are there. We need just 3.
my lord,
witnesses.
charge sheet witness
Within
is
1 month,
31.
completed the, yes. No need to all. Within 1 month, witness evidence is completed, lordship.
My lord, any fruitful purpose will be served by keeping me in custody, my lord. When all the vulnerable witness had been examined, my lord. There is no chance of any tampering of the witness. This honorable court directed the trial to be concluded within 1 year and 1.5 years. My lord, I am only 21 years. My lord, I have annexed the entire deposition.
Lordship.
My lord, I have annexed the entire
He
deposition.
is presently aged about 21 years.
Yes, no, my lord. He was
aged.
aged about 21, so my lord, now he will be 23.
And this case is pre-motivated, lordship.
My lord, any
He purchased the
fruitful
knife. He purchased the knife. The deposition of the shopkeeper is there, and that was for the kindly see the deposition of PW7, lordship.
my lord, I have annexed.
Annex.
PW7.
Yes, my lord, to my petition. My lord, since those were yet
Para 1.
Yeah, since those were that time to be examined, my prayer for bail was rejected. It was observed by this honorable
Yes,
court.
which para? Para?
Para one,
Para 1.
PW7.
PW7. He was a vital witness who was to be examined that time.
And last thing together.
No, where, yes, 38,
Last
2022.
Has my lord got it? PW7.
That is page of the,
Page was-
Page number, my lord, cannot be given.
yes, certified copy.
Surojit Shaha.
No, date.
Date of examination is 17 November 2023.
And his 164 is also there. It is corroborated, Lordship. Darawala.
My lord, I am not disputing that. So, my lord, he has now been examined.
And PW8.
If, my lord, my charges are proved, my lord, I will be convicted. But, my lord, what purpose will be served, my lord, by keeping me in custody?
PW 15,
PW8, Lordship, para 3.
PW 8.
Para 3, last portion. Now, offending weapon are seized from his leading statement, Lordship, within 2 days of arrest.
My lord, 3 years and 6 months.
Yes, PW 8.
Yes.
Yes, Lordship. Para 3, last portion.
My lord, that is a knife purchase. There is no FSL. My lord, no FSL.
There, Lordship.
FSL.
FSL is there.
My lord, I stand corrected.
Knife,
My lord,
exhibit A1, Lordship. FSL is there.
and PW 7 and 8 were the vital witnesses who were at that time to be examined. That was observed, and my lord rejected my prayer for bail by this honorable court. The direction of 1 year and 6 months elapsed. I have renewed my prayer for bail only after the expiry of the said term. And my lord, only after the examination of the vital witnesses are over. Now only the, my lord, official witnesses are to be examined.
Constable is
My lord, official witnesses are to be examined. IO and constables. My lord, nothing can be tampered with. It is a
day-to-day evidence is going on, Lordship.
I am only aged about 23 years, my lord.
So,
But running commentary can.
So it, as per the
My
record,
lord,
17, examination of 17 witnesses over.
no, 22. Yesterday is the date and today is the fixed court date.
Okay, 17,
And 22.
My lord, when I filed this application, it was 18
18.
witnesses. Yes, it was at
After
total
that,
is?
27.
total in the charge sheet 33. 31. Total in the charge sheet 31.
Three.
And the remaining witnesses are the official witnesses.
No, total charge sheeted witnesses are
31.
31.
31.
Out of which 18 witnesses are already, 22
Is
witnesses.
completed, Lordship. With
And
the
1 year, 3 months,
witnesses.
my lord, 1 year, 6 months elapsed. Vital witnesses examined. Independent witnesses.
Order, Lordship, just 18 months is over.
So, my lord, this honorable court, when passes,
Real of that is
My lord,
we are-
I have annexed this on the entire order sheets. No witnesses were present on several occasions.
আরে evidence চলছে, যাচ্ছি
Yes. Learned advocate for.
And Lordship, this is the last month to taking the evidence.
Yes,
There are 3 arrested witnesses are there. We completed the evidence last month, this month.
learned advocate for
And
the
the rest
petitioner
were the
and learned advocate
official
for
witnesses.
the state are present. Are learned advocates for the parties.
And
Peruse the
motive, Lordship, that
materials.
touches the die.
That
the
pass
case
হচ্ছে তো।
diary. Learned advocate for the petitioner submits that his client who is only 24 years of age is in custody for more than 3 years.
We have
And-
6 months, my lord.
3 years,
6 months.
6 months, and the trial is yet to complete. Stop.
And Lordship, speedy trial is going on, Lordship. Speedy trial is going on.
It is learned advocate further draws attention to order dated 16/10/2023 and submits that the prayer of the petitioner was last rejected on the ground that the vital witnesses was yet to be examined, who are already examined at this stage. Stop. Learned advocate also draws attention to the order sheets. Stop. Learned advocate for the state opposes the grant of bail application and submits that the materials will show the involvement of the petitioner, direct involvement of the petitioner, and it is a pre-motivated crime. Learned advocate further submits that at this stage, already 22 witnesses have been examined and only few witnesses are yet to be examined. Upon perusing the materials in the case diary and upon hearing the learned advocates, although the nature of the offense is very serious, and at this stage, it would not be proper to make observation with regard to the merits of the case. But it is necessary to decide as to whether the petitioner should be granted bail, considering the fact that he is in custody for 3 years, 6 months. In this regard, it is necessary to consider some judicial pronouncements. As this case is under section 302 IPC and most of the witnesses have been examined, but it appears that 11 witnesses are yet to be examined, although learned advocate submits that all witnesses will not be examined and only few witnesses will be examined. Only three witnesses will be examined. Thus, considering the period of detention and the nature of offense, it is also necessary to decide as to whether the petitioner should be granted interim bail. Interim bail. এবার interim bail ওটা কোটে দাও ঠিক আছে quotation. Upon considering the nature of the offense, the period of detention, this court is of the view that the petitioner should be granted an interim bail for a period of 6 weeks. Hence, the petitioner be released on interim bail for a period of 6 weeks with 2 sureties of rupees 10,000, one of which must be local, subject to the satisfaction of the learned trial court. The petitioner, upon being released, shall meet the officer in charge of the concerned police station twice a week and shall not enter into the locality where the incident took place and shall not leave the jurisdiction of the court and shall not meet the persons acquainted with the facts of the case and shall attend court on all dates fixed. On completion of 6 weeks, the petitioner shall surrender before the learned trial court. The learned trial court may extend the interim bail or may pass such other orders as the court deems fit and proper.
I'm grateful.
Not under compelling
Yes.
Item number 44, my lord, it's an anticipatory bail application. But dispute
Let me-
between
let me
two
come-
brothers. The
let
only
me
thing
come
is,
at-
my
let me
lord,
come at 2 p.m. Okay.
My lord.
At 3 p.m. I shall consider what are urgent or what are non-urgent.
My lord, under compelling.
From 2 p.m. the list will be called on serially.
জলপাইগুড়ি বেঞ্চ
Yes.
only 3 matters are there জলপাইগুড়ি bench.
but Jalpaiguri,
Would
there
your
are
lordship permit me to mention, my lord, one matter?
I
My
can,
lord, I'm appearing virtually, my lord. My junior is there, my lord. Unfortunately, I can't.
We take a chance at 3 p.m. Okay, 3 p.m. I shall consider which is urgent. Apart from bail matters, with regard to criminal revision matters, I shall consider.
জলপাইগুড়ি also bail matter, that is why.
Yes, yes. At 3 p.m. At 3 p.m. I shall consider with regard to Jalpaiguri matter as well as with regard to criminal revision matters, which are very urgent.
My lord,
Bail matters I shall dispose of.
my lord,
my
under,
lord,
my
my lord, would your lordship, my lord, permit me to mention one matter, my lord, virtually?
They have sent a case diary without 161 statements, we have written it back.
Okay, if 45, if you pray for time, I can make it not today. Okay, item 45. Okay, item 45, make it not today.
My lord, item number 19.
Would not be taken up.
Okay, if you want to pray for adjournment, please come at 2 p.m.
My lord, under compelling circumstance, my lord, item number 19, if it can be taken up at 2 p.m. My lord, the petitioner number 1 is suffering from cancer. I have annexed all the medical documents.
I shall take up the bail matters. I have granted opportunity with regard to 3 Jalpaiguri matters and revision matters. That with regard to urgency, I shall consider if it can be taken up. But bail matters, I'll take it up.
My lord, item number 100 for withdrawal, my lord.
Okay, mention at 2 p.m.
My lord,
And
is that mentioned?
my lord.
Yes, for your information, all bail matters and anticipatory bail matters will be taken up. Thereafter, only those matters, criminal revision and civil revision matters, which cannot wait till Monday and to great urgent, only those will be taken up.
My lord, we had mentioned in the morning, my lord, item number 78, Lordship had indicated at 3 p.m. to come at 3 p.m. Only, my lord, I was.
Instead of 3 p.m., let these applications be over, these bail matters, and those matters which were mentioned out, those matters which cannot wait till Monday, those will be taken up.
Lordship, from 3 p.m. my lord will take up.
Not 3 p.m., let this be.
Because
taken
at
up.
3 p.m. Lordship has already published a supplementary list.
No, that's a
For
different issue.
motion.
If a list is already published, that will be taken up for today, supplementary list.
My lord.
But those which were mentioned and I granted liberty to
My lord,
move at
to
3
come at
p.m.
3 p.m.
I am clarifying that after these bail matters and anticipatory bail matters are over, those matters which are very urgent and mentioned in the morning, those will be taken up.
Lordship.
My lord, the bail matters from the circuit bench, and circuit bench, my lord, circuit bench bail matters, 3 matters only there.
No, you have mentioned in the morning.
My lord, I had mentioned,
But I-
that Lordship had said that bail matters will be taken.
No, revision matters, you have mentioned revision matter.
No, bail, circuit.
I have clarified that all bail matters will be taken up. Yes, it will be taken up. All bail matters will be taken. My lord,
Withdrawal, my lord.
division matter, my lord. Yes, item 100.
For
You
withdrawal.
are for the petitioner.
Yes,
Hey, record an order.
my lord, I
Item 74, I mentioned morning, my lord, criminal division, very urgent.
mentioned in the morning, my lord.
Item 100.
Yes, my lord.
Yes, learned advocate for the petitioner is present and submit that his client is not interested to proceed with this application.
My lord,
This,
the order did but
as this application has become infructuous
the order has been executed, my lord.
and the order has already, as this application has become infructuous, let this application be treated as not pressed and withdrawn.
আমার বয়স কত?
Item 74, my lord, I have mentioned in the morning, very urgent. Criminal division,
Item
my lord.
74 regarding what?
My lord, criminal division, my lord.
Division, anyway, it will be taken up after this bill matters and anticipatory bail
89, my lord, I have mentioned Mr. Dev is leading me in this matter.
matter.
In morning, Mr. Dev is appearing virtually, my lord.
Division.
Division.
I appear on behalf of the petitioner. Unfortunately, my video is not working. There is some urgency, my lord. Item 89, my lord.
Yes, after the bail matters, it will be taken up.
Very
Also,
well, my lord. Item number 89, kindly consider.
My lord,
Grateful, my lord.
Grateful, my lord.
my lord, my lord,
For the statement.
My lord, I am for the petition.
my
yes, it is.
As per direction of this Honorable High Court, the
my lord, I am mentioning item number.
Yes, mention after these matters are over. Okay, service upon the
victim.
victim is.
My lord, I am for the petition. My lord, allegation is under section 6 of the Protection of Children from Sexual Offences Act. My lord, the petitioner is aged about 18 plus years. And my lord, the victim, my lord, the girl has been said to be 10 years. My lord, it has been alleged that the victim girl, when went to the house of this petitioner, my lord, she was ravished. My lord, in her statement under section 164, she has also said that, my lord, she was ravished. My lord, my lord,
Yes, apart from POCSO, any other sections are there?
my lord, of the IPC there is 376, 511, and my lord, POCSO. If, my lord, I beseech your lordships.
76 AB.
My lord, I beseech your lordship to kindly seize this injury reported to my lord.
No, let me consider this case diary first.
My lord, this is with the case diary. I'm, my lord, producing this from the 207 papers that have been supplied to me. My lord, I am in custody for about 190 days. My lord, no such incident has ever happened. In the injury also, my lord, injury report, it has been stated no act of sexual offense has been found on the body of the victim. My lord, the victim party has refused medical examination. And my lord, the victim girl, she has been said to be 10 years. When she entered the room of the petitioner, my lord, she found a lozenge on the bed, and when she tried to take it up, my lord, then this petitioner entered the room and my lord committed the penetrative sexual assault on her. My lord, in verbatim this has been stated, but in the my lord, that is not corroborated with the medical report so supplied to us. And my lord, my lord, charges had been framed. I am only aged about 18 plus years.
10 years, as per 164 statement, the allegation of penetrative sexual assault is there, but medical refused, my lord.
Yes.
Charges already
Medical refused.
refused.
And my lord, before medical
Page
refused.
22,
Page 22.
yes, medical refused.
And my lord, will kindly see the medical report, the first line of the doctor. No act of sexual offense has been found on the victim girl. And thereafter it has been refused.
ইনজুরি রিপোর্টে নিচে লেখা আছে যে
কোথায় ইনজুরি রিপোর্ট?
এইটাই মেডিকেল আর মাইল্ড 164 টাও আছে
দিয়ে কি করবো? তো মেয়ে তো শুনেছে। Charge has already been framed and date has been fixed 9th June for evidence.
But at this way,
Where is the FIR? For which page?
well, that is there with the my copy that I have handed over to your lordship as well.
Page 2 is the FIR.
Yes.
এবারে পেজ খালি লেখো না। এবারে পেজ খালি লেখো না।
নাম দিয়েছি দিলি না তো নাম দিয়েছে
আমি লিখি জি FIR এখানে দেখো পেজটা দিয়ে
দেখা যায় যে এফআইআর
সব লিখে কি ডিফেক্ট সেটাও লিখে। কোথায় লিখেছে? আর $164 মায়ের হচ্ছে
183
164 statement of the defect is also there, page 38.
Well, initially the case was started under section 376, 342 of the Indian Penal Code and 6 of the POCSO Act of the older code. And my lord, charge sheet has been submitted under section 376 AB, 342 and 6 of the POCSO Act. My lord, the de facto complainant was the mother. The statement of the mother is the FIR maker. My lord, the victim, the mother, though all stated that there was a penetrative sexual assault on the victim, my lord, there was nothing found on her body, my lord, on the body of her person in the medical report, and she ultimately refused the medical, though the FIR was made on the self-same day, on the alleged date of occurrence. And my lord, I am in custody for 190 days about, and I'm a my lord, teenaged boy of 18 plus years.
Yes, where is the 164 of the de facto complainant?
38.
How long you're in custody?
For about 9 months.
Charge has already been framed. From 9th June, trial will be started.
How many witnesses?
12 custody. One,
My lord, I'm in custody since 25th of November 2024. My lord, there is no FSL of the seized apparels as well. More importantly, my lord, there is nothing corroborative on our medical.
You were in custody for 6 months.
9 months since 25th November 2024.
6.5 months.
এখানে 182 6 months. না 7 মাস. My lord, for about 7 months. I stand corrected, my lord. 25/11 থেকে এটা তো জুন মাস পড়ে গেছে 7 মাসের উপর.
Age is 18 years of the accused.
Of the petitioner. My lord, will seize the charge sheet 18
And
plus.
the victim is 10 years.
10 years.
Yes.
tuition teacher of the
That means private tutor.
private.
Of the locality.
That means school student as well as a private tutor.
Yes, my lord. Of the locality, I used to render tuitions.
Yes. Learned advocate for the petitioner and learned advocate for the opposite party state are present. The learned advocate for the state files service report upon the de facto complainant. Stop. Learned advocates for the parties produce the materials in the case diary. Learned advocate for the petitioner submits that the allegations made against his client is not maintainable and the medical report does not suggest, and the medical examination was refused. Learned advocate further submits that the petitioner is 18 years old and is in custody for about 7 months, and as the investigation is complete, the prayer for bail made by the petitioner be considered. Stop. Learned advocate for the opposite party state objects the grant of bail and submits that the trial is going to start from 9th of June. Stop. Upon hearing the learned advocates and considering the materials in the case diary, the statement under section 164 CRPC and the statement under section 161 CRPC, there appears some contradictions. Stop. It further appears from the medical report that the de facto complainant refused medical examination of the victim girl, and so far the statement recorded by the medical officer does not suggest any sexual assault upon the victim. Although at this stage it would not be proper to make further observation with regard to the merits of the case. But considering the age of the petitioner, which is 18 years, his period of detention, which is 7 months, and the fact that charge sheet has been submitted and 12 witnesses are to be examined, which may take some time, this court is of the view that in the interest of justice, the petitioner should be released on bail. Thus, I allow the prayer for bail made by the petitioner. Hence, it is ordered that the petitioner shall be released on bail with 2 sureties of rupees 10,000, one of which must be local, subject to the satisfaction of the learned trial court. The petitioner, upon being released, shall meet officer in charge of the concerned police station once in a week and shall not enter into the locality where the victim girl and the de facto complainant resides, and shall not meet the persons acquainted with the facts of the case, and shall not leave the jurisdiction of the court without leave of the trial court, and shall attend court on all dates fixed. In the event there is any violation, the learned trial court will be empowered to cancel the bail without any further reference.
Complaints report.
No, service report, the service compliance report upon the de facto complainant be kept with the record.
I am grateful.
Eh.
আমাদের একটা কপি আছে। Well, I'm for the petition. Well, offense under section 365, 376D, IPC and 6 of POCSO Act. Well, the petitioner is in custody for 4 years, 10 months, 9 days. And my lord, the principal one of the accused, my lord, he has granted bail from the court below. I am standing on the same footing, my lord. My lord, it is appeared from the has been served. Well, regarding
Oh, this is a POCSO matter.
yes,
So service
well,
is
yes,
complete.
service has been served, my lord. Notice has been served, my lord, on the last occasion, 3rd June, my lord. The matter was hard, my lord. Just
No, madam, de facto complaint has appeared in this matter.
no, I do not know, my lord, but I have served, my lord.
So affidavit of service is there.
Well, my lord, I have made the service in terms of the complaints address, my lord, but the track record shows that insufficient service.
Okay, so serve
So,
again. Let the state serve
one-
the de facto
One thing,
complainant.
my lord, my lord. Well, I am in custody 4 years, 10 months, 9.
No,
Well,
anyway,
yes,
it will be taken after 2-3 days.
well, one thing, my lord, and my lord, the co-accused have been granted bail by the court below. That is apparent from the evidence, my lord.
These points will be kept open. These are not decided, but let the de facto complainant victim girl be served.
Well, how do I serve, my lord? Because, my lord,
The state will cause the service.
well, that's exactly that was fallen from my lord justice for Proceedings বিশ্বাস.
No, I'm
His lordship was directed the state to ensure. Yes. No, order. Orally said, my lord. Everything is not reflected in the order.
affidavit of service.
Well, kindly consider this position, my lord. Well, insufficient address. Then
Insufficient
again,
address. Yes, state will serve again. Yes, record. Learned advocate for the petitioner and learned advocate for the state are present. As service upon the victim girl de facto complainant, victim girl could not be affected.
Due to insufficient service that is
Uh,
appearing from the track
and
report,
the same
but
has
have made the service as per the
and the
address.
same has returned as insufficient address. The learned advocate for the state is requested to take necessary steps to cause service in the proper process upon the de facto complainant. Let this matter appear on 11/6/2025.
অরিজিৎ আমাকে এত ভয় পায় একটা মামলা করতে হবে।
Item 15, I am for the petitioner, Your Lordship. Last occasion, it was directed upon the state to serve upon the victim girl. I think they have appeared, my Lordship. Lordship,
You are for?
I am for the petitioners, Your Lordship.
Yes.
I am for the de facto complainant, my lord.
Yes, state is appearing.
Our exception, my lord, we need some time.
My Lord, kindly, my Lord, this is a short story. Let me submit, my Lord, which is my application.
My lord, we will file exception, my lord. We
Let
have
me
got also
let me file an application, my Lord.
When did you
My Lord,
serve?
this is a case, my Lord.
You
It's
see,
he can proceed, my lord, but
yes, you are ready with the case ready. Yes, submit.
My Lord, this is a case, is a dispute between two neighbors, Your Lordship. What happened, my Lord? Dispute took place on 15th of April at around 7:30. Case and counter case was lodged between both the parties, Your Lordship. The wife of petitioner number 2 lodged the initial case, that is Rajarat PS case number 171. Allegations are most of the similar, that is on 15th April at 7:30. On the very next day, the opposite party lodges another case on 16th, alleging same kind of allegations at the same time. Your Lordships can peruse the complaints which are annexed at page 16. Is the complaint lodged against us? Page 16, Your Lordships. That is complaint dated 16th of April 2025.
Yes.
And my lord, our complaint is at page 23. This is lodged by wife of petitioner number 2. This is complaint dated 15th of April. Lordship kindly draws your lordship's attention to the time of the incident. Both have mentioned the time of the incident. Page 23, your lordship. My lord, may I, your lordship?
So this complaint was lodged by the wife of the petitioner number 2.
Petitioner number
Against-
2, my lord. Against the complainants of this case who have complained against us, your lordship. I would draw your lordship attention to one thing, your lordship. Kindly comes to page 18, your lordship. Annexure P3, page 18.
Yes.
My lord, this is the formal part of the FIR, your lordship. In the middle portion, your lordship will see, my lord, the date of the occurrence is of 15/4. The time of the occurrence is from 1930 to 1945. It is there, your lordship. And in the initial FIR also, which is at page 11, that is the case lodged by them. This is the case lodged by
Your
us.
case was lodged on 15,
Our case was lodged on 15th of April, your lordship.
and the present case?
The present case was lodged on the subsequent day, that is 16th of April, once this case was lodged, your lordship. My entire family has been roped in. 6 women members, 4 male members, and present petitioners are the earning members. They are the 2 brothers.
How long you are in custody?
My lord, petition number 1 is in custody for more than 50 days. Petition number 2 is in custody for more than 42 days.
So POCSO is alleged against whom?
My lord,
they have alleged that they broke into the room and there was some assault, which is under section 8 of POCSO. There is no allegation of any penetration, your lordship. And this is what I will draw your lordship attention to the fact, your lordship. Your lordship is far more aware, as per TT Antony and Babu Bhai, as the offense's time is exactly same. It is not maintainable a second FIR on the same offense. Out of both the FIRs, one FIR has to be false, your lordship, because their time frame is same. One is saying on 7 o'clock to 7:30, another is saying from 7 o'clock to 7:45 on the same date of incident. They have lodged their case, formal part is at page 11. We have lodged our case is at page 18, and ours is the preceding complaint. So my humble submission is that this is just a counter blast to abuse the process of the harsher process of POCSO Act, your lordship. And they have suffered custody in this regard. And
They are still under treatment, my lord, and for the de facto complaint, if exception should be filed, my lord, at least one chance should.
No, question is, you see, you have received a copy of the petition, okay?
No, not received. Today just received the today morning.
No, this petition was served long time. When did
my
you
lord,
serve?
previously we served, their door was locked. Then it was directed upon the state day before yesterday. State has served.
Yes. Okay, let me see. And the medically examined.
Well, both the cases contain 325 of IPC, that is grievous hurt. Both parties have suffered injuries as per both the cases.
This is page 27.
Page 41.
My son, my wife, my entire family has been, extended family has been roped into the case.
All are in custody.
My lord, 2 are in custody, others are apprehending arrest, your lordship. My son is there, my wife is there.
Page?
40.
2 brothers are in custody, your lordship.
Forty-eight, 49. Yes, hey.
Kindly see the roll, your lordship.
এটা একটু খুলে দিন তো এটা এই এটা তো এই দুটোই তারপর আবার ঢুকিয়ে রাখতে হবে আর কি
Oh, recent.
Yes. So petitioner's number one's name is there in the 164. Petition number one's name.
My lord, kindly consider in that aspect, I would draw your lordship's attention to one thing, your lordship.
But input ওটা comment করতে আবার Yes, apart from the victim, any other examined under 164, any other witnesses?
My lord. My lord, if may I, Lord, draw your lordship's attention to just one thing, your lordship. The initial case that was lodged regarding this incident at the PS, that case was lodged under section 308 of the erstwhile code and 325. So, my lord, 308 stands for attempt to commit culpable homicide and grievous hurt. So, this FIR was pretty grievous, your lordship. Only to devoid arrest and only to face the consequences of this FIR, the subsequent FIR was lodged, involving POCSO into it.
Yes, you are not served with a copy of the petition.
Today morning, we have received the vocal.
No, maybe, but so yes, copy is not served upon the parties.
My lord, we have deposited our affidavit of service, which must be in the record. Subsequently, a direction was passed upon the state to serve it upon the.
Yes. You have notified the victim. No, earlier copy was not served.
My lord, the affidavit of service is there in the record, my lord. On the erstwhile date, day before yesterday, we have submitted the affidavit of service.
No, but they were intimated.
My lord, it was there in the track report, your lordship, my lord, door locked.
That means it will not be served.
It reached the victim, but their door was locked.
So unless he gets a copy, how
My lord, I have no difficulty. Lordship, let it be. In that case, your lordship may call for the case diary of the initial case that we have lodged. That case diary should also be there, your lordship. Case number 171.
Threatened continuously.
Well, this is just a counter blast to avoid that FIR, your lordship.
Yes. Learned advocate for the petitioner and learned advocate for the state and learned advocate for the de facto complainant is present. Learned advocate for the de facto complainant prays for time. As because no copy has been served, although the state has intimated the de facto complainant about this present case, learned advocate submits that the counter case which is lodged by the petitioners be also put up.
Lordship, grateful Lordship.
Thus, the learned advocate appearing for the state is requested to put up the counter case diary,
Case diary mein
case
photo.
diary on the next date to be fixed on 11/6/2025.
If your Lordship pleases, if your Lordship can make the matter part heard, your Lordship.
So that is not done in bail matters
Lordship, grateful.
unless hearing is concluded.
Lordship, no problem.
11/6/2025. Give the case number of the other case number.
It's your Lordship, Rajarhat Police Station case number 171 of 2020.
Give it in a slip of
I
paper.
shall, Lordship. Copy be served positively, my lord.
The compliance
We
report,
are serving it in the course of the day, your lord.
compliance report be kept with the record.
171 it. Grateful lordship. Please, my lords.
But prior to taking this matter, sorry, extremely sorry.
Item 16.
No, extremely sorry, my lord. Item number 94, revision application.
Yes.
Can it be possible to take up the matter?
You see, after the bail matters, okay,
It is
after
78.
after the bail matters are over, I shall take up those extremely urgent revision matters, okay, those which cannot wait till Monday.
So my matter is extremely urgent, but it is 90.
Yes, I'll take it up after this bail matters.
It is 90.
My lord,
I'll take up all the bail matters and anticipatory bail matters. Thereafter, only extremely urgent revisional matters will be taken up.
So can it be my matter is 94? Can
Whatever it is, all urgent matters will be taken up.
my lord, 70 to 72, my lord, can't wait till Monday, my lord. That is revision.
Please wait, let these bail matters be complete. I'll take it up.
My lord.
102, there is also a civil revision urgent. It was mentioned in the morning by.
Yes. Those which are mentioned in the morning is already marked. It will be taken up after completion.
My lord, I am 23-year-old young man, my lord.
Yes, which item?
My lord, 16.
Item number 69 for the state lordship, we have not received the case diary.
Okay.
Complete case diary, and it involves valuation of around 350 crores. So without the complete case diary, lordship could not proceed with this case.
Yes, as the case diary is not learned advocate for the parties are present, as the case diary could not be obtained, the matter stands adjourned till
My lord, the initiated
9/6/2025.
9/6.
Nine.
Lord, can it be another than 9th, my lord?
Okay, 10/6/2025.
10/6.
My lord, civil division and matter.
Please, after the bill matters.
Yes.
Huh? চেন অ্যাডভোকেট ও ফোন করে দেবেন ওই যে এ তো ফোন নাম্বার আছে সব কেস ডায়েরির মতো।
My lord, in 17, I beg to appear. My lord, in this matter, may I just tell you, lordship? My lord, if your lordship kindly sees this
Service upon the de facto complaint is
expert, my lord.
no. First of all, say whether the service is complete or not. Yes, state has served the de facto complainant.
The complaint who has complained this matter, the mother of the victim, he is the complainant. He has also made an accusation.
My lord, she was later on made an accused. Now, if your lordship directs another person, the father to be made as the I don't know, my lord. Otherwise, my lord, the person who made the complaint was the mother, but the first person arrested was the mother herself. Actually, my lord, it was related to the death of a girl child of 9.5 years who was roaming around in the platform. Mother used to reside in the platform itself. Mother was made the complaint upon identifying the dead body, but the police submitted charge sheet saying that mother took the money from two other accused persons for.
Let the service be effected upon the father of the victim.
If your lordship so directs, my lord, let it. Father has been named in the list of witnesses. I am not mentioning that. Let them.
Learned advocates for the petitioner and learned advocates for the parties are present. As the mother of the victim girl is made an accused in this case, let service of copy be effected upon the father of the victim girl.
My lord, there is one problem subject to. The father used to work in Andhra Pradesh initially, but there is his permanent residence is in Bardhaman. So let them try that.
Yes. Let the service be effected by the.
Here, lordship, the father's statement is here.
Here he is stating that he stays in Andhra Pradesh.
So you take steps to cause service if possible. Let the
Otherwise,
charges
my
be
lord,
effected by the learned advocate appearing for the state.
my lord, only one humble prayer. My lord, with your lordship's kind permission, my lord, just one line, my lord. Two other accused has been released on bail by this honorable court, saying that mother has been not been made an approver, but her 161 statement has been used. So on that score, there has been granted bail. The co-accused is also granted bail, and this petitioner is unfortunate. He is in custody for 1 year more. My lord, though being on the same footing. Now, my
No,
lord,
no,
yes,
the different footing. That
not
I
I can
that
show, but only I'm praying whether I can pray for interim bail in that event.
So do it after a few days, same thing, pray the same thing after a few days. Let this matter appear on 13/6, I think, 13/6. Correction. না ওগুলো সব পরে হবে, ওগুলো লিভ নেওয়া না, যেটা কারেকশন, এটা ওয়ান ম্যাটার কারেকশন। কি আছে ভুলটা? হ্যাঁ, হুম, ও অর্ডারে। Yes, the matter is put up for necessary correction by order dated 3/6/2025. Bail was granted to the petitioner Sujit Choudhury alias Vijay Top. However, in the cause title, it appears that Abdul Imran is the petitioner. Let necessary rectification be made. Top. Other contents of the order dated 3/6/2025 remain unaltered. এই লিস্টটাও রেখে দিন এটা।
18 কি হলো? আচ্ছা 18
মানে তোমাকে জাজমেন্ট বলে বাট আই মিন কাস্টাডি ফর 100 এন্ড এটা কি আমারটা? এটা আমাদেরটা তো
কি গো? এত জাজমেন্ট
লাগবে my lord I mean it's a murder case my lord I'm in custody for 108 days.
So 302 added.
No 300 my lord 200
already case started.
case started.
In the first title, it is not shown.
No my lord this is a BNS section.
Oh, right, 103.
Now my lord what happened my lord will kindly see judge my lord will kindly see in this case my lord will have to go to the case diary. Grounds of arrest were not informed to me at that time of arrest, my lord, on the basis of a statement of a co-accused. I was not identified basis of a statement of a co-accused. I have been arrested. Now, my lord, will kindly come to the first judgment, my lord, Pankaj Bansal. আমার গুলো তো যেটা আমি মার্ক করেছি কোথায় my lord paragraph 42 my lord will see 42 and 43 আমার জাজমেন্ট গুলো কোথায় যেতে মার্ক
Yes.
এই এবার তুই জাজমেন্ট গুলো দিন এই শাইলা ওই ফটোতে মার্ক করা আছে এবার দেখবো জানি আমার একটু মার্ক করেছি গো প্যারাগ্রাফ So, my lord, ground of arrest has to be informed according to this Pankaj Bansal judgment. দেখো না আমি দিচ্ছি তোমাকে।
Yes.
Now, my lord, then comes a judgment of Ram Kishore Arora. My lord, we'll see it is there, I guess. This says that Pankaj Bansal judgment will have a prospective effect. এত করে মার্ক করে আনলাম আমার জাজমেন্ট গুলো কোথায় চলে যায়। My lord, paragraph 23. That this judgment of Pankaj Bansal will have a Pankaj Bansal
Yes.
Then, my lord, we kindly see Probi Purokayesto, the next judgment. This upholds Pankaj Bansal and grants bail, saying that communication of grounds of arrest is must. Paragraph 17, my lord, will see. Paragraph 17, paragraph 20. Paragraph 30.
Yes.
Paragraph 30, my lord, will see. And then, my lord, will see in the arrest memo there is a place for reason to arrest. My lord, will kindly come to paragraph 48. Supreme Court has clearly drawn a difference, has noted down the difference between reason to arrest and grounds of arrest. বিহান কুমারও আছে, বিহান কুমার কোথায়? Now, my lord, paragraph 49, my lord, will also see. That is the finding of Supreme Court after discussion of all these judgments. My lord, then my lord will kindly come to Bihan Kumar. There is another judgment of Supreme Court. Paragraph 15 of the Bihan Kumar judgment. That's the 2025 SEC online, Supreme Court, page 269.
Yes.
My lord, paragraph 15 of the judgment. Paragraph 15 of the judgment. My lord, it has discussed Pankaj Bansal and all the other judgments, and then paragraph 15 has come. It has to be informed in writing to the person arrested, not to any relative. And if the initial arrest was bad, all subsequent remand is bad.
Yes.
That is the law. Right?
Secular law, all the officers know.
Now, my lord. Now, my lord, this Honorable High Court, a division bench of this Honorable High Court, after discussion of all the judgments, paragraph 9, my lord, will see. Paragraph 9, my lord.
Paragraph 9 and 10.
9 and 10, yes, my lord. All the discussing all the previous judgments of Supreme Court. Bail has been granted. Now, my lord, in this case, I have not been communicated grounds of arrest. Let them show whether I have been. Otherwise, I am entitled to bail, my lord. I don't have any antecedent. Sure. My lord. Precisely my submission.
Yes.
So now it is settled proposition of law, and almost all the police officers who are investigating all these cases, they know very well, and it has been done. It has been complied. That's it, kindly.
My lord, how? Let them show writing.
Yes, yes, in writing.
Very well, sir.
He has signed.
In this confessional statement, his signature. This is page 74.
He has, let's say, he has been,
Page 74.
let's say, page 74.
Yes.
The police officer has stated the ground of arrest to him, and
No, it is on the top, it is recorded confessional statement.
That is not a ground of arrest.
That may have been written, but let's say, kindly see the contents. আমি করছি
কথা বলতে গেলে টিপে কথা বলতে হবে। একদমই হ্যাঁ, ওটা করলে
70.
These are the allegations against you, and I am arresting you, and he has signed. The accused has signed. So that point goes. Now kindly come to the merit.
Yes.
This petitioner have been identified by 2 eyewitnesses in TI parade.
My lord, whether those
Pages, page 128 and 133.
My lord, no recovery from me. And my lord, the presence of those 2 people who allegedly identified me, it has also not been established. Grounds of arrest আমাকে দিয়েছে আদৌ কোন পাতাটা বার করো? My lord, ground of arrest has not been furnished to me.
This petitioner is a hired shooter, identified in TI parade by 2 eyewitnesses.
But how my name surfaced, my lord, that is important. No one knew me.
Identified in TI parade, these men. You know how identified in TI parade is done. So kindly see page 128 and 133.
না না আমাকে এটা দাও কনফেশনের এটা দাও
CCTV footage is there, PDR is there. Gate pattern is there. No doubt that this is the petitioner who was there and who sought. Why?
No, no, but 3 people were there. All 3 couldn't enter.
How can you overcome PI parade?
One gunshot injury.
CCTV footage, CDR, and recovery of the booty amount of 20,000.
Two people allegedly identified me, but those 2 people, whether they were at all present at the place of occurrence was doubtful. In the 164 statements also, there are 2 164 statements. My name do not transpire.
164 statement of those 2 who identified you in PI parade.
My name.
What are the 164 statements?
Let's say kindly says at page 186 and 188. We have seen the man who has fired, and thereafter these petitioners have been identified in court.
74.
PI parade.
$74 হ্যাঁ ওটা one gunshot injury, madam. And one person is on bail, madam. Lalchan Loshkar.
He has not been identified in TI parade.
Lalchan Loshkar was never placed on TI parade. He was a known person.
He was an informer.
Mala, in a case where there is criminal conspiracy, everyone is equally involved. But otherwise, why 120B, why 34?
Insider informant.
On the basis of a statement of a co-accused, I am arrested.
You cannot equate Lalchand with this petitioner. And cancellation has been filed, that is pending.
And I don't have a copy of the communication, my lord. I have not been given a copy of the communication. I can't even counter that, man. Whether it was a communication or at all a confession. Yeah, good. Allegedly, one Devashish Dr. alias Mithu identified us. He is the only person who knew us. Now, he was arrested and we were arrested on the same date. How come? They all were arrested on 18th of February.
So this person was identified by Ronit Mondol.
Yes, my lord, yes.
Rohit and
Rohit Mondol.
Rohit and Morselim.
Morselim's presence is definitely not confirmed. FIR speaks about the presence of Rohit.
How many accused persons are there?
Total 8.
Total 8, out of which all are in custody.
One on bail.
One is on bail.
One is on bail. He was the informant.
So this person was named in, not named in the FIR.
No.
But see, nobody has been named in it.
Nobody was named in the FIR.
Nobody knows me.
But in one
Nobody knows him. That is why you are placed in TI parade. And you have been identified in TI parade by 2 eyewitnesses.
How can you say they are eyewitnesses? Who vouches that I was present there?
For 164
Well,
statement.
they say that I was present. Now, who says that actually they were present?
That is why identification, sir.
No, was identification for only this accused person or for all others?
But if some other accused has been identified in TI parade also. Was it 3 persons total identified in TI parade?
How long you are in custody?
108 days, madam.
Only 108
Oh, it's
days.
a very initial stage.
The charge is submitted.
Whatever it is, if the trial does not progress, you come after some time.
Okay.
Yes, record an order. Learned advocate for the petitioner and learned advocate for the opposite party state are present. Heard learned advocates peruse the materials in the case diary. Upon hearing the learned advocates and considering the nature of offense and the materials in the case diary, this court is of the view that it is not the fit stage to enlarge the petitioner on bail. Thus, the prayer for bail filed by the petitioner stands dejected.
Okay.
Yes, essentially, sir.
May it please your lordship, my lord, 19. 19. My lord, I have a supplementary affidavit also একটা দিয়ে দাও
But I'm for the de facto complaint.
99.
Department নিচ্ছে
I am appearing for this.
এই নাও তোমায় কপি দিলাম
ডিপার্টমেন্ট নিচ্ছে না
কপি দিলাম
ওই ভেকেশন তো
my lord, I am in custody for exactly 7 months.
Yes.
I am in custody for 7 months. This is under 103(2) and 61(2), which corresponds to our 302 by 120B. My lord, comes to order at page 13 and page
Yes, this is with regard to co-accused person.
persons being granted bail. And that was on last day, the 30th of May during the vacation. My lord, I have filed a supplementary affidavit also. I'll come to that later. My lord, the statements which have been supplied to me, my lord, they show that these petitioners stand on the same footing. Apart from one statement, my lord, the principal, what happened? My lord, the factual background. My lord,
You are named in the FIR.
my lord, everybody named, all those persons who have been granted bail, 3 of them have been also named. If your lordships come to page 16, my lord, his lordship specifically recorded the reason for granting bail.
Page 16.
Para 4. Para 4, lordship.
বুঝতে পেরেছি হ্যাঁ হ্যাঁ
Now,
আমাদের প্রিন্সিপাল অ্যাকিউজ
Yes.
para 4 at page 17, this is the reason why the co-accused were granted bail, and the principal accused, his prayer was rejected.
So this petitioner.
No. They are fresh.
So this petitioner is coming for the first time.
First time.
Yes.
My lord, so far as my lord, the principal accused is concerned, it is Sheikh Shahada. Now the story, my lord, let my lord, your lordship has gone through this. 5th of November 2024. My lord, there was a dispute between the complainant's family and the family of the accused persons. Now this person, Sheikh Shahadat, whose prayer was rejected, another co-accused, he and his brothers, they attacked the father of the complainant when he was sitting in a tea stall. He was dragged to the go down of one person called Noku Maiti, where Shahadat assaulted him with sharp cutting weapon, sword, and he succumbed to his injuries. That is the reason why Shahadat's prayer was rejected. Now 15 persons were named in the FIR. Out of them, 3 have been granted bail: Sheikh Mustafa, Sheikh Najibul, Sheikh Nasir alias Bapi. So far as the petitioner number 1, my lord, is concerned here, now before your lordship, Shahabuddin, it is stated that in the, I have received the copies and therefore, my lord, I am trying to assist your lordship. Now it is said that Lalu had, my lord, there is only one statement of a person called Shona Khan, where he says that the petitioner number 1 had held the victim while Shahadat assaulted him. My lord, so far as the other petitioner is concerned, my lord, he stands on the same footing with all those who have been granted bail. Now, if your lordship sees the order of Nasir also, there the allegation against him was that he was guarding the door from the statement of Shona Khan. Now, my lord, today my contention is that these two petitioners who are before your lordship, they are on the same footing with those who have been granted bail. The assailant, as recorded and as appearing from the statement of the witnesses, is Sheikh Shahadat, whose prayer has been rejected. Now, this is the father of the deceased, he Sheikh Kamal. My lord, the informant Amir Hamza, Shubhendu Maiti alias Noku, in whose shop the incident occurred, all have universally said that they are members of who were present there but had no overt act. My lord, this is where I stand.
May I?
And my lord,
Sorry.
my lord, I have filed a supplementary evidence. I have handed over to your lordship. So far as the petitioner number 1 is concerned, my lord, if your lordship comes to page 7,
Page
7. My lord, these are his medical documents. He is suffering from malignant cancer, throat cancer malignancy, and he is undergoing treatment. This is, my lord, your lordship sees, my lord, history, my lord, page 7. My lord,
how long you're in custody?
my lord, 7 months. Investigation complete. Copies have been supplied. Now, on the last occasion, it was, my lord, my learned senior friend, Mr. Shur, had appeared in that matter also, my lord. Mr. Shur had shown the postmortem report to my lord Justice Shane also. 34 injuries, exactly. This was, my lord, submitted. And his Mududa says and this was exactly what was said. And our Justice Shane, after perusing the entire case diary and the postmortem report, had, my lord, come to these findings. My lord, also, so far as the petitioner number 2 is concerned, in the supplementary affidavit, my lord, two last pages, annexure P, page 22. He is a student of class 12. He is 18 years old. This is his mark sheet from his class 11 annual examination. Now, so far now, my lord, your lordship, from the case diary sees kindly. The eyewitnesses, they in fact say that they were chased out and they had not seen the incident. All the eyewitnesses have said that it is Shahadat, whose prayer for bail was rejected, my lord, was the person who had assaulted. My lord, less.
State who is appearing.
I am appearing. Proceed, kindly see, specific allegation against this petitioner number 1 is there.
Now, what is this document?
That is my learned friend is appearing for the defect of complaint. He is relying on the photograph.
36 witness injuries were there. 36 foot marks were there, my lord. And my lord, the person was brutally, my lord, chopped by the accused person.
Very much there. They all came in a body. Some assisted the principal accused, whose prayer has been turned out.
They are the money lenders, my lord, by occupation, unregistered and illegally, my lord, they lends money and they does all these things, my lord. And there is a 164 statement even.
They state what is there in the case.
There is a it's there in the 161 statements.
The name of the petitioner number 1, Sheikh Shahabuddin alias Lalu. Lordship, kindly mark. I have marked
Yes, my lord. And there is a specific 164 statement with respect to petition number 2 along with others that they restrained everyone, threatened everyone in the locality not to enter the house, enter the place wherein the victim was chopped. Common intention is very much there, my lord. This is a brutal murder, my lord.
There is no section of 34.
My lord, 12th is the date for framing of the charge. If my learned friend is saying 34 is not there, that will be added.
First, let it be added.
Then, my lord, let us come back after 12th.
In the meantime, grant bail.
No, why bail?
We can decide in the
But
revision.
12th is the date for framing of the charge. Few days, only 5-6 days left.
None of the persons who have been granted bail on 30th May are
No, they are not named in the 164.
Yes, yes,
everybody. Everybody.
No, those who have been granted
Yes,
bail.
yes.
No, who have been granted bail in this.
One of the persons who have been granted bail are my lord Najibul, Nasir alias Bapi, and Mustafa.
The 164 statement is of one Mur Halim Khan.
No, 164 is this. You see, Sheikh Arshad, Sheikh Lalu, Sheikh Maidullah.
Lalu is the petitioner before your lord.
Yes.
Saibuddin Elias Lalu.
Now, Bapi alias Nasir, Mustafa.
6th line from the top, my lord, Sheikh Shahabuddin, middle portion, and 7th line from the top, Sheikh Jubei.
And same person, my lord, his name's Nasir alias Bapi.
Why India code?
One 120B is there. My learned friend was saying 34 is not there. My lord, बोलता है
You see, those persons whose involvement is there, are they granted bail?
My lord, my lord,
so for these persons who are granted bail, their names are mentioned in 164.
Not in this 164.
In this 164, their names are not there.
Nasir's name, Sona Khan's statement.
164 of I.
Nasir.
Say.
No, where?
He has specifically said, I have seen essay Dekhi. Lots of kindnesses before my marking. Just before my marking. I am marking name. Just before that, Ami essay Dekhi.
Okay, the other 164 in which page?
My lord, next page.
164. Like 130.
AJ, my lord, may I read the 164 that your lordship was reading? My lord, he says, Sheikh Lalu ke dekhi, Sheikh Bapi alias Nasir, Sheikh Hasibul, Sheikh Mainur, etc. And Bapi alias Nasir has been granted bail.
No, this is in the second para. You first come to the first para, first stage.
Of your lordship is reading Sona Khan.
No, I am reading. Yes.
Sona Khan, my lord. Yes. Sheikh Shahadat. বাহাদুরকে এলো পাথারি কোপাচ্ছে আমি বারণ করলে আমাকে গালার ইত্যাদি করে আমি দুটো ছুটে পালাই আর তারপরে লাইন দেখি ওরা শেখ বাহাদুরকে নৃশংসভাবে হত্যা করে শেখ বাপি দাঁড়াও করছি তো শেখ বাপি আলাইস নাসির শেখ হাসিবুল শেখ মইনুর ইত্যাদি and Bapi alias Nasir has been granted.
That is the second phase. You see, first phase is this acts committed by the accused.
That is attributed to Shahadat. That is why his prayer was rejected.
That is why I am asking that Sheikh Shajjad and this Saifullah.
They are not on bail. They are not.
Yes.
Now,
petitioner's number 2 is not there.
not there, and
Petition
one.
number 2 is there in 130, page 130.
Arey bhai, then do it.
130.
They create cool. And here 3 people.
Yes.
Now, come to 130, my lord. Let us come.
130, okay.
My lord, this is Amir Hamza, তাই তো? Amir Hamza. My lord, see, he has named all the persons who have been granted bail. Nasir, Sheikh Mustafa, and Sheikh Najib. Good. All 3 granted bail.
ঠিক শাহাদা তো তার সব ভাইটা মিলে মিলে আমার বাবাকে কোপাচ্ছে। Specific allegation of the eyewitnesses are there.
And Shahadat to rejected.
That is why you
I
stand
am
on the same footing. All of
and 3 have been granted bail, and these 3 are named here.
all of you are
In the
there
160.
at the place of occurrence.
It is Shahadat.
Common intention was there. 120B is there.
And that is why the Honorable Court granted bail to 3 of them. You are not sitting in appeal over Justice Sen's judgment. Mr. De. Now, my lord comes to the statement of other eyewitness also. 160, 164, sir. Moor Halim Sheikh.
That is page?
My lord, this is the copy supplied to me. This is page 1. Amir Hamza. Atat Morin. Da 140 Nokumaiti. I will not appear anymore. More only. I'm telling you. Why are you bothering me like this? Now, Nokumaiti, your lordship sees.
141.
Right. My lord, Nokumaiti is the person. He's shocked the incident occurred. He specifically said Shahadat stabbing Bahadur with a weapon. No specific role against the petitioners. This is where, my lord, the role to Shahadat, Nokumaiti. And your lordship sees Nokumaiti. Now,
my petition number 2 is
আমি শেষ করিনি বল
Yes,
now one more statement may I show. 161. My lord, Moor Halim 163. Your lordship sees.
Moor Halim Khan.
No, this is the statement of the witness of the shopkeeper where the place of occurrence.
And he specifically says Shahadat assaulted. Now, the other eyewitness, they are showing only one, my lord. I am showing all. Now, kindly seize now. 163, Moor Halim. Now, Moor Halim again says, Shahadat took Bahadur inside the hall and Shahadat assaulted. He names Najibul, granted bail, Mustafa, granted bail. Kindly seize.
Specific roles have been ascribed over there.
You do it.
And I am doing it for the defective complaint. Specific allegations have been ascribed, my lord, in the 164 statement with respect to the.
I am doing the 164.
Please, sir.
117.
Now, 163.
So this is a local person.
Yes, he had gone out to purchase something and he is a chance witness. He saw the incident. Most uninterested witness, he names everybody. Everybody. In the same breath, saying Shahadat assaulted. Now, next, now.
Yes.
Now, one more 161 is 4 is left. One more. Kindly see. 118 now. তুমি তো বললে তাই জন্য তুমি একটা দেখিয়ে চেপে গেছিলে আমি বাকিগুলো দেখাচ্ছি এবার দেখো Now, আমি তো subject disinterested. Now, another, my lord, kindly sees.
Yes.
This is Sheikh Julekar 9, his name.
Yes.
He is the nephew. The nephew says, he names clearly Sheikh Nasir. Nasir is on bail.
I am on independent witness.
Independent দেখালাম।
117. The first one I relied. Specific role has been ascribed.
Page 117 is a local person.
That's it. Nothing
Okay.
to discredit him.
And page, this thing,
16,
no, 160, I think.
163.
163
Murhalim.
is the shopkeeper.
Nah, shopkeeper is 141. No.
Yes.
141, huh? Noku. Noku also says the same thing. Shahadat assaulted.
You assisted him. It's the number one.
And 163.
163 is that independent person who had gone out to buy something. Names everybody and those persons are on bail. Nasir, Mustafa, Najibul.
Not everybody, 3 are on
No,
bail,
no,
but
no,
that's something
three.
different.
Yes. Why different?
But
I stand on the same footing.
specific allegations has been ascribed
And
to the,
is Nasir also.
to the petition. These are not a case for bail with respect to lordship will with the date for framing of the charges. Let my learned friend come back after my lord the
Yes.
vulnerable witnesses are examined.
Hey. Learned advocate for the petitioner, learned advocate for the state, and learned advocate for the de facto complainant are present. Are learned advocates for the parties. Learned advocate for the petitioner submits that his client is falsely implicated in the instant case and is in custody for about 7 months. Learned advocate further submits that 3 co-accused persons are on bail and the prayer for bail made by the petitioner be considered. Learned advocate for the state and learned advocate for the de facto complainant objects the grant of bail and stop. Learned advocate for the state submits that these present petitioners have played role. The petitioner number 1 has played a role as will appear. Played a role in this offense as will appear in the statement of the witness of Shona Khan. Upon considering the materials in the case diary and the orders passed by this court with regard to the 3 co-accused persons and the involvement as is alleged in the 164 statement of Shubhendu Maiti, the shopkeeper where the place of occurrence took place, as well as the state where the place of occurrence and the other materials in the case diary, this court is of the view that considering the nature of involvement of these persons and the fact that 2 co-accused persons who are on the same footing, 3 co-accused persons who are on the same footing.
Who is in the same footing maybe, but these are
Anyway, I've recorded that
Order দিচ্ছি দাও।
the 3 co-accused persons are already on bail. And how many witnesses are to be examined in this case?
My lord, 18.
And the total number of witnesses which are to be examined in this case, this court is of the view that in the interest of justice, the petitioner should be granted bail. I therefore allow the prayer for bail made by the petitioners. Hence, the petitioners be released on bail with two sureties of rupees 10,000 each, one of which must be local, subject to the satisfaction of the learned trial court. The petitioners, upon being released, shall meet officer in charge of the concerned police station twice a week and shall not enter into the locality where the de facto complainant resides without leave of the trial court, and shall not meet the persons acquainted with the facts of the case, and shall not leave the jurisdiction of the court, and shall attend court on all dates fixed.
Obliged. Extremely obliged. My lord, one line, supplementary affidavit file taken on record.
Supplementary affidavit filed along with the medical documents of the petitioner number 1 be kept with the record.
Copy has been given.
হ্যাঁ দিয়েছি দিয়ে কি
এখন দিয়ে দেখার কোনো সময় পাই।
হ্যালো
20 I am for the petition.
State কি আছে এগুলো দিয়ে দেবেন, ওই যে যেটা তো ইয়ে হলো না, রিজেক্ট হয়ে গেল, সেটাতে দিয়ে দেবেন একটু। এটাও দিয়ে দেবেন, ওই যে অ্যাডভোকেট চলে গেল, ওই যে yes item 20
I am for the state.
okay item 20 I am order record an order. Yes item 20 orderটা রেকর্ড করে নিন। item 20 as the case diary has not been received by the learned advocate for the opposite party, the same stands adjourned till 10/6/2025.
After 11 1.
Huh?
After 11/6.
Okay, adjourned till 12/6/2025.
My lord, I am for the
21
petition.
I am paying not to bear.
My lord, two persons were granted bail by this honorable court on 30th of May, my lord. And my lord, the CD is here, my lord, on 30th.
So if the CD is here, you will.
My lord, 30th of May, two persons were granted bail by this honorable court, my lord, last
No,
Friday.
in this case.
Yes, my lord, in this case.
In this case, no, this for this petitioner.
Yes, my lord.
Because CD, once the case is disposed, CDs are returned. Then again they have to call the CD. So that has not come. Anyway, not today. Let it be on Monday. Okay, record kore niun in same order. As the case diary is not received, the matter stands adjourned till 9/6/2025.
Worship, in this matter, I am praying for not today.
Okay, item 22, not today.
My lord, I am appearing for the petition, my lord. State. My lord, I am moving this application for the first time before this honorable court. I am in custody for 2 years, 4 months. My lord, I am arguing this matter, my lord, primarily on 3 issues.
So earlier, when it was rejected, you
Not
are
rejected by this honorable court. For the first time, I am moving before this honorable court. I am in custody for 2 years, 4 months.
So 307 is there.
307 is
302 is not there.
no. And that section will also not attract to me, my lord. I will show it to your lordship. My lord, primarily on Article 21, my lord, there are total 23 witnesses in the charge sheet. Charge has been framed, my lord. I have been supplied with the copies, my lord. I have annexed. There are 5 witnesses have been examined till date. 18 is still left. My lord, pleasure would be if your lordship kindly comes to page 26 once. Let me start with page 26. My lord, allegation is that I was intercepted in a guest house at the reception. There was another accused at a first floor of the room. Allegation that when I was taken, I shouted and raised an alarm to that other accused, and that accused shot fired to another policeman. That is the sum and substance of the allegation. If your lordship kindly sees page 26, this is on 161 of a police officer. Page 26, your lordship.
Yes.
At the bottom, your lordship would find এরপর আমরা তাদের চিনতে পেরে জানাই যে তারা আজ সকাল 13/1/2023 এই হোটেলে এসে হোটেলে 204 এবং 209 নম্বর কক্ষে উঠেছে। তারপরে রিসেপশন কাউন্টারে আমরা আসামি পারভেজ আক্তার ও আক্তার আলীকে দেখতে পাই। আক্তার আলী ইজ দি পিটিশনার লর্ডশিপ। আমাদের দেখে তারা পালানোর চেষ্টা করলে আমরা তাদের আটক করতে সক্ষম হই। এরপরে আমরা আটক আসামিদের নিয়ে হোটেলের প্রথম তলা 209 নম্বর কক্ষে যাই। তখন ধৃত দুই অভিযুক্ত চিৎকার করতে থাকে, সোনু পুলিশ পুলিশ, গুলি কর, মার। এই সময় কক্ষের ভিতরে থাকা ব্যক্তি একটি পিস্তল টাইপ ফায়ার আর্মস বের করে আমাদের লক্ষ্য করে এক রাউন্ড গুলি চালায়। এই সময় আমাদের থানার সিভিক সোয়ানসো রিজাউল গুলিবিদ্ধ হয়ে রক্তাক্ত অবস্থায় পড়ে যায় এবং আমাদের রহরা থানার বাকি পুলিশরা আহত ব্যক্তিকে নিয়ে হাসপাতালে যায়। This is the involvement. Now, without wasting your lordship's time, because the other statements are just replica, if your lordship kindly for once kindly comes to the 161 of the victim, that is very important, your lordship. That is at page 46.
Yes.
Kindly, my lord, page 46. My lord, kindly to read me out. My lord, 9th line from the top. তারপর আমরা সহযোগিতায় আমরা ডলফিন গেস্ট হাউসে যাই। তারপর আমরা ওই হোটেলের রিসেপশন থেকে দুজন আসামিকে আটক করি এবং ওই হোটেলের এবং তখন অন্যান্য অফিসাররা ওদের জিজ্ঞাসাবাদ করছিল। তখন আমি এসআই তারক কটাক এবং সোয়ানসো মিলে হোটেলে 209 নম্বর রুমে যাই। আমাদের পেছন পেছন সমস্ত অফিসার ও অফিস ফোর্স আসছিল। তারপর আমরা দরজা নক করি এবং বলি আমরা পুলিশ, দরজা খোল। তারপর দরজা খুলতে তারক বাবু সোনুকে ধরে ফেলে বাম দিক থেকে। আমি তখন স্যারের দিক দিয়ে রুমের ভেতরে ঢুকে পড়ি, রুমের ভেতরে আর কেউ আছে কিনা দেখার জন্য। তখন আমি রুমটা চারদিকে ঘুরে যখন দেখি সোনু ডান হাত দিয়ে কোমরের বেল্টের নিচ থেকে কি বার করছে, সঙ্গে সঙ্গে স্যার ওর ডান হাতটা ধরার জন্য চেষ্টা করছিল। তখন আমি ওর হাতটা জাস্ট ধরতে গেলে ততক্ষণে ও ফায়ার করে দেয় এবং পুলিশটি এবং গুলিটা আমার বাম পায়ে লাগে এবং আমি পড়ে বসে পড়ি। So, my lord, in this is the 161 of the victim. There is no indication or no whisper that at all I raised an
complainant has been examined in this case.
Yes,
And the victim is also examined.
my lord, in trial, no,
Yes.
Not yet.
No, de facto
Not yet.
complainant examined.
not yet.
Not yet.
No, how many witnesses are examined?
Well, 5 witnesses examined.
No,
De facto
four.
complainant?
4 completed.
My lord, he is the,
No, including the de facto complainant.
including the de facto complainant. There are 5 witnesses have been
But
examined.
this injured person is not examined.
Not examined.
Total number of witness?
23.
Yes, where is the CD?
My lord,
You
my lord,
report.
one more thing I must indicate, there is also no recovery from me. If your lordship kindly sees the scissor list, which I have annexed at page 25. Page 25.
How many accused persons are there in this
The
case?
total 3.
3.
The victim does not implicate me at all. I was not there when the fire was shot. And my lord, kindly sees page 25 of the scissor list.
So from where you were arrested?
My lord, from that guest house.
From the place of occurrence?
Yes. But I was at the
Kindly see
reception.
page number 9, your lordship.
My lord,
Offending
my lord,
vapor
kindly,
is
kindly,
from
kindly let me
accused.
finish.
Yes,
My lord, kindly let me
Page 9.
finish. My lord, kindly sees page 25 once, the scissor list.
Same it will be reflected in the case diary also.
Yes, because I have received the 207 copies. Well, it would be same. Well, kindly sees point number 5, article seized. Kindly sees from whom the arms has been seized.
Yes,
There is
this
no
is-
recovery from me.
Okay, this is discharge summary of the victim.
No, no, page number 9.
Page 76.
Page 9, lordship.
No, page 76 is the medical report.
Lordship. Medical report, your lordship. Gunshot injuries are there on the leg.
And page 9.
Page 9. Offending weapons seized from all the accused. 3 of them.
Well, probably that is why I'm indicating your lordship the page 25.
Page 9. Yes, page 9 from the position of
এক মিনিট দাঁড়া।
Sonu. But kindly says it's only Mohammed Sonu. My name does not
no,
transfer.
no, page 9 of the case diary.
Oh, I'm sorry.
Page 9 of the case diary. Same thing it will appear.
Yes, Mala, because that's a
No, no,
207
Mohammed
copies.
Sonu, then Parvez Akhtar.
Parvez Akhtar, only mobile phone.
And Akhtar Ali?
Akhtar Ali is the petitioner, my lord.
Akhtar Ali is a petitioner.
Is the petitioner.
So from Akhtar Ali, what was seized? What was the seized from?
Lordship, kindly. Just receive the case diary, that's why. Lordship, kindly. एक मिनट
Any weapons seized or not?
My lord, in the meantime, kindly see space 25. My lord, it would be same document.
Same. No, I am asking what was seized from this petitioner.
Well, to my knowledge, as per the seizure list is concerned, well, only a mobile
Same
phone.
seizure list.
Only a mobile phone has been seized from me. No arms, nothing. And the victim also does not implicate me.
From the possession of Sonu,
Yes.
one magazine has been seized.
You are in custody for?
Well, 2 years, 4 months.
ওটা আমি লিখে ওপরে কার কাছে নিয়েছো নিজের ডিটেইলস
ये तो दिन केस डायरी टेक को Learned advocate.
and
of the
please see page number 61 the injured statement
page 61.
Lordship.
So does the injured person say that this person fired, this petitioner fired from?
He has not taken the name, but he has taken the name of the two Asami.
The name is specified.
He has taken the name of the Sonu that he shoot, and the petitioner is present over there.
No. Did he state that fire can be made by only one person from this?
Person from Sonu, yes.
That is from Sonu.
Yes,
Sonu.
not my name.
Learned advocate for the petitioner and learned advocate for the opposite parties state are present. Hard learned advocates for the parties peruse the materials in the case diary. Learned advocate for the petitioner submits that his client is in custody for 2 years. 2 years, how many? 2 years?
23 witnesses.
2 years, 4 months. 4 months.
সেটা তো সে নিজে এখানে
সে তো আইনত তারপরে কোর্ট বলবে তারপরে হবে তার আগে কি করে হবে পুলিশ কি করে জানবে পুলিশের কাছে কি সেই এফআইআর যেটা কি আছে যে না আগে থেকে নিয়ে হয়েছে তাই না
made by the injured person where the name of the petitioner firing from the weapon is not mentioned. Learned advocate further submits that no arms was recovered from the petitioner, although there was recovery of arms from another co-accused person. Learned advocate submits that this case involves examination of, this is the 22 witnesses.
23
witnesses. 4 examined.
And out of which 4 have already been examined.
Completed in full.
Learned advocate for the opposite party objects the grant of bail and draws to the seizure list in the case diary. Upon hearing the learned advocates and considering the materials in the case seizure list and the
আমি তো
statement
ভালোই খুশি দিদি আর আমি একই কমপ্লেন দিয়েছি এটা ভালো না
and considering the period of detention which is 2 years, 4 months, and the fact that 18 more witnesses are yet to be examined, which will take a considerable period.
আরো যারা ফায়ার করছে
Which will take
তারা
a
তো এটাই
considerable
বলছে
period.
যে মা কামাখ্যার
Because of
নামে
the
আর
view
শ্রীকৃষ্ণের নামে
that
এরকম
further
বলে
detention of the petitioner is
ভাষার
not
ইংরেজি
necessary for
ল্যাঙ্গুয়েজটা
the
হয়তো
purpose
একটু
of
আলাদা
trial. Thus, the petitioner should be enlarged on bail. Hence, the petitioner be released on bail with 2 sureties of rupees 10,000 each, one of which must be local, subject to the satisfaction of the learned trial court. The petitioner, upon being released, shall meet the officer in charge of the concerned police station twice a week and shall not leave the jurisdiction of the court and shall attend court on all dates fixed.
Lordship.
I'm deeply up.
Go to item
15 or 24.
24.
Sir, I beg to appear on behalf of the petitioner. My lord, the service has not been completed, my lord. Kindly direct the state to ensure the service.
Yes, record an order. Learned advocate for the petitioner is present. As service upon the de facto complainant could not be effected, the matter stands adjourned till 11/6/2025. Learned advocate for the state is requested to take necessary steps for causing service upon the de facto complainant.
Wait, please, Lordship.
I'm for the victim.
All parties are here.
You're for?
I'm for the petitioner.
Yes, you are for the state.
My lord, the petitioner, my lord, in the present case, my lord, is in custody for 42 days. My lord, I would say that this is far too long a time period for him to remain in custody, my lord, because of the facts in the present case. My lord, may kindly takes up, first and foremost, page number 13. Page number 13. My lord, the petitioner before your lordship is a 25-year-old student. My lord, he has a very bright future ahead of him. If your lordship may kindly takes up page number 13 first.
No, he may be a very good student.
My lord, I'm
but-
telling you, I'm coming to that. I'm coming.
But
I'm
how
coming.
far his involvement is there?
Lordship, I'm coming to that. My lord, this boy, my lord, has now qualified the CA foundation exams. Now, my lord, he is in the cusp of CA admission. Now, my lord, in this backdrop, this particular case has been foisted upon him. My lord, under section 6 and section 10 of the Protection of Children from Sexual Offences Act. Now, my lord, your first and foremost, my lord, your lordship may kindly takes up the FIR and the 164 statement of the victim girl, my lord, wherefrom it will appear that neither 6 nor 10 of the Protection of Children from Sexual Offences Act is attracted. My lord, the only section which is attracted in the present case is of section 8, where the definition is at section 7. My lord, I'm giving the act, my lord, first. My lord, may first and foremost seize the FIR first. The FIR is at page number 24, my lord, of my
this is the mother of the victim.
Mother of the victim girl has lost this particular case, my lord. Now the mother is the cook working in the house of the petitioner. Now they had their own previous disputes with regard to the salary amount, my lord. I don't want to make any further comments on that. My lord, page number 23, my lord, 24 is the written complaint. If your lordship may kindly seize it. I don't want to place it, my lord.
Yes, it is there.
My lord, lordship has seen the term which is used. My lord, it does not reflect aggravated penetrative sexual assault, which is section 6 of the act. Now your lordship sees the FIR allegations and sees once, my lord, for my satisfaction, section 7 of the POCSO Act, my lord. Section 7. But subject to correction, the investigating agency ought to have incorporated section 7 only in this particular case. Your lord. The punishment for section 7 is in section 8, which is for 3 years to 5 years. Now your lordship may kindly seize, my lord. In this case, charge sheet has now been submitted. My lord, I'm handing over a copy of the charge sheet because during the pendency of the bail application, I've obtained the certified copy. My lord, copy of the charge sheet. My lord, from the charge sheet, it is very well clear that the victim, minor girl, my lord, has refused medical examination in this present case. My lord, this part would be substantiated by my learned senior appearing for the state, my lord. The victim girl has denied medical examination. Thirdly, my lord, in this case, my lord, the 164 of the victim girl, my lord, reflects that, my lord, lordship, your lordship will seize, my lord. It is the same term which is used in the FIR. I don't want to use that term. The same term used in the FIR, which reflects section 8 only. My lord, this boy is in custody for 42 days now. My lord, on any terms and condition, my lord, I am beseeching that this boy may be released on bail as he has his exams and other aspects. This is a case which has been initiated due to other misunderstandings, my lord, which I don't want to, my lord, bring it before your lordship's court. Lordship, may kindly, my lord.
Yes, my lord, give the case.
The girl is only 2 years 10 months, my lord, and mother is the cook of the this present petitioner, my lord. Kindly say at first, my lord, the 164 statement of the my lord that victim, the girl, my lord, who is 2 years 10 months, 2 years 10 months, not 10 months mentioned for also. Then, my lord, the mother of the VG, my lord, that is page 54. Only one line, my lord.
That also, my lord, shows that it is of section 8 only. That is 3 years to 5.
Page 50.
Page 5, my lord, 164% of the my lord.
No, 164 is in 51.
Yes, yes.
And another is, my lord, 54 is the mother of the VG.
And my lord, let them show the medical document. She has refused a medical examination.
Yes, 164 of the mother,
Mother page 54.
54.
Medical document দেখাচ্ছে না actually.
Mala 161 of 161 as well as 164 of the mother of the VG are totally corroborating, my lord. Kindly see.
আবার বলবো আবার দুটো করতে
As well as FIR also, my lord.
witness. সেটা তো বলেছি তো দুবার তিনবার করে চারবার বলেছি তো আমি এটাকে কত বলবো এটা কি বলা যায় অন্যকে তুই তো বড় খিলাড়ি সেটা বলছি তো লিগাল স্ট্র্যাটেজি প্রত্যেক করবি না পালন করে দিই বড় খিলাড়ি কি অবস্থা খেলে let them show the medical document also.
You see, the
Medical-
so far this nature of offense is medical examination is very much necessary.
My lord, no.
No.
Now your lordship is now my lord, I'm grateful it is fallen from your lordships, my lord.
It is
They
denied.
have incorporated section 6 and 10. Had it been section 8, it was not necessary. Charge sheet has also been submitted on 6 and 10.
Same, my lord. Charge noted.
So it is at a much lesser section. Section 8 is for 3 years, my lord.
The charge same.
3 years is section 8. If they admit that it's a case of section 8, I am
Yes,
Only charge is submitted, not it, charge not it been framed.
so medical examination is refused.
yes.
So 164 of the mother and the victim.
And that too, my lord, the ingredients of section 8 is only there.
Any other relevant?
No others.
My lord, kindly see page 13, local people.
Wow.
Page 13.
13.
No, local
Not the
person.
percentage.
একটা কোরবানি ওখানে লোকাল পার্সন আছে তুমি ইন্টারেস্ট ছিল আছে স্পটিং ছিল আমার বাড়ি কাছে লোকাল পার্সন আছে they are the local people of their victim, not the accused person, my lord. So they don't know about the incident at all.
The victim is aged 3 years.
Below 3 years, 2 years, 10 months.
Other 164 statement আমরা file out actually.
Yes, what do you say?
My lord, I'm for the victim, my lord. My lord, victim lady is personally present before this honorable court.
Mother.
Victim mother, mother of the victim, my lord. And he instructed me, my lord, if the honorable court is pleased to granting bail this petitioner, she has no objection. My lord, I fairly submission before this honorable court, my lord. My lord, this victim lady.
No, you see, this is not a compoundable offense.
No,
So,
no, my lord.
actually-
But what he instructed me, I make a submissions before this honorable court, my lord.
Yes, anything else to add?
My lord,
Only
there is also, no, my lord, there is also a history regarding the salary also.
Then, like I said, my lord, this is a case in which this boy has been, my lord, wrongly interpreted. Yes, sir.
learned advocate for the petitioner, a learned advocate for the opposite party, and learned advocate for the de facto complainant are present. Third, learned advocates produce the materials in the case diary. Learned advocate for the petitioner submits that his client is a brilliant student and has a bright prospect, but he is falsely implicated in the instant case. Learned advocate draws attention to the mark sheets of different examinations of the petitioner. It is further submitted by the learned advocate that the allegations made against the petitioner does not contain the ingredients of section 6 of the POCSO Act, and it can at best be an allegation under section 7 of the said Act. Section 7/8 of the said Act. 8 of the said Act. Learned advocate submits that the petitioner is in custody for a long period and his prayer for bail be considered, as medical examination of the victim girl was refused. Learned advocate for the opposite party objects the grant of bail and refers to the statement of the victim girl and the de facto complainant under section 164 CRPC. However, it is submitted that the medical examination of the victim girl was refused. Learned advocate appearing for the de facto complainant submits that he has no objection if the petitioner is granted bail. Upon considering the facts of the case from the materials in the case diary and considering the nature of allegations against the petitioner, although the allegations are serious, but considering that the petitioner is a student and his period of detention, this court is of the view that in the interest of justice, the petitioner should be released on bail. Thus, I allow the prayer for bail made by the petitioner. The petitioner shall be released with 2 sureties of ₹10,000 each, one of which must be local, subject to the satisfaction of the learned trial judge. The petitioner, upon being released, shall meet the officer in charge of the concerned police station once in a week and shall not meet the victim girl and the de facto complainant and those who are acquainted with the facts of the case, and shall attend court on all dates fixed.
একটা দেবেন দিয়ে দিয়েছে না দেখি একটা দাও না ওই এর হাতে আছে আচ্ছা আচ্ছা আরে দাদা একটা দাও
May I take your lordship's kind indulgence? Lordship, item 102 civil action was mentioned in the morning.
Yes. After this bill matters, please.
Lordship, it has not been marked. I was told by your officers that the matter has not been marked.
Okay,
if it can be marked.
Mention when it will be taken up. Okay.
Okay.
Well, I'm for the petition. Offense under section 21C, 25 and 28-29 of Narcotics by NDPS.
Item 25. 25. Oh, 25.
Well, here the petitioner is in custody for 1 year, 3 months, and on the who have been granted bail, considering the detention.
No, question is, you are for the state.
I am for the state, my lord.
No, there was recovery from you.
My lord, there are.
And you see, my lord, page 23, my lord,
Completely on a different distinct grounds. Sorry, sir. Sir. Please, sir, sorry.
Page 23. Now kindly come to page 23, my lord, the order, my lord, first by the Supreme Court, my lord, that kindly see the next page, my lord. The considering the fact and circumstances of the case,
Page 23.
Yes.
So considering the fact and circumstances of the case, the period of incarceration already undergone by the petitioner, which is more than 1 year, we are inclined to grant bail to the petitioner. Accordingly, we are directing the petitioner to be released on bail. Next, regarding the allegation which my followed from my counterpart, kindly come to page 22, the charge sheet. He is the kingpin who has got bail from the Supreme Court.
Page 22.
Page 22. Malad, kindly, I am reading, Malad. In course of investigation from statement of arrested accused Upendra Kumar Mahato and other witnesses, it could be learned that defendant accused one Santanu rented the house at Mogra from the owner of owner.
No, which page? Page 21.
22. 22.
Yes.
In course of investigation from the statement of arrested accused Upendra Kumar Mahato and other witnesses, it could be learned that defendant accused one Santanu. Santanu is Dheeraj Malad, same person, rented the house at Mogra from the owner to function his illegal activity. Investigation received the said defendant accused Santanu is actually Dheeraj Haldar, who is involved in the commission of the crime but was absconding. Next, from his go down, next page, next paragraph. On 9th May 2024, the accused Dheeraj Haldar, Santanu, was produced before the learned court and shown arrested in this case and remanded to jail custody till 22nd May 2024. I paid for TIP test identification parade of the accused and was done on 14th May 2024 at Dom Central Correctional Home in presence of learned JM Second Court, Balasar, by witness. In the TI parade, the two witnesses duly identified him. I took him to police custody. This person have granted bail for by the, on the ground of touchstone of Article 21, the detention. So I am in custody 1 year 3 months.
So nothing was recovered from that person.
Well, he is the person who is involved dealing with the business, and in the TI parade he was identified.
TI parade identified regarding what?
Regarding from the
to run the business.
Godown belongs to whom?
Santanu or Dheeraj Haldar? Santanu and Dheeraj Haldar same person?
Yes, give the case.
I'll take cue from the submissions of my learned senior friend, Malad. He says that he is the person who used to run the business.
Is ready to that? Oh, this is the memo of evidence.
Malad. Kindly, Milord, kindly have a look, Milord, at the first page of the memo of evidence, Milord, and the second last paragraph, which says that Milord.
Second page?
First page of the memo of evidence.
Yes.
The second last paragraph from the bottom. In respect of the present petitioner, Milord, Upendra Kumar, Milord. Accordingly, on 22nd 2024 night, I such and such took charge of investigation of this case. I interrogated the PC accused Upendra Kumar Mahato and other available witness. I visited the PO as shown by the PC accused. And leading statement, I left for Mogra PS under Hooghly district. There at Natungram village under Mogra PS, I held raid in a house which belongs to Pradeep Sarkar and I recovered huge amount of fentanyl. Well, there are two recoveries. One in the vehicle and he is the owner of the vehicle. He is the
owner is this petitioner.
Owner and driver.
No, this petitioner.
Petitioner, Milord. He is the owner. Page 360, Milord. Page 360, Milord. Kindly have a look at the case diary. Case diary, though. Milord, kindly have a look at the. Please let us, my lord, get to the. Page 360, I'll. Page 360 is in that volume. Lord, there is a huge that I will distinguish him, Milord, with Shantan. And I'll satisfy your lordship, Milord, that he is not entitled.
Shantan is better footing.
Page 60.
360, Milord. 360.
ওর মধ্যে আছে নাকি? হ্যাঁ, এখানে আছে।
trouble, your lordship, my lord. Kindly look at the name, my lord, of the owner of the vehicle, my lord, which was carrying the drugs, fentanyl, contraband articles. Is Upendra Kumar, my lord, on the top hand, my lord, it is there. And my lord, he was also the driver. And then, my lord, he led with his leading statement. The house was raided, the godown, wherein other materials were also recovered, my lord.
No, that godown belongs to whom?
That was Shantanu.
Who granted bail by the Supreme Court, my lord?
Please, sir, please. Shantanu, my lord, there is a distinction, my lord. There was no recovery from Shantanu 1.
No, but from his godown, there was recovery.
Yes, my lord.
My lord, but he was not there at the time. So it is
His godown was under lock and key.
godown was under lock and
That means
and my lord, this Upender, this present petitioner showed the godown. Secondly, my lord, there is a major distinction, my lord. But the other major distinction is that this present petitioner hails from Bihar.
So what?
Don't poke like this. So what?
no, this petitioner, yes.
This petitioner hails from Bihar, my lord. If he is granted bail, and this is a racket, one of the co-accused, my lord, has been booked under UAPA. There are other co-accused in this, my lord. Some 2 co-accused were arrested, my lord, after the submission of charge sheet. They were absconding. And my lord, if he is granted bail, my lord, he will never turn up for trial. And my lord, even in the Supreme Court order,
any stringent condition.
Your lordship may kindly have a look at the Supreme Court order, my lord. The Honorable Apex Court says, my lord, considering the facts and circumstances of the case of Shantanu, not of Upendra.
Period of incarceration. The period of
Period of detention, my lord.
Case of Shantanu, not of Upendra. Upendra's case was that there were recovery. Upendra was driving a car which he owned, and in that car he was.
Simpliciter if that Shantanu was named by this accused person and no recovery from his godown, then definitely he is on a different footing. But the question is, there is recovery from his godown.
Shantanu is from Bengal, my lord. He is from Bihar.
That's a different issue, whether he has a chance to abscond or not.
He will abscond, my lord, because he's a part of a big racket. It is not a simple case, my lord. A same person who has been arrested.
Mala, I shall not leave the jurisdiction, my lord. Local court. Local court, my lord. Any stringent condition.
Because
because of the detention, my lord.
From his possession, 5,000 fentanyl bottles were recovered, my lord. Not a small quantity. Kindly appreciate, my lord. Shantanu, my lord, was not on the spot, my lord. If he is granted bail, my lord, then it will leave a very bad message, my lord, because they work in a racket, and the other petitioners will, my lord, just follow the suit, and a floodgate will open, my lord.
No, each case has to be decided on its own merits.
Yes, my lord.
This merit, my lord, on its own merit.
Otherwise, had this order not been there, he has no case.
But this order was for Shantanu because there was no recovery, my lord. That was there in the.
That observation.
The observation is that in the facts of the case was that there was no recovery from Shantanu. Lord, we all know, my lord, that the higher wisdom comes from the Supreme Court, my lord, which speaks less, my lord. So it is written.
Learned advocate for the petitioner and learned advocate for the opposite party state are present. Our learned advocates peruse the materials in the case study. Yes, how long you are in custody?
1 year, 3 months.
More than 1 year.
Yes.
More than 1 year.
Learned advocate for the petitioner submits that he is in custody for 1 year, 3 months and is falsely implicated in the case. Learned advocate further refers to the order passed by the Honorable Supreme Court, where the co-accused Hiraj Haldar alias Shantu has been granted bail. Learned advocate for the petitioner submits that as per the observation in the charge sheet, there are serious allegations against the co-accused Hiraj Haldar alias Shantu, and the petitioner stands on a better footing than co-accused Shantu. Learned advocate for the opposite party objects the grant of bail and submits that the petitioner does not stand in the same footing with that of the co-accused Shantu, who obtained bail from the Honorable Supreme Court. Learned advocate further submits that there was a recovery from the vehicle in which the petitioner was driving. Stop. It further appears from the record that a raid was held at the godown of the co-accused and different articles alleged to be narcotics were recovered from the godown of the co-accused person. It appears thus it cannot be said that there was no recovery from the co-accused person. Upon perusal of the order of the Honorable Apex Court, it appears that the co-accused was granted bail considering his period of detention, which was for more than 1 year. Stop. In the instant case also, the petitioner is in custody for 1 year, 3 months, and the case, yes, charge sheet is submitted.
Submitted. The next date is for PW1.
Okay.
For examination.
Although the date is fixed 3 months, and
July.
this case involves examination of how many witnesses? 12. 13 witnesses. Stop. Which may take some time. In the interest of justice, this court is 31 witnesses, which will take a considerable period. Thus, in the interest of justice, the petitioner should be released on bail. Hence, the petitioner be released on bail with 2 sureties of rupees 10,000 each, one of which must be local, subject to the satisfaction of the learned trial court. The petitioner, upon being released, shall meet the officer in charge of the concerned police station twice a week and shall not leave the jurisdiction of the court and shall attend court on all dates fixed. The petitioner shall further intimate his mobile number to the officer in charge of the concerned police station.
My lord, may I claim for another indulgence?
Yes.
Also his address where he will be staying.
Yes, and furnish the address where he will be residing.
Great.
Deeply obliged.
There's a slight mistake in my submissions, Lord.
Yes.
There are 19 witnesses, not 31.
ওটা 31 না করে 19 আচ্ছা 19 করে দেবেন।
Great. No more bail and
No. Bail and anticipatory bail will be completed after 10-15 minutes. Maybe. So what? So, okay, if they are not available, it will not be taken up. If both parties are not available, it will not be taken up. But I shall try to complete the bail and anticipatory bail matters after 15 minutes. No. If both parties are not ready, I'll not take it up. Yes, it is after completion.
শোনা যাচ্ছে? শোনা যাচ্ছে কিনা? অডিবল শোনা যাচ্ছে?
Mention never bail হয়ে যাওয়ার পর. Yes.
Divisional matter.
After this bail matters. Only those which were mentioned in the morning.
I for the petition.
Item 27. Okay, not today. Regular bench. Petitioner's advocate is not here. Okay, 50. Item 51. Okay. 51 and 52. 28. Item 28. My lord, 1 year and 3 months I am in custody. And item 28, who is appearing? 1 year and 3 months I am in custody, and it is written, as per direction of the officers, I searched both the vehicles. From the first vehicle, we recovered a trolley bag containing gaja of 12 kg, 12 and something. And from the second vehicle, we recovered a trolley bag and black bag written American containing gaja in packets, and the same was weighed by electronic weighing machine to be 12.400 kg. So total 24 kg was recovered from a vehicle. So there is a prima facie case against you. So far the co-accused person is concerned, there was no recovery. No recovery. No recovery. Yes, but we are 8 persons. And 8 persons were arrested, 7 persons were arrested, and it is written in the FIR, then 1 person fled away, managed to flee, and that person has been granted bail. However, we are there is recovery from you. We are in custody, not directly from me, my lord. Not directly. It is written from the vehicle. There are 2 trolleys. From one trolley 12 kg, from another trolley 12 kg. It is written in it is the case diary, my lord. It is the evidence. So on the last order of rejection, 7/10/2024. Yes. How many witnesses are examined? My lord, only 7 witnesses have been examined. How many witnesses are there? 13 witnesses are there. 13 plus 2 supplementary evidence. 15 witnesses are there. My lord, now, my lord, I am saying. How long you are in custody? My lord, 1 year, 3 months. 1 year, 3 months. I am. My lord, no, I am. My lord, 1 year, 3 months from since 2025. There is prima facie, there is case against you. You come after some time. Case is there, my lord, but there, my lord. So far the co-accused person is concerned, you do not stand in the same footing. No, my lord, stand in the same footing as, my lord, it is written that he managed to flee. Whatever it is, you say. Now, my lord, I am showing, my lord, only one thing, my lord. These 7 witnesses have been examined. Thereafter, my lord, special PP was appointed. As because, and these witnesses have been recalled. So it will take another 2 or 3 years. Anyway, liberty is granted to you. You can, yes. My lord, on any terms and conditions, my lord. You see, this is an NDPS case. How can any terms and conditions? But my lord, kindly see, my lord, this judgment, my lord, Supreme Court said, my lord, when there is no phenomenal progress is made. No, that I am observing. Okay. Yes, record an order. Learned advocate for the petitioner and learned advocate for the opposite party state are present. Are learned advocates. Upon perusing the materials on record and considering the nature of allegations, which is under section 20 within bracket B within bracket 2 within bracket C stroke 29 of the NDPS. It involves commercial quantity. Well, just above commercial quantity. From 7 commercial quantity. So, my lord, court is of the view that it is not the fit stage to grant bail to the petitioner. However, as 7 witnesses are already examined, and total number of witnesses out of 15 witnesses, the the learned trial judge is requested to expedite the trial and complete the same within a period of 4 months. Well, within 3 months. Within a period of 4 months from the date of communication of this order, stop. In the event the trial is not completed within the period of 4 months, the petitioner will be. No, trial has been progress. Now it is progress. Trial has been progress. His period of detention 1 year 6 months. No. So in the event the trial cannot be completed within a period of 4 months, the petitioner will be at liberty to pray for bail before the learned trial court. I love statement.
Well, 29, my lord, my lord, only 2 minutes I will take, my lord. Kindly see the page number 9. Kindly see page number 9. My lord, there are 3 petitioners, 2 petitioners first time. And my lord,
go for this petitioner number 3.
Yes. They were arrested on the same date and same footing. I am telling. My lord, there are 3 petitioners. And my lord, a total 5 petitioners have been charge sheeted. 5 accused persons, 2 are on bail. And my lord, this petitioner bail application was earlier rejected.
All 3?
All 3 now. Only third petitioner, that is Shoma Roy.
Yes. No, you are moving for all the petitioners.
I am for all the petitioners.
Yes.
And the 2 petitioners, it is the first application in respect of 2 petitioners. And Shoma Roy moved an application, my lord, before this honorable court. That was turned down. Thereafter, she preferred an application before the honorable Supreme Court. Kindly see, my lord, page number 10. Page number 10, my lord. However, the trial court is directed to expedite the trial and conclude the same preferably within 9 months from the date of receipt of a copy of this order. Within 9 months. So, my lord, only 2 or 3 witnesses have been examined out of 11 witnesses, and this order was passed on, my lord, 9th day of September 2024. So already 9 months have been passed.
Total, how long you are in custody?
My lord, I am in custody for, my lord, more than 2 years and 2 months.
More than 2 years, 2 months.
More than 2 years, 2 months.
All the 3 petitioners?
All the 3 petitioners.
And?
4. So 7, my lord, Supreme Court direction is there, and 2 years.
7 witnesses are to be examined?
Yes.
Yes, what was recovered from these 3 petitioners?
Total.
No, from, let us see.
That is why, my lord, Supreme Court made this direction. That is why Supreme Court made this observation, directing the learned trial court to conclude the trial within 9 months. And that order was duly communicated before the learned trial court. But, my lord, no phenomenal progress was made. Out of 11 witnesses, my lord, only 4 witnesses have been examined. And we are in custody for 2 years and 2 months.
No, the recovery was from the exclusive possession of these 3 petitioners. That means they were carrying packets.
That is doubtful, my lord. We challenge the same thing, my lord, before the taking evidence. But, and after considering all the aspects, my lord, the Honorable Apex Court, my lord, directed the learned trial court to conclude the trial within 9 months. That was not done. Search and seizure was highly, my lord, challenged at the time of evidence. And my lord, section 50 was not complied with, section 53A was not complied with. I am not on that. My lord, now I am on the point that, my lord, we are in custody for more than 2 years and 2 months, and Supreme Court direction was not complied with.
Total kg, how much? 990.
We made all our points before the Honorable Supreme Court. That is why matter that direction was made. So only touchstone of Article 21, as well as my lord. Judgment দুটো কোথায়? ওই judgment দুটো কোথায়? ওই যে judgment দুটো বের করে আনলে? Kindly see, my lord. On earlier date, my lord, by showing this judgment, this honorable court has been granted bail, my lord. It's on Article 21. And 2 years, 2 months we are in custody. No. Supreme Court, when the Supreme Court directed, how this honorable court will further direct?
So the articles are recovered from the vehicle, and articles were recovered from the vehicle. In that particular vehicle, these 3 persons were there.
My lord, this question was raised before the honorable Supreme Court. We highly challenged, my lord, the procedure of the
And the owner of the vehicle is implicated.
No.
The vehicle belongs to any of the 3 accused persons.
No. And no. Why? I am sitting here since 10:30.
So let me see all your records. Huh? So these 2 persons who were granted bail, from them there were no recovery.
That's right. That is Supreme, and for which, my lord, but there was connection that is proved. That is why Supreme Court made this direction. And this substance is a process was highly challenged. And this guy who has been granted bail, he is the owner. He is the owner. On personal information, person confessed that we are the seller of ganja and we are working under the person supply of certain stuff they divided in the code of supply and also disclosed that the same supplies to be on the time or one of the key whose number is certain. So that supply person might not have already been granted.
Yes, record and order.
No, my lord, but kind criminal antecedent is not part, that is on 7 days before Supreme Court passed a judgment.
Learned advocate for the petitioner and learned advocate for the opposite party state are present. Are learned advocates for the parties. Peruse the materials in the case diary. Learned advocate for the petitioner submits that his clients are in custody for more than for 2 years, 2 months, and the trial is yet to conclude. Learned advocate further draws attention to the order passed by the Honorable Supreme Court, which was a special leave petition moved by the petitioner number 3, Kumar Roy, Stop. By order dated 9/9/2024, the Honorable Apex Court was pleased to dismiss the special leave petition with the direction upon the trial court to expedite the trial and conclude the same, preferably within 9 months from the date of receipt of a copy of this order. Stop. Learned advocate submits that pursuant to the order passed by the Honorable Supreme Court, the trial is not expedited and it will not conclude within a short time. Stop. Learned advocate also submits that 2 co-accused persons are on bail and the prayer for bail made by the petitioners be considered, as there is no chance for the trial to be expedited. Stop. Learned advocate for the opposite party state submits that 90 kg of ganja was recovered from the 3 petitioners and the charge sheet has been submitted and the trial has commenced and 4 witnesses have already been examined. Learned advocate submits that the prayer may not be granted to the petitioners. Upon perusal of the case diary, it appears that the articles were seized from the vehicle in which the petitioners were traveling. Stop. The vehicle owner was granted bail as because his name transpired from the co-accused persons. As the trial has commenced, it would not be proper to make further observation with regard to the merits of the case, but it is necessary as to whether the petitioner should be enlarged on bail. Upon perusing the order passed by the Honorable Supreme Court with regard to the petitioner number 3, it appears that although there was a direction on 9/9/2024 to conclude the trial, preferably within 9 months, but till today, only 4 witnesses are examined, and it will take a considerable period to conclude the trial. It is also observed in different judicial pronouncements that where trial cannot be concluded within a reasonable period, the accused persons should be enlarged on bail. In the case of ওইটা একটু ইয়ে করে দেবেন, হ্যাঁ, ওই যে in the case of ওই অরবিন্দ কেজরিওয়ালের যেটা কোটেশনটা আছে না, ওই কোটেশনটা দিয়ে দেন ওইটুকু। How many witnesses are yet to be examined? 7. No, 4 witnesses examined. 7. Okay. At this stage, 7 more witnesses are required to be examined. Thus, the trial is not concluded within the period, cannot be concluded within the period as has been observed by the Honorable Supreme Court, and it will take a considerable time to conclude the trial. Considering the nature of offense, the materials in the case diary, and the fact that the petitioner number 3 is a female accused and is suffering incarceration for more than 2 years, and considering the order passed by the Honorable Supreme Court, this court is of the view that the petitioner number 3, Shoma Roy, should be released on bail. Thus, I allow the prayer for bail made by the petitioner number 3, Shoma Roy. The petitioner number 3, Shoma Roy, shall be released on bail with 2 sureties of rupees 10,000 each, one of which must be local, subject to the satisfaction of the learned trial court. The petitioner, upon being released, shall intimate the officer in charge of the concerned police station of her mobile number and the place where she is residing, and shall not leave the jurisdiction of the court without the leave of the trial court, and shall attend court on all dates fixed. The prayer for bail made by petitioner number 1 and 2 stands rejected at this stage. Anyway, the Supreme Court order was confined to this petitioner anyway.
Petitioner he only preferred this application, but we were arrested on the same day. We were arrested on the same day.
Anyway, you see, female accused sometimes stand in the different footing.
It is not mentioned, my lord, in the order, my lord. We are standing on the same footing, my lord. That is why, my lord.
You try after some time.
No, we are standing on the same date we are arrested. Thirdly, my lord, it is, my lord, completely opposite case to the, my lord, the previous case. The persons from whose possession, my lord, the narcotic, my lord, recovered, all the persons have been granted bail. And actually, I was arrested on 4/2/2025, and that is why, my lord, showing me myself as absconding, and that is why, my lord, my bail was earlier turned down. But thereafter also, my lord, the last person out of 8 persons, 5/2025, my lord, has been granted bail. So, my lord, only keeping myself behind the bar, if any progress be made, that is my.
How long you are in custody?
My lord, 4/2/2025, that is, my lord, 3 months.
No, why were you absconding for long period?
No, I was not absconding as because, my lord, I was arrested from my house.
No, question is any recovery?
No, nothing has been recovered from myself. Kindly see. Conversation, my lord, no.
Other accused persons are on bail.
All accused persons are on bail. All accused persons are on bail. Yes, that is why thereafter last petition has been
6.
Thereafter other persons have been granted bail. That is the change in circumstances. And from their possessions, my lord, these articles were recovered. From my possession, there is no recovery.
No, 8/4/2025, your
yes
application was last rejected. So what are the new grounds?
New ground, my lord, thereafter also, my lord, another person has been granted bail by this honorable court. Thereafter also, my lord, another person has been granted bail, and my lord, the prime accused, that is, my lord, Jagannath Niriki, he has already been granted bail long before. Well, only, my lord, I am in custody. Nothing has been recovered.
Oh, this Jagannath Niriki was enlarged on bail after custody for how many years?
Yes, he was. They were all in custody since the year 2021. Thereafter, my lord, my name has been transferred from the co-accused statement. That is not valid. Your lordship knows very well better than me. My lord, when they were in custody, they named myself. As per their statement, my name transferred. Thereafter, I was arrested. And before that, my lord, no police, my lord, came to my house. And I was arrested from my house.
Yes, what are the materials against him? How many witnesses are examined?
Not a single witness has been examined. 3, only 3 out of.
How many witnesses are to be examined? No, how many charge sheeted witnesses are there? 12. Anyway, what are the allegations against him?
Only statement, co-accused statement. Yes, only co-accused statement. No, not future. Kindly see the CD. Kindly see the CD. Where is the allegation against myself? Is anything has been, my lord, recovered from my possession? That
yes, which page? 25. 99.
Monetary transaction. So monetary transaction, how will you connect with this offense? It is written that during the custody they named myself. Long after, thereafter, my lord, my name transferred.
Oh, this is the account of this petitioner.
Oh, no, that is not the account of myself. My lord, can you see that is not the account of myself?
Page 99.
No, not the account of myself. Can you see?
Ramchandra.
Yes. My lord, can you see, my lord? It is not the account number of myself. Can you see it is written? No, my lord, the account number is also not mine.
Yes, item number. Yes, page number.
Kindly for the CD, where from? My lord, kindly see the my lord chart sheet. It is
Yes, you have
for-
submitted. Please let your learned friend submit.
এই chart sheet টা কোথায় এটা? Chart sheet টা কোথায়? So kindly show from my account, it was transferred to another account. Kindly show, kindly see. No. Kindly see, kindly show whether my account is involved. Then I will not utter any single word. Okay. But I am reading out.
So bank authorities were cited as witness.
No. But I am reading out. My lord, then everything will be clear. My lord. During investigation or follow-up action taken by other that's myself. I transfer this case. We make contact with the principal father. And my lord, the same to the account to downtown the father in to another person, namely my lord, that old account of Sabir Dafadar. Sabir Dafadar to Ramchandra Kedia. So where is this? Where is the name of my?
Yes.
My name is not there.
Learned advocate for the petitioner and learned advocate for the opposite party are present. Heard learned advocates produce the materials in the case diary. Learned advocate for the petitioner submits that all co-accused persons are on bail and there was no recovery from the petitioner and his prayer for bail be considered. Learned advocate for the opposite party state objects the grant of bail and submits that the petitioner was absconding for a long period and he used to finance the illegal business of narcotics. Upon learned advocate also draws attention to the bank accounts. Upon it further appears that the prayer for bail made by the petitioner was last rejected on 8/4/2025. It is true that the petitioner absconded for a long period and after his arrest. How long you are in custody now?
Well, 4 months.
After his arrest, he is in custody for 4 months. Upon further perusal of the case diary, it appears that there was no recovery from the petitioner and his name transferred from the co-accused person. And although bank statements are relied upon by learned advocate for the state, but at this stage, it cannot be inferred that these relate to the business of the petitioner. Upon considering the materials in the case diary, the period of detention, which is a period of 4 months, and the fact that co-accused persons are on bail, and 7 more witnesses are yet to be examined, this court is of the view that in the interest of justice, the petitioner should be released on bail. I therefore allow the prayer for bail made by the petitioner. Hence, the petitioner be released on bail with 2 sureties of rupees 10,000 each, one of which must be local, subject to satisfaction of learned trial court. The petitioner, upon being released, shall meet the officer in charge of the concerned police station once in a week and shall not leave the jurisdiction of the court without leave of the trial court, and shall submit the mobile number to the officer in charge of the concerned police station where he will be residing, and shall attend court on all dates fixed.
My lord, I answer the petition.
Highly obliged.
My lord, 1 kg is the commercial quantity from my possession. 1.693 kgs of codeine phosphate.
Yes, where is the state? Okay, not today, regular bench.
Ready?
32 I am for the petitioner. 32 I am for the petitioner.
Yes, who is for the state?
My lord, nothing has been recovered from my possession, my lord. Only statement of the co-accused person, my lord, my name has been transferred, my lord. My lord, I am for the petitioner, my lord. My lord, nothing has been recovered from my possession, my lord. Only statement of the co-accused person, my name.
How long
has
you
been-
need custody?
53 days, my lord. Worship, kindly see, my lord, nothing has been recovered, my lord. No phone call, no nothing, my lord.
One co-accused is on bail, one co-accused is in
No, my lord.
custody.
Principal accused has been is in custody, my lord. Noor Islam.
Yes, let me see the case diary.
Kindly see the seizure list and lordship. From one Noor Islam Mondal, my lord, the article has been seized, my lord. From Noor Islam Mondal.
Yes, record and order. Page?
Advocate and record.
Yes, record and order. Learned advocate for the petitioner and learned advocate for the opposite party are present. Are learned advocates. Peruse the materials in the case diary. It is submitted by the learned advocate that there was no recovery from the petitioner and his name transferred from the statement of the co-accused persons. Upon considering the materials in the case diary and the fact that there was no recovery from the petitioner and considering the period of detention, this court is of the view that the petitioner has been able to meet the rigors of Section 37 of the NDPS Act. Thus, the petitioner should be granted bail. Hence, the petitioner be released on bail with two sureties of rupees 10,000 each, one of which must be local. The petitioner, upon being released, shall meet the investigating officer twice a week and shall not leave the jurisdiction of the court and shall not do any act prejudicial to the investigation.
I'm grateful to us.
My lord, I am for the petition.
Not today.
Okay, 33, not today.
Great.
34, who is for the state?
My lord, although this is my renewal application, my lord, I will not take much more time of your lordship, my lord. What happened here, my lord? One raid was conducted in a godown. From godown, my lord, 369 liters of Procedural was, my lord, the cup syrup was recovered. My lord, the present petitioner before your lordship are there, my lord. There are many persons. One of them is, my lord, the labor of this particulars, my lord, the warehouse. My lord, the person who was rented in this godown, he was not been, my lord, cited as the accused. And my lord, the person from whom he was get the rent, my lord, he was not in the scene.
My lord, it was the last rejected.
My lord, kindly come to page 6, my lord. I am on my last rejection. There are other.
There is a last rejection.
My lord, page 7. Page 7.
Yes.
My lord, I am on the point of Article 21, my lord.
Yes, how long you are in custody?
About here, my lord, kindly come
Only
to
1 year.
Just my lord, kindly come to page 8, paragraph 5. Then, my lord, I am answering the question.
Yes, it was passed when? 16/12/2024.
Say
Okay.
December 2024, charge sheet filed July 2024. My lord, there was a direction to expedite the trial.
How many witnesses are to be examined?
Not only the examination of the witnesses, my lord, thereafter from December to, my lord, till June, my lord, charge has not been framed. 14 witnesses there. Other 2 accused persons are on bail, my lord. Next to the copy.
Your allegation, your petition was last rejected on 16/12/2000.
Yes, my lord.
Yes, record.
Charge not yet framed and
Charge
your
has not been
lordship
framed. One
on
year in
23/5/2025.
14 witnesses there, my lord.
Charge sheet not
For
yet
the state are present. Hard learned advocates. It
Last 6 months, no progress.
16/12/2024.
Order by this High Court, my lord.
Petitioner's prayer for bail was last rejected. Stop. Although there was a direction
Two
to
here only.
although there was a direction to expedite the trial, but at present the charge is not yet framed. Stop. Considering the materials in the
This is there, my lord.
See this?
the nature of offense and the materials on record, this court is of the view that at this stage the petitioner should not be enlarged on bail. Thus, the prayer for bail made by the petitioner stands rejected. Stop. Learned trial court is requested to expedite the trial and conclude the same within a period of 9 months. Stop. In the event the said trial is not concluded within a period of 9 months, the petitioner will be at liberty to pray for bail before the learned trial court.
Great. My lord, instead of 9 months, can it be, my lord, 6, my lord? My lord, all
9 months okay.
Because no witnesses are being examined.
14 witnesses there, my lord.
9
You
months
are
okay.
very 9 months.
Very well.
6 months impossible.
I am for the petition. Well, nothing has been recovered. Nothing has been recovered from my possession.
Not today, my lord.
Okay, not today. 36, okay, not today.
কত নম্বর ছিল এটা আমারটা?
37.
এই নিন।
37 not today.
Okay, 37, not today.
38, my lord, I am appearing for the petitioner.
The case diary है ना।
38, not today. Yes, 39, call.
Also not to do your lordship.
I did 39.
Yes.
Yes, not today.
Forty, my lord, I am for the petitioner, medical refuse, love affair, everything is there, my lord.
Yes, 40.
Not
today.
But a protection mechanism given.
No, it will be taken up next week itself, Monday. Yes, Kodedin,
I'm for petitioner, my lord.
41, yes. You have not received the case diary?
Yes, my lord, state is there, my lord.
You have received the case diary?
Deepankar Pramanik is there. বাইরে আছে। মানে kindly pass it over.
No, no, he has not received the case diary.
Case diary is also in.
Deepankar Pramanik is appearing in this matter, Lordship.
Oh, okay, then not today.
My lord, I am for the petitioner. My lord, 42.
Yes, 42. Who is appearing for the state?
My lord, Monisha Sharma. My lord, she was just now here. Hey, Orijita, Monisha ছিল তো?
Make it not. Make it not today, Lordship.
Okay, 42, not today.
My lord, I am for the petitioner.
Okay, not today.
44, my lord, I appear for the petitioner. It's a case, my lord, under section 308 and 354B of the Indian Penal Code. I tell you, Lordship, my lord, what had happened. My lord, two brothers and unpartitioned property. Now, my lord, one brother was
308 and
354B are the only non-bailable sections. My lord, the de facto complainant is the sister-in-law of these two petitioners. My lord, the brother, my lord, the petitioner number 1 and the injured are brothers, full-blooded brothers. Now, my lord, there was a property in which a construction was going on. It's an unpartitioned property. Now, my lord, thereafter, my lord, there was a scuffle. He suffered injuries. Now, my lord, presently, the disputes between the parties have been amicably settled. Now, my lord, there is no dispute, but it's between two brothers. My lord, kindly considers, my lord, one brother has leveled allegation against other brothers, and my lord, the injury, my lord, is not much, my lord. During the scuffle, that gentleman, my lord, fell down and he suffered injuries. Now, my lord,
yes. Just a minute. Yes, what is the nature of injury?
Lord, page 3 and page 17, my lord.
it has been settled, my lord. Kindly considers between two brothers who
Page
are
17,
landed properties,
page 7, my lord, and as well as page 3.
and it's 308. It's not even 307. 110 of BNS. The injured and the petitioner number 1, they are full-blooded brothers. It was their ancestral property. Over the dispute of property, my lord, the elder brother was constructing a kitchen over the, my lord, property which is still unpartitioned. The younger brother raised protest. There was a scuffle.
What is the statement of the injured person?
Injured person statement. My lord, there is Shanaza Khatun, page 5.
Page 5.
And there are eyewitnesses at page 8.
No, page 5 is the statement of the injured person.
My lord.
And eyewitnesses in which
Page 8, 9, 10. There are 3 eyewitnesses. My lord.
But the dispute has been settled now. My learned sister is appearing for the de facto complainant, but it has been settled because brothers, lordship understands, my lord, sending one brother into custody, my lord, will be of no help.
The nature of injury is grievous, not grievous.
It is stitches, my lord.
Nature of injury, yes. Learned advocate for the petitioner, learned advocate for the opposite party state, and learned advocate for the de facto complainant are present. Hard learned advocates. Learned advocate for the petitioner submits that it is a family dispute and the allegations made against the petitioner is not maintainable. Learned advocate for the opposite party state objects the grant of bail. Stop. And the learned advocate for the de facto complainant submits that the de facto complainant has no objection if bail is granted. Upon hearing the learned advocates and considering the materials of the case diary and the nature of injury, this court is of the view that custodial interrogation of the petitioners are not required. Thus, the petitioners should be granted anticipatory bail. Thus, I allow the prayer for anticipatory bail made by the petitioners. The petitioners shall be released on bail with 2 sureties of rupees 10,000 each, subject to the satisfaction of the arresting officer. The petitioners shall, upon being released, meet the IO as and when called and shall not do any act prejudicial to investigation.
But petitioner number 2 is a lady.
No, as and when called.
As and when called. Yes.
Grateful.
My lord, I am for the petitioner. My lord, allegation under section 341, 326, 34.
46. Yes, you are appearing 46.
46 Lordship, I am playing for not today.
Okay, 46 not today.
My
47, my lord, I appear for the petitioners, my lord.
Not playing for not today.
Okay, 47 not today.
My lord, the senior citizens, my lord.
It will be taken up on Monday before the regular bench.
Lordship, I am praying for not today.
48.
I am praying for not today.
Okay, not today.
49, I am for the petitioner.
48 not today. State is praying for time. State is praying for time. It is made not today. 48.
Sir, 49 together.
49 who is appearing?
I am for the petitioner.
Yes, 49. Do you have the case?
49 also I am praying for not today.
Okay,
My lord,
49.
49 kindly fix on 13, my lord.
Yes, item 49.
Yes, my lord.
Okay.
I'm the bank. There is public money involved. Your lordship would kindly direct them to supply us a copy. Your bank, my lord.
Yes. No, question is, you see, in all cases, you see, de facto complaints are not served. But
True. But when a bank is involved and public money is
you are the de facto complainant.
de facto, I'm the bank.
Question is, you can submit only from your complaint, but it is the public prosecutor who can get the case records.
Unfortunately, the law has changed that with us.
No, not in all cases.
But in Jagjit Singh's case,
Yes.
the Supreme Court is saying that where the matter is of some importance and the de facto wishes to participate, he must be given a passive participatory right in bail.
Okay, you obtain on the next day. Necessary.
My lord, kindly fix the
Okay.
49 on 13, my lord.
Learned advocates for the parties pray for time. Let the matter appear on 13/6/2025. Make your prayer before the regular.
40 and 49 both.
48 and 49.
I'm grateful, my lord.
For the petition,
Yes,
Nothing
50.
is there, my lord.
50 who is for the state?
Case and counter case.
Lord, I'm praying not today.
Okay, not today 50. 51 and 52 already made not today.
Not today.
And
And 53
53.
also I'm praying.
53?
53 I'm for the state.
Okay, 53 not today. 53 acha kyo petitioner hai?
Criminal division.
No, 53 anybody is appearing.
I'm ready, man.
You are for the state.
Yes, for the state.
Okay, not today.
Yes,
Yes, criminal revisions.
60. My lord, 63.
Just a matter. The was mentioned in the morning. Yes, you want.
But I 63 I had mentioned.
Yes.
Only one matter, my lord. Item number.
জলপাইগুড়ি matter গুলো দেখেছেন?
My lord, circuit bench matter, I have mentioned, my lord.
এই সার্কিট বেঞ্চ না
But circuit bench is there.
জলপাইগুড়ি কি ইয়ে What is present?
Yes, my lord.
Below 3 p.m.
My lord, 63, my lord.
জলপাইগুড়ি ম্যাটার বলছে তো
জলপাইগুড়ি matter, both parties present.
My lord, Jalpaiguri, I am for the petitioner in.
Yes, state present. Jalpaiguri.
আইটেম নাম্বার তো বলো না
Item number 3.
Item number 2.
Yes, you are not representing the state.
Not instructed in the
But Jalpaiguri, item number 2.
Item number 2. Anyway, both parties are not present.
My submission is this, my lord. I am
Kind-
a teacher, my lord. School teacher.
Kindly grants us some interim protection.
So, in the absence of others, and how
Only protection they kindly give.
Man sends it back to the circuit
Jalpaiguri
bench.
matter.
Yes.
But you see, in the absence of the other side,
My lord, I
My lord, last 4 days, since 28, my lord, they are not producing the case diary. We apprehend arrest.
so it can be moved before the Jalpaiguri bench. Okay. From Monday, I think the Jalpaiguri bench will start. It can be moved on before the Jalpaiguri bench itself.
my lord, I am stating only one.
But some interim protection and my lord, till such time, my lord,
Whatever it
it's a
is.
case based on documentary evidence, my lord. It's a case of
But you are not in custody, so you have nothing.
Not in custody, but there is every
apprehension of arrest.
arrested, my lord. I am a government teacher and I was on that very date, my lord, at his school.
Yes, are you?
That is, my lord, 7 days protection may kindly be given, my lord, within 7 days, my lord.
But 7 days protection, we will go back to the
In
circuit.
in the absence of the other side, it is not proper.
Protection only.
my
not
lord
to-
revision my lord
That is also, you see, an order. Okay, it should be done upon hearing.
Otherwise, my lord, if I will state, my lord, the petition will be in front to us.
So why are you apprehending arrest? When was the case instituted?
No, my lord, that is not the bar.
No, case was instituted when?
My lord, case is instituted in the year 20, on, my lord, 2025.
No, which month?
My lord, in the month of May.
Month of May. Anyway, this month of June.
The very date, my lord, when I got information, my lord, I then and then I filed prepared this application.
See, it would not be proper. This is a Jalpaiguri matter. Had it been Calcutta matters, I could have requested any learned advocate. Okay. But I don't know Jalpaiguri matter whether the case diary is here or not, who can represent. Anyway, so you try your luck on Monday.
My lord, criminal revision, my lord. Item number 8. My lord, circuit bench, Jalpaiguri matter, item number 1.
Yes, just criminal revision, which matter?
Criminal revision, my lord. My lord, 63 and 68. My lord, there are few matters, my lord, can be taken up, my lord. There are few matters, my lord.
Just a minute. Yes, maintain your sincerity. Yes,
item number.
I had mentioned 63.
So 76 is mentioned.
Yes,
My lord,
74. I had mentioned.
My lord, item number 8. No, my lord, kindly take it.
I had mentioned 63.
76. 78. Who is appearing? 78.
74. But I had mentioned 60 in the morning.
80, you are for? Okay,
81 minutes.
Please, let me all the numbers which are already mentioned.
So 3 in the morning.
Okay, 76, Mr. Chaudhary, Dr. Chaudhary.
Lordship, item number 97, Lordship.
Please, let me mention the numbers present, what the numbers which I have marked. 76, Dr. Chaudhary is present. 78, anybody present? Item 78, okay, not today.
74.
Just a minute. 80, you are present.
Lordship, I'm appearing for item number 78.
Okay, item 78.
81.
63.
Just a minute. 80, anybody present? 80?
80.
Okay, 80. Yes, 81?
81 minutes.
81 is present. 89? Is 90? Okay. 63?
I had mentioned.
Lordship, 97, I had mentioned.
74, my lord, I have mentioned. 63, I am for the petitioner. 74. 63 and 68.
74.
Yes,
Now, my lord, 73, my lord.
For what is the urgency?
My lord, octogenarian persons are implicated in a false case. Police regularly.
My lord, 73, my lord.
105.
Lordship, 97, I had mentioned in the morning.
73, my lord. My lord, 73, my lord. My lord, 73.
Item 97, Lordship, I had mentioned in the morning, Lordship. 97, Lordship.
Yours?
My lord, my matter is 73, my lord, at the behest of the wife for interim alimony, 23 dB.
My lord, 103 to
3
105.
p.m. matter. Please let the criminal revisions be over. Yes. Criminal revision. Item?
103 to 105.
Lordship, 97, Lordship.
1 million.
Lordship, item number 1.
Item? 101.
Item 89, my lord, my junior mentioned it.
Yes, it is marked. It is already marked.
100 and takes it up, my lord.
97, I have mentioned.
Troubling your lordship, kindly, my lord, takes it up. It will
101.
not take-
Your is 197.
97, Lordship. I had mentioned.
And my lord, 3 p.m. fixed criminal matter, my lord.
Lordship, 97, I had mentioned in the morning. Item number 97, Lordship. I had mentioned in the morning, Lordship.
Item?
97.
Item 70. Yes, I have already marked.
103 to 105.
Yes, those are civil matters. Let the criminal matters be over.
97.
My lord, may I be permitted to mention?
87 already marked.
Obliged, Lordship.
My lord, may I be permitted to mention?
Yes.
My lord, circuit bench, Jalpaiguri matter, item number 1, my lord.
No, circuit bench matter
For bail.
is not here. It will be taken up on Monday.
Grateful.
Yes, call the matter. Item 63.
63, my lord, I appear for the petitioner.
Yes. All
63, my lord, I appear for the.
Yes, please wait. Let the
My lord,
criminal matter.
63, I appear for the petitioner.
63, please keep the file.
My lord, I am the accused in a criminal proceeding.
Lordship is taking up item 89.
No,
63.
But I am an accused, my lord, in a criminal proceeding. My lord, the evidence of PW7 is over. But thereafter, my lord, the prosecution comes up with a petition under 311. But kindly comes to the petition under section 311. Now, my lord, your lordship knows, my lord, this honorable court in a catena of decisions has held that in 311, the questions which are to be put on recall, my lord, that has to be spelled out in the petition, nothing spelled out.
Which page?
My lord, kindly comes to the, my lord, the certified copy. I have annexed the petition under section 311. My lord, it's a petition dated 25th of February 2025.
What is the order passed by the court?
My lord, order passed by the court. My lord, the lordship would get it as a part of the certified copy.
No, which page? Which page?
My lord, just, my lord, it is after, my lord, page number 169. My lord, at such a belated stage, 311 is allowed. And the 311 petition does not contain any questions which are to be asked to the witness on record.
No, I'm asking where is the order?
Order number 32, just after page 169.
Just of page 169.
Lordship is getting the certified copy, first order, order number 32.
After how many?
After PW7 is over. But thereafter 311 is allowed. And kindly sees, my lord, this honorable court in a category of decisions is held.
What is the offense?
My offense is 302. I am the accused. Prosecution has filed this petition. After PW7, all vital witnesses over, 311 is filed.
Yes, record an order.
But I was praying for stay of all further proceeding.
Learned advocate for the petitioner is present. Hard learned advocate for the petitioner. The petitioner has challenged order dated 2/5/2025 passed by the learned additional district and sessions judge, first track first court, Barakpur, North 24 Parganas, in ST 5 within bracket 7/23. It is submitted by the learned advocate that after 7 vital witnesses were examined, the prosecution has filed this application under section 311 of CRPC to cover up the laches. Upon hearing the learned advocates and upon considering the order passed by the learned trial court, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite party state of West Bengal within 3 days from the date of reopening after vacation and affidavit of service filed. Let this matter appear 3 weeks after vacation. Pending hearing of this application, there shall be a stay of further proceedings in ST 5/7 of 2023 for a period of 4 weeks from the date of reopening after vacation.
Grateful.
Yes, item 68 ta takun.
68 minute I appear for the petition. Malad 317-476, two consenting adults. Malad, they were in a long-standing relation. Now, Malad, kindly sees, Malad, in the Malad PT 164, she admits I have annexed the entire 207 papers which have been supplied to me by the court. Malad, she admits that there was a love relation they made through Facebook, and the Honorable Supreme Court, my lord, in a recent decision has held that, my lord, no offense is made out. My lord, this is the decision. My lord, kindly sees, my lord, this is the latest judgment of the Honorable Supreme Court. My lord, in which the Honorable Supreme Court has said, my lord, has quashed.
When is the next date fixed?
My lord, next date fixed before the learned trial court is on 6th. That is tomorrow. That is why, my lord, I have mentioned it before your lordships. My lord, tomorrow is the date fixed for framing of charge.
When did you file this application?
I have filed this application, my lord, on 20th of May, just before the vacations. But I was praying for a stay. Let me serve copy upon the opposite parties.
ওরা ডেট ফেলে দিয়েছে, এবার আলটিমেটলি হবে না, আলটিমেটলি নোটিফাই করে দেবো। Learned advocate for the petitioner and learned advocate for the petitioner is present. Our learned advocate for the petitioner. The petitioner in this instant application has sought to quash the proceedings in connection with SC number 24 of 2025 corresponding to GR number 1830 of 2024 arising out of Chakda police station case number 712 of 2024 dated 1st July 2024 pending before learned additional sessions judge fast track court Kollani district Nadia. Stop. It is contended by the latest submitted by the learned advocate that the allegations made against the petitioner is not is maintainable in law and for which the petitioner has filed this application for quashing the entire case. Learned advocate also relies upon the decision of Rajini Singh alias Soni versus State of Uttar Pradesh and another, reported in 2025 4 SCC, page 197. Upon hearing the learned advocates and considering the nature of allegations, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon both the opposite parties within 5 days from the date of reopening after vacation. An affidavit of service be filed. Let this matter appear 3 weeks after vacation. Pending hearing of this application, there shall be a stay of further proceedings in regard to SC number 24 of 2025 pending before learned additional sessions judge fast track court Kollani district Nadia for a period of 4 weeks after vacation.
Great. Grateful.
4 weeks after vacation, stay. Further proceedings. 70.
70 I am for the petitioner, my lord. My lord kindly takes up the 71 first. That will be the leading matter, my lord. These 3 matters, my lord, 70 to 72 is an analogous matter, my lord. Kindly takes up the 71 first. Which 70 take a 72, 71 to first. Analogous matter. 71 to first.
Yes, 70. What are your contentions?
Kindly takes up the 71 first, my lord.
Yes, this is 71.
71 first, kindly. Then I will come to the 70 and 70 and 72.
70 yet in one body.
Yes. These 5 petitioners are related. These 5 petitioners, my lord, before your lordship, is come to quash the proceedings against initiated them on in CR case number 1096 of 2024.
Yes.
Previously, the opposite party number 2 has initiated one FIR. That is the subject matter of 70 and 71. He initiated one FIR under section 307, 334, 323, 498A before the NDPS. Though the cause of action has been arised in under the Horiarpara PS. And lordship knows better than me, there is no pecuniary jurisdiction in the criminal proceedings court. And secondly, my lord, I'm kindly come to the page number 22, the contention of the FIR.
No, the charge sheet is submitted.
In that,
no, the court has taken cognizance.
Court has taken cognizance.
Yes.
It's a complaint case.
Yes.
And we better know that without a complaint, there will not be able to initiate one FIR.
So in Supreme Court in various judgments, like T.T. Anthony has stated that if the cause of action, date and time, and also the place of occurrence will be the same, the two simultaneous FIR cannot stand. First FIR will be stand and second FIR will be quashed.
No, this is 71. You are relying upon the complaint.
Yes, my lord.
Filed by the filed by the petitioner, the opposite party number 2.
Opposite party number 2.
Yes.
Now, kindly come to page number 23 on the last portion.
Yes.
May I read for your lordship?
Yes.
গত ইংরেজির 21/4 my Bengali is little bit of bad, my lord. তারিখে বাদী অকথ্য ভাষায় গালিগালাজ করে, বাদী মৌখিক প্রতিবাদ করলে উপরোক্ত সকল আসামিগণ মিলে এলোপাথারি ভাবে মারধর করে বাদীকে প্রাণে মেরে ফেলার উদ্দেশ্যে মুখে বালিশ চাপা দিয়ে শ্বাসরোধ করে। Now, kindly come to the page number 18 of Lordship's brief. The first FIR.
Yes.
On the last portion, my lord, গত ইংরেজির 21/4/2024 উপর তারিখে রাত্রি 10টা নাগাদ আমাকে আমাকে মারধর করে, আমাকে প্রাণে মারার উদ্দেশ্যে শ্বাসরোধের জন্য আমার
No, you see, if there is complaint before the police authority and before the
court, this is the same. This
no, wait, question is one, the court proceedings will be stayed.
Yes, my lord. I want this CR case will be stayed, my lord.
So this is with regard to CR 1096.
1096.
When it was lodged?
It was lodged belatedly on 5th of October 2024.
Okay. And the complaint before police?
Complaint before police is 9th of August 2024.
9th of August, and this is 5th of October.
This is 5th of October. And surprisingly, the complaint before the police was belatedly 4 months after. The incident
complaint before the police is 9/8/2024.
Yes.
And this is?
This is the CR case has been initiated on
21/4. No, not 21/4.
No, not 21/4, my lord. It's on. The date has not been mentioned here. It's on 5th of October. I have seen the records in lower court because I have stated.
Oh, where have you stated? Which paragraph?
Paragraph number 10, page number 6.
Paragraph number 10, page number 6.
Page number 6 of main petition, my lord. Moreover, it is stated.
Anyway, so this is a ground for stay of this complaint case.
Complaint case, because my lord, may I cite one judgment before your lordship?
No, anyway, you come to the next. So this is the ground for stay.
This is the ground for stay.
Yes, and what is the case with regard to 70?
70, my lord kindly comes to the FIR portion.
Okay, 70 ta din to
70.
No, is it the FIR which you are relying upon this other petition, CR 2425, or is it a different case?
This is a different case.
Different case, yes.
This is a different case. And this is a same petitioner, two different cases. Same petitioners.
Okay, this is before the police authority.
This is before the police authority. Kindly come to the page number 15 once, my lord. Same paragraph. The date of the incident and place of the incident is under Horiarpara PS.
Yes.
It's not under Nauda PS. Nauda PS has to transfer the FIR to Horiarpara PS.
That's a different issue. Why at this stage? For that, why it will be quashed?
My lord, kindly appreciate one thing. If a person, may I cite one example for my side? This is I have faced recently. I have lost my mobile under the PS of
So this officer in charge, this is not the PS.
No the PS, and no in the charge sheet, no the PS has never mentioned. They have informed the Horiarpara PS that they are going to the investigation.
Charge sheet is already submitted.
Charge sheet is already submitted. Charge sheet is under 498A and 34. How can now the PS submit the charge sheet and do the investigation where the place of occurrence is Horiarpara PS? My lord, kindly stay there. This is my only prayer. Kindly stay these proceedings and heard the matter elaborately, my lord.
Yes, where is that other? 472?
This is a
72.
72 is for the other accused person who are the in-laws.
72, yes.
72 and 70 is collaborating, is same, my lord.
Oh, is it the case that both PS case and this complaint case?
Complaint case, my lord.
Where is the PS case copy?
PS case, my lord,
page.
PS case copy is my lord.
Here, charge sheet is already submitted.
Charge sheet is already submitted.
Oh, what is the allegations here?
Here is the allegation is the 307 has been went out, and for only 498A and 34.
So what is this relation?
Relation between the opposite party number.
This petitioner.
This petition.
So there are so many petitioners.
4 petitioners are there. First petitioner, Mr. Gajul Mondol. Petitioner number 1 is a father-in-law. Who is suffering for cancer 4th stage, my lord. I have pleaded all things in my petition and the annex the all document. And petitioner number 2, Pushparani Mondol, is the grandmother-in-law. Maluti Mondol also grandmother-in-law. And petitioner number 4, Joyshri Mondol, is the distant relationship. He is the auntie.
What is your ground of challenge in this case?
This case grounds of there is two grounds. One, the jurisdiction issue, the issue of initiation of FIR, my lord. Initiation of FIR can be now the PS, but the FIR should be transferred to the Horiarpara PS because the place of occurrence has been placed in Horiarpara PS. They have cited in their FIR, my lord. And another issue, the incident happened in 21st of April 2024. The FIR has been initiated 9th August 2024. Belatedly 4 months. There is no explanation of delay.
Does this 2415, that is 70 and 72,
70.
relate with the same FIR?
Same FIR.
So here the husband has sought for quashing and 72 the
in-laws
have sought for quashing.
Quashing.
Yes. Item 70. 70. Learned advocate for the petitioner is present. Hard learned advocate for the petitioner. Learned advocate for the petitioner submits that this case is instituted against the petitioner is liable to be quashed as the cause of action took place within the jurisdiction of Horihorpara PS, but the case was investigated by Nodapara PS, which is against the provisions of law. Learned advocate further submits that the allegations made against the petitioner is also not maintainable. Upon considering the materials on record and upon hearing the learned advocate, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within five days from the date of reopening after vacation. An affidavit of service filed. Let this matter appear 3 weeks after vacation. Pending hearing of this application, there shall be a stay of further proceedings of GR case number 4030 of 2024, pending before learned judicial magistrate, third court, Bahrampur, Murshidabad, for a period of 4 weeks from the date of reopening after vacation. Item 70 are item 72 same. ওখানে পিটিশনারের জায়গায় 72 তে পিটিশনার্স করে দেবেন। Yes. So 71. Learned advocate 71. Learned advocate for the petitioner is present. Our learned advocate for the petitioner, it is submitted by the learned advocate that the de facto complainant has instituted both a police complaint as well as complaint before the learned magistrate with regard to self-same cause of action. Learned advocate draws attention to the copy of the complaint made before the police authority and the copy of complaint made before learned CJM Murshidabad at Bahrampur. Stop. Upon hearing the learned advocates and upon perusing the facts of the case, this court is of the view that this application should be admitted. Thus, should be admitted. ওই একই অর্ডার করে দেবেন ওই যেরকম করেছিলাম। Thus, I admit this divisional application. Let notice ওটা যেরকম ছিল সেরকমই, ঠিক আছে? Pending hearing of this application, there shall be a stay of the complaint case number 1096 of 2024, pending before learned judicial magistrate at Bahrampur, Murshidabad. Which judicial magistrate? Only one JM?
Second JM.
But you have not, okay. Learned judicial magistrate, second court at Bahrampur.
Second court, my lord.
Within a period, for a period of 4 weeks from the date of reopening after vacation.
My lord, may I request one thing? Kindly made this three petition parted before your lordship.
No, why parted? This is an admission stage.
My lord, I am led by Mr. Showman Bhattacharya. I have put his.
Okay, 72 হয়ে গেল।
My lord, 73 had mentioned, my lord.
73 আছে।
73 had mentioned. My lord, it is in the, my lord, at the behest of the wife. My lord, I have already served the husband.
Yes.
Though it is, my lord, before my lord Justice Bandyopadhyay, my lord, I had mentioned that it is in the
So
course
the
of
matter is
delivery.
admitted. The case is admitted, application is
No, my lord,
admitted.
its service was not complete. That's why her lordship
No,
still before your lordship, my lord.
no question.
Now, my lord, the matter relates to refusal of interim order of alimony under 23 of the DV Act. And my lord, it was heard in the presence of the husband. And my lord, that against the refusal I had.
Where is that order?
My lord, kindly see the interim order is of revision. Affirmative order without going to the merits or even the DV Act petition.
Where is that order?
My lord,
Okay, a certified copy.
yes, my lord. Last page. My lord, there the learned judge has mentioned that after 2015, I was ousted. Learned judge my lord, simplicity has stated that there is no torture, but that was, my lord, factually incorrect, because in the petition itself I had stated in 21 the husband had come to my parental home to torture. So learned judge, learned magistrate, as also the learned session judge relied on the DIR only, but when the DIR was wrong. Then this is one count, and secondly, your lordship kindly finds only 2,000 rupees maintenance order was there in 125. That was the reason for refusing.
See, if a decision is to be arrived at, hearing of the other party is not necessary.
My lord, I understand, my lord. Only
What
one.
do you want at present? Stay or there is no stay of further proceeding.
No, my lord. But only thing is that kindly after this revisional court's order, my case before the London magistrate gets prejudiced, because London judge has almost disclosed his mind. As also, I am only suggesting your lordship may kindly set aside this order and set it back before the London revisional court.
If I want to set aside again, I have to hear the other side.
I have already served, my lord. That is what I.
Actually, you see, now at evening they are not present anyway. Because there is no scope for any interim order.
My lord, interim order in the sense his husband is not a government, and I am only not even that. And from 2015 till date, he is earning 50,000 rupees.
So
And
that means, you see, when is the next date fixed before the trial court?
that was June 2024. Nani just stated no question of maintenance. Considered final maintenance.
That means you want to say that by this order, the learned trial judge may be prejudiced.
Yes,
I can grant you one opportunity, fix a date for hearing and grant you liberty to take adjournment before the learned trial court, so that you can obtain a decision from this court. That much I can grant you. Yes. Learned advocate for the petitioner is present. Non-appears for the opposite parties. However, in the interest of justice, the matter stands adjourned till 13/6/2025.
I'm grateful.
Let one more service be effected upon the opposite parties.
I'm grateful.
As this matter is sub judice before this court, the petitioner may seek adjournment before the learned trial court, which may be considered.
And kindly, your lordship kindly grants me liberty to pray for all interim reliefs in the petition before the regular honorable court. Only that mention that interim order prayer was not heard before your lordship.
Yes, the petitioner is also granted liberty to make necessary applications for interim reliefs.
I'm grateful, Mala. Great.
Yes, let the affidavit of service file be kept with the record.
My lord, I am for the petitioners, my lord. But petitioners is falsely implicated in a criminal case at the instance of the de facto complainant, who is forcefully grabbing the land of the petitioners. And out of revenge, this is a mere counterblast. The de facto complainant moved this case before the learned CJM of Purva Bardhaman. My lord, they are the octogenarian people, 83 years, 75 years. One is orthopedically handicapped. How they involved in a offense like 352, 1152, or
anyway, for this you see case diary is necessary.
My lord,
case diary has to be called.
My lord, I have attached the charge sheet along with the 175(3) petition. My lord.
No, whatever it is, case diary is also necessary. The nature of involvement of the
Yes,
parties.
my lord.
Yes, record and order.
Let the proceeding be stayed for the
learned advocate for the petitioner is present. Learned advocate
direction
for the
given to serve, my lord.
petitioner.
The octogenarian, they are not
Learned advocate
global,
for
my
the
lord.
petitioner submits. Who are octogenarian?
My lord, the petitioners.
Which petitioner?
My lord, petitioner number 3, Kanai Mukherjee.
Learned advocate
Petitioner number 4, Chanda Mukherjee.
Petitioners number
And my lord, petitioner number 1 is orthopedically handicapped. My lord.
3 and 4 are aged persons, and they have been falsely implicated in the instant case. And the allegations made against the petitioners are not maintainable. Stop. As the charge sheet has already been submitted, it is necessary to peruse the case diary to arrive at a decision. Thus, notice be issued upon the opposite parties within 1 week after vacation. Let the case diary be produced by the opposite party number 1.
Well, till the period.
Let this matter appear 3 weeks after vacation. Pending hearing of this application, let there be a stay of further proceedings with regard to
There is an order of civil court for the injunction.
for the proceeding with regard
Crowding the injunction, the de facto complaint made the
for the
unauthorized construction
with
over
regard
land
to
occupied.
memory PS case number 883 of 2024, 883 of 2024 dated 15/11/2024, as well as what is the GR case number?
My lord, this is not yet, GR number is not yet put, my lord. This is a memory PS case number, my lord.
Okay.
Memory PS case number.
Okay, that is it. And charge sheet number 213 of
Yes, my lord.
2025
That
dated
is annex, my lord.
30/4/2025 for a period of 4 weeks after vacation.
Bibliography. Let urgent website copy, my lord.
Yes.
Police is harassing, my lord. Urgent website copy is necessary.
That you can get it. Server copy. Seventy-four. No. 73 holo to. 74 to 76.
Lord, I am for the petitioner. May it please your lordship. Lord, the petitioner before your lordship, my lord, is an erstwhile managing director of a company, my lord, which is into service providing. My lord, the company provides services, my lord, like trademark registration, food license registration, etc., etc. My lord, amongst all, my lord, there is one service they provide, that is drafting of complaint, letter, representation, and submitting it with the administrative authorities. Now, my lord, the story starts. This lady, my lord, who is the de facto complainant, the OP number 2, my lord, she has been duped by some scamsters online to the tune of rupees 12,000. Lord, after that, she starts, Lord, searching on Google how to file an online complaint. Lord, she finds my website. She enters into my website, Lord, puts her details there, and Lord, one associate from my company contacts her. Lord, after the contact, Lord, my associate comes to know that this is the difficulty, and one online complaint before the National Cybercrime Portal has to be lodged. That was her grievance. Lord, I say a charge of rupees 999 plus 18% GST has to be paid. She pays that, my lord. 1179 is the payment, my lord, she does. Thereafter, my lord, on the same date, that is, my lord, on 23rd of January 2023, my lord, the cybercrime control, the complaint has been lodged by me. My lord, after that, after 2 months of lodging the complaint, my lord, I also prefer a RTI application to seeking the status of the complaint, my lord, as to what has happened with the complaint, free of cost. Lord, astonishingly, after 2 months, Lord, this lady goes before the police and files a complaint that she has paid my company 1179 rupees, but I have not provided her any service. My lord, complaint FIR registered 406, 420, 120B of the Indian Penal Code. My lord, I must be candid.
So what is this order which you have relied upon?
Yes. I am coming to that. My lord, just after the FIR was registered, my lord, we had approached this honorable court for quashing.
Yes.
But my lord, the honorable court declined me relief, saying that the investigation is going on. Let the police investigate, and thereafter, if you want, you may come. Now, my lord, the charge sheet has been submitted. My lord, I have been given the 207 papers. My lord, I know what the police has collected against me. My lord, except few 161 statements, nothing. My lord, in the charge sheet, the lady has not even cooperated with the police, not even given the bank statements. My lord, I have issued a receipt, I have provided service to the tune of my lord, drafting the complaint, and my lord, I have taken charge of rupees 999 plus GST. So, my lord, at the best, my lord, if she is aggrieved, this could come under deficiency of service, if at all. But, my lord, what happened? She files a complaint before the police, and this FIR has been lodged. Now, my lord, coming to the legal submissions. My lord, 406 and 420, your lordship knows, my lord, both are antithetical to each other. They cannot coexist simultaneously. My lord, the Supreme Court has categorically said, my lord, the landmark judgment, Delhi Race Club, my lord, 406, 420 cannot exist together. Next, my lord, comes the company. I am the managing director. Nothing
overt act has been attributed to me. Only it has been.
What is the copy of
Milord,
the FIR?
Milord, page 23.
Page 23.
Page 23, Milord. Kindly see once. একটু খুলো না, Milord.
The nature of amount involved, how much?
Total 179, 1179 rupees.
Now you're on bail.
I'm on bail, Milord, yes. Now, Milord, in the last portion of the complaint, Lordship will find 1, 2, 3, 4, 5, 6. Milord, 4th line from the bottom. Milord, searching their website, it could be learned that original name of their office is Fast Info and director is Rajesh Kewat. This is, Milord, my implication. I am the director of the company, nothing else. Now, Milord, the company itself has not been made an accused. Milord knows this is a settled proposition of law, Milord, without making.
It remains in your name.
Yes.
And director.
Yes.
So this account is in the this online website is in the name of the company.
Yes.
Of which you are the director.
Yes.
How many directors are there in that company?
Milord, there are 2. At that point of time, 2, Milord. Now the number of directors has increased. Milord, I am praying for a limited period stay. I will serve and come back.
For the petitioner is present. Dr. Chaudhary, learned advocate for the petitioner, and produce the materials on record. Learned advocate for the petitioner submits that the allegations made against his client is not maintainable, and the petitioner has rendered service to the de facto complainant and received the service charge. Stop. Learned advocate further submits that the website is in the name of the company of which he is a director, and the company is not implicated. There is no mention of the company. Learned advocate further draws attention that as the charge sheet has been submitted without proper materials, the petitioner has filed this application for quashing the same. Stop. Upon hearing the learned advocates and considering the facts of the case, this court is of the view that this application should be admitted. Thus, I admit this revisional application. Let notice be issued upon the opposite parties within 1 week after vacation, an affidavit of service be filed. Let this matter appear 3 weeks after vacation. Let the case diary be produced by the opposite party state of West Bengal. Stop. Pending hearing of this application, let there be a stay of further proceedings with regard to here 262/2023 arising out of Bidhan Nagar Cyber Crimes PS case number 30/2023 dated 17/3/2023 under sections 406, 420, 120B of IPC, now pending before the Court of Learned Additional Chief Judicial Magistrate at Bidhan Nagar, North 24 Parganas, for a period of 4 weeks after reopening, 4 weeks from the date of reopening after vacation.
Grateful to your Lordship. We can let the
yes, 80.
Milord, I am appealing for the petitioners. Milord, the petitioners had been granted bail by the learned sessions judge. Milord, I have challenged the warrant of arrest. Milord. The petitioner had been granted bail by the learned sessions judge. Thereafter, they failed to appear on 2 occasions, on 19th of June 2024 and 6th of September 2024. Thereafter, warrant of arrest was issued on 28th of January 2025. But the allegation is under section 427 and 430.
How many dates you have defaulted?
Milord, on 2 occasions.
Yes, what is the 2
Milord,
occasions?
19th of June 2024.
No, were you represented by learned advocate?
Milord, I have been represented by learned advocate.
No, when, which page?
Milord, this was, Milord, certified copy. Milord.
No, 28/1.
Yes, Milord, 28th of January 2025.
This is the only day, or earlier there was?
This is the only date, Milord. The warrant of arrest was issued. On earlier date, Milord, I have missed the court, Milord, on 6th of September 2024.
So on 2/12 you appeared.
Milord,
2/12, 2nd of December.
on 2nd of December, Milord, there was no step. There was a resolution of no steps taken, Milord. 2012. There was a resolution of the bar.
See, 6/9/2024 you could not be present.
Yes, on 6/9/2024, I was not present before the
Yes.
learned trial court, and
Yes.
before that, on 19th of June 2024, I was not present. On these 2 dates, I had missed. Milord.
Thereafter, 2nd of December.
Thereafter, Milord, 2nd of December, Milord, I was not present, Milord. Thereafter, on 28th of January, the warrant was issued.
So 4 occasions you were not present.
We were on 3 occasions.
No, you see, question is, was there any step on from your side?
No, Milord. There was no step was taken by my learned lawyer, Milord, on my side, Milord.
It's not
And-
that any time was sought for.
Yes, Milord.
Yes,
And
what
no-
is the stage?
It is at this stage, Milord, after cognizance was taken on, Milord, in 2023, 22nd of September 2023.
What is the ground for not being present?
Well, the ground was that, Milord, there was a miscommunication, Milord. There were various dates on where the learned local bar was taking resolution to not to attend the court. But my prayer is, Milord, kindly stay the warrant, allow me to surrender before the learned court. Milord, kindly give a direction
for
that
the
on surrender of the
petitioner
petitioners, the prayer for
is
bail
present. Hard
may
learned
be considered.
advocate for the petitioner. Peruse the materials on record. The case of the petitioner is that he failed to appear before the court on 19/6/2024, 6/9/2024, 2/12/24, and 28/1/2025 due to miscommunication by the learned advocate. It further appears that by order dated 28/1/2025, the warrant of arrest was issued. Upon perusing the order passed by the learned magistrate, it appears that opportunities was granted by the learned magistrate to be present on court dates, and it appears that the petitioner could not make himself present. Neither he was represented by any lawyer. In the facts and circumstances, this court does not find any error in the order passed by the learned trial court. However, in the interest of justice, this court is of the view that no fruitful purpose will be served by keeping this matter pending. Thus, this matter is disposed, granting liberty to the petitioner to surrender before the learned magistrate in GR 6467 of 2022 within a period of 1 week,
No, 2 weeks, Milord.
from 2 weeks from date. In the event, the warrant of arrest issued on 28/1/2025 in GR 3467 of 2022 by learned Chief Judicial Magistrate at Howrah in Shakrel PS case 629 of 2022 shall remain stayed. Stop. In the event the petitioner surrenders and applies for regular bail, the same may be considered in accordance with law. The matter disposed.
'81, Milord, I am for the petitioner, Milord. Milord, praying for quashing of the proceeding. The short question of law is that, Milord, the proceeding, the investigation is barred by 167(5) of CRPC, and taking cognizance is barred by 468 CRPC. Milord, the background of the case, if I may place before your lordship, that 2016, there was the de facto complainant got married to the petitioner number 1, and petitioner number 2 is the mother-in-law who is a senior citizen, my lord. Now, my lord, if your lordship kindly turns to page 21. Page 21, this is a my lord 156 clause 3 application on the basis of which will be revealed my lord from page 22, 156 clause 3 petition. My lord, if your lordship kindly turns to page 21, the date of FIR. The date of FIR is, my lord, kindly note 14th February 2022. 14th February 2022. Now, my lord, kindly turns to page 25 of the FIR, of the petition, page 25.
Yes.
Your lordship will find the paragraph 3. এমত অবস্থায় গত ইংরেজি 2020 সালের অগস্ট মাসে আসামিগণ আরো নগদ টাকা প্রচন্ড মারধর করে এবং তার জন্য তাকে বাদিনীকে তাড়িয়ে দেয়। The next paragraph, paragraph 5, শেষে গত ইংরাজি 18/7/2021 তারিখে সকাল 10টা নাগাদ বাদী আসামিদের বাড়িতে গেলে আসামিগণ বাদিনীদের ঘরে ঢুকতে দেয়নি and thereafter গালিগালাজ করে বের করে দেয়। So, my lord, last date of offense is also, my lord, 18th July 2021. 18th July 2022, kindly note the date, my lord, 18th July 2021 is the last date of offense. The FIR was submitted, the 156(3) was lodged, my lord, on my lord 6th August 2021, and FIR was lodged on 14th February 2022. Since then, my lord, 3 years, 3 months have passed. Now, my lord, no charge sheet have been submitted. Now, your lordship is aware of the section 167(5) West Bengal Amendment Act that, my lord, more than 2 years, the investigation has to be stopped and, my lord, accused has to be released. But no magistrate has not taken any step.
But magistrate, with the permission of the magistrate, it can continue.
My lord, magistrate has not taken, no, my lord, that is the subject. That part has also been clarified by the Honorable High Court, this Calcutta High Court, that my lord, application of condonation of delay.
When did you surrender?
No, I surrendered much long before, my lord.
No,
That is, my lord.
there is a provision that from the date of arrest, if the charge sheet is not submitted.
Well, I surrendered, my lord, 2021 itself only. But the 167 provision is that.
No, let us see the.
My lord, let us see 167. 167, my lord, West Bengal Amendment Act.
Yes. Yes.
May I read, my lord? Yes. But kindly see West Bengal Amendment Act number 1 for subsection 175 substitution would be any case triable by magistrate is a summon case, which is not applicable here. And for that, my lord, period is 6 months. And, my lord, or any case exclusively triable by court of session. The
investigation is concluded within a period of 3 years.
3 years.
The date when you were arrested.
My lord, kindly.
You were arrested or when?
I am coming to that, my lord. And, my lord, from the date on which any case other than those mentioned in clause 1 and 2, the investigation is not concluded in the period of 2 years from the date on which the accused was arrested or made his appearance. Now, my lord, I appeared, my lord.
No, that means you surrendered.
My lord, I
surrendered and obtained bail.
Yes, my lord.
So that means when?
My lord, at that I am saying, my lord, my lord, 21 February 2022, page 29, my lord. Kindly come to page 29. And thereafter, my lord, this is the petition number 1. And my lord, petitioner number 2 surrendered on 1st March 2022. That is page number 31. Page number 29 is the, my lord, mother-in-law when surrendered. That is,
yes,
February 2022. And, my lord, I surrendered on 1st March 2022. I am covered by 167, my lord. 3 years have already passed. Not only that, my lord, 468 also there is bar.
So charge sheet is not submitted.
No, my lord, not yet submitted. This is the only short question of law, my lord.
Learned advocate for the petitioner is present. Art learned advocate for the petitioner. Learned advocate for the petitioner submits that the petitioner has filed this application to quash the FIR number 53 of 2022, dated 14/2/2022. Stop. It is submitted by the learned advocate that pursuant to the arrest of the accused person under section 167(5) of the Code of Criminal Procedure 1973, as amended with regard to West Bengal, no investigation can continue after a period of 2 years from the date of arrest of the accused persons. Learned advocate draws attention to the petition and submits that how many petitioners are there?
Well, there are two petitioners.
So that both the petitioners have surrendered in the year?
In the year 2022, one is
The year
in February 2022,
2022.
and Milord March 2022.
More than 2 years have passed, but the investigation is not complete. Stop. Upon hearing the learned advocate and considering the facts of the case, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties. There is nothing on record to show that there is an order of the magistrate permitting further investigation. Stop. Let notice issued upon the opposite parties. Within 1 week after vacation, an affidavit of service be filed. Let the matter appear 3 weeks after vacation. Pending hearing of this application, let there be a stay of further investigation in further proceedings,
my lord,
with regard to Baguihati Police Station case 53 of 2022, dated 14/2/2022, pending before learned Chief Judicial Magistrate Barashat, North 24 Parganas.
Most obliged, my lord.
81, 84. 84.
My lord, I am for the petitioner, your lordship. My lord, in this case, I have challenged the initiation of the FIR, your lordship. My submission is that it is not at all in accordance with law. My lord, in short, what happened, my lord?
আরো তো তিনটে আছে 88, 89, 90. এক মিনিট তিনটে আছে 88, 89 যদি থাকে অবশ্য 88, 89, 90 আর 97 যদি থাকে, না থাকলে কোনো ব্যাপার নেই.
May I, my lord?
Yes, item.
My lord, item 84.
Yes.
My lord, I have challenged the initiation of the FIR, my lord. My lord, here the case is, the complainant's allegation is that on 14th of March, that is on the day of Holi, she attended an event at a 5-star hotel. She lost her phone on that day. She visited the police station on the very day at the evening. She lodged a GD, but this does not disclose a cognizable offense and it was not reduced to an FIR. 5 days later, she again came up with a manufactured complaint. She lodged the same as an FIR, your lordship. What I am humbly submitting is that, my lord, initial information that discloses cognizable offense should trigger police investigation, not any subsequent manufactured complaint. Your lordship kindly comes to the complaint at page 26. Everything would be clear, your lordship. Page 26. She had herself admitted that in the letter of complaint.
Yes, thereafter?
My lord, thereafter what happened, my lord? My submission is that to address these kind of situations, my lord, a new section has been introduced in the BNSS, that is 173 subsection 3, which lays down, your lordship. My lord, may I?
Yes.
173 subsection 3 of the BNSS, your lordship. Kothay?
173 subsection 3.
My lord, may I? It states 173 states that.
Yes.
My lord, may I?
173 of
BNSS, your lordship. Suraksha Sanhita, that is
the punishment.
My lord, may I? 173 subsection 3. My lord, of the BNSS, that is erstwhile CRPC.
Yes, yes. One 173, yes.
My lord, 173 was asked while 154.
This is there. So your grievance is with regard to the subsequent lodging of FIR.
My lord, subsequent lodging of
This
FIR
was lodged on 26, page 26.
Page 26 was lodged on 19th of March. Incident is of 14th.
Yes, thereafter?
Thereafter, what happened, madam? Without conducting any preliminary inquiry or taking permission from the DSP, as stated in the EA, they have issued 41A notice on 29th when all courts were
This was not instituted.
My lord, case was instituted, my lord.
On this complaint, the case was
On
instituted.
this complaint, the case was instituted without addressing anything about the asked while GD entry, which she has mentioned in the letter of complaint. And I have been served, I am a housewife, your lordship, from a well-to-do family. I'm a middle-class housewife. I have been served with a 41A notice on 29th of May when courts were closed and asked to attend within 3 days. Otherwise, I have to face arrest. Absolutely, they have blatantly disfollowed the statutory provisions, my lord.
Learned advocate for the petitioner is present. Our learned advocate for the petitioner. Learned advocate for the petitioner submits that the petitioner has challenged the institution of the case on the second information given by the de facto complainant. Top. Learned advocate submits that the police authority ought to investigate on the very first information report which is submitted with regard to a particular incident and cannot rely upon the subsequent information. Stop. Learned advocate submits that the information received on 19/3/2025 cannot proceed further with regard to investigation as it is not maintainable in law. Upon hearing the learned advocates and upon considering the nature of the case, this court is of the view that this application should be admitted. Thus, I admit this revisional application. Let notice, notice pending hearing of this application, there shall be a stay of further proceedings with regard to Bidhannagar South Police Station case number 60 of 2025, dated 19/3/2025, under section 303(2) of BNS 2023, corresponding to GR case number 306 of 2025, pending before the Court of Learned Additional Chief Judicial Magistrate Bidhannagar, North 24 Parganas, for a period of 4 weeks from the date of reopening after vacation.
Grateful, lordship. I shall serve in the meantime, your lordship.
Grateful. I beg to appear on behalf of the petitioner, my lord. In this matter, my lord, I am challenging the order dated 9th of April 2025. My lord, kindly see, my lord, very short, madam. Kindly, my lord, take off the certified copy once, my lord. Third page of the certified copy, my lord. My lord, got it?
Yes.
Kindly see, my lord, I have filed a discharge application. Next to it is a discharge applications. The learned judge, what he has done, my lord, he has framed the charge and thereafter rejected my discharge applications. My right has been waived. Kindly see, my lord, I am on Bulan here, my lord. Accordingly, from 4th paragraph, I hereby frame the charge against the accused person, namely Jadab Sheikh, Bulan Mia, MD Latifuddin, Rentu Sheikh. Bulan Mia is the petitioner.
Which sections?
Well, the sections are 307 in Old Act and 341. My case is that, my lord, no one names my name. 180 notice was given. I went to the police stations and police implicated me. I made up my entire, kindly see the order. Next to it is my petition. My lord, kindly see, my lord, my petitions. Nothing was dealt by the learned judge. Next to it, my petition, my lord. My main submission before the learned court is that only mere suspicion is not enough to implicate me. There must be a grave suspicions. My lord, kindly see next to petition, my lord, and the order kindly see.
So what have you prayed? Quashing of the case against...
My lord, I am challenging the order of framing of charge discharge application, the order 9th of April 2025, my lord.
This what have you stated? Yes. Learned advocate for the petitioner is present. Hard learned advocate for the petitioner. the petitioner in the instant application has challenged order dated 9/4/2025 passed by learned ADJ Bolpur Birbhum in sessions case number 6 of 2025. Stop. Learned advocate submits that the learned trial court framed the charge without passing any reasoned order on the discharge application. Upon perusing the discharge application and the order passed by the learned trial court, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week after vacation. Let this matter appear 3 weeks after vacation. Pending hearing of this application, let there be a stay of sessions case number 6 of 2025 pending before ADJ Bolpur Birbhum for a period of 4 weeks after vacation.
Time for the petition. And Mr. Dev is appearing virtually. And have challenged an order dated 2nd May 2020.
Malad, I appear on behalf of the Malad petitioner as 89, I think.
22nd May.
22nd May 2025.
Malad, may I, Malad, address your Lordship? Malad,
okay, this is the...
Lordship is order. Lordship can hear me, Malad?
Yes.
Malad, in short, Malad, unfortunately, my video I cannot on, Malad. It's very short matter, Malad. Almost identical to the one which Lordship has had. I filed an application for discharge, Malad, before the court below, which were dismissed. And, Malad, against that, I have come up before this honorable court for quashing of the entire proceeding. And, Malad, learned court below has entirely proceeded on the basis of, Malad, suspicion and apprehension of the others. Now, Malad, the law is well settled and held by the Supreme Court in 2010, Volume 2, Supreme Court Cases 398, which says, Malad, Lordship knows it, if two views are possible and one of them gives rise to suspicion only, as distinguished from grave suspicion, the trial judge will be empowered to discharge the accused. And, Malad, at this stage, he is not to see whether the trial end in a conviction or not. And, Malad, my case is, Malad, I tell you, Lordship, if Lordship sees the order impugned, in last 3 paragraphs, it has been recorded that merely on the basis of an apprehension, Malad, my name was registered. Initially in the FIR, Malad, my name was there along with 7 other persons. Now, when the charge sheet was filed, Malad, 7 other names, Malad, their names were deleted. My name was there and 3 other persons' names were added. Since I was a member of the Legislative Assembly, Malad, MLA, Malad, there was a rivalry between the 2 political parties. A person, Malad, died after receiving a phone call. And nothing has been found from me, no direct evidence, nothing. Malad, Lordship would find from page 25, Malad, the statement of the wife of the person who died, Malad. Nothing comes straight. Nothing comes, Malad, directly against me. So, Malad, what I pray before your Lordship, Malad,
accused persons
kindly,
are here.
grant us an interim.
So how many accused persons are here?
Malad,
Initially, FIR name was 8.
Malad,
Thereafter,
initially,
6.
Miss
Discharge,
Ghosh, just wait.
7 was discharged.
Initially, Malad,
Presently 4. Including me, 4.
Initially 8. When I was there, 7 were discharged at the time of framing of charge sheet. Then 3 persons were added along with me. So presently 4.
Yes.
My grateful, Malad.
Yes. Learned advocate for the petitioner is present. Our learned advocate for the petitioner. The petitioner before this court is an accused in
Malad, in special case number 1 of 2025.
In special case number 1 of 2025,
arising out of Barwan police station case number
79 of 2020. On the ground that the application for discharge filed by the petitioner was not decided by a reasoned order. On perusing the petition filed by the petitioner and the order dated 22/5/2025 passed by the learned trial court, whereby the learned trial court rejected the petition filed by the petitioner. This court is of the view that this revisional application should be admitted. Thus, I admit this revisional application. Let notice be issued upon the opposite parties and affidavit within 1 week after vacation, and let affidavit of service be filed. Let this matter appear 3 weeks after vacation. Let the case diary be produced by the opposite party state. Pending
But
hearing
kindly stay till 6 weeks after vacation. This is my prayer.
of this application, there shall be a stay of further proceedings in special case 1 of 2025 pending before the Court of Law Judge, Special Court West Bengal, MPs and MLAs cases at Bidhannagar, North 24 Parganas for a period of 4 weeks from the date of reopening after vacation.
I'm grateful, Milord. I'm grateful.
Grateful, Milord.
Grateful, Milord. My video is not working, Milord. Kindly, Milord, pardon me for this, Milord. Grateful.
Item 90.
Thank you, my lord. I am appealing for the petition. My lord, here the peculiar, my lord, order has been passed in the criminal jurisdiction by the additional chief judicial magistrate. If your lordship kindly come to the page 51, my lord, the learned additional chief judicial magistrate decided the issue which was involved under section 14 of the Surfacey Act. My lord, that is not at all applicable before the additional judicial magistrate, and additional judicial magistrate ordered the cell beliefs to act as a commissioner and to the evict the petitioner within Malad 36 2025.
The Chief Judicial Magistrate is having the jurisdiction of
See the section 14 of the
no. So far Calcutta is concerned. Chief Metropolitan Magistrate.
No, this is Alipur.
Chief Judicial Magistrate.
Additional Chief Judicial Magistrate decided the issue which was involved under section 14 of the Surfacey Act. And my lord, if your lordship kindly see more for a moment, page 51, the petitioner from top, the petitioner has filed an application on 21st/1/2024 under section 14 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, herein after referred as said application. And what order he passed, the learned court below has been passed. My lord, page 52, kindly come, my lord, see for a moment. The last para, hence it is ordered. That is, my lord, from top after 1, 2, 3, 4,
No,
5,
page
6, 7.
52.
Page 52. My lord, I annexed one order and then impugned, again I annexed. Page 52.
No, you are not paginated.
Page 52, my lord.
It is not paginated.
Then, my
Anyway, this is a certified copy.
Certified copy. Certified copy, second page. Hence, it is ordered. The cell belief of this court is hereby appointed as court commissioner. My lord, cell belief is only working in the, my lord, court internal workings. Appointed as a court commissioner to take possession of the secured asset mentioned herein above as the scheduled property, and which, my lord, the learned court below passed. Next page, third page, inner page, that is from bottom second. For removal of doubts, it is made clear that objection application, if any, may be preferred by any borrowers, guarantor, mortgagor, lessee, or any other aggrieved person before the debt recovery tribunal having jurisdiction as per the amended provision.
Learned advocate for the petitioner is present. Hard learned advocate for the petitioner. The petitioner in this case has challenged the jurisdiction of learned additional Chief Judicial Magistrate Alipur, South 24 Parganas, in passing order under section 14 of SAR FAESI Act. Learned advocate draws attention to the order dated 14/5/2025 passed by the learned Chief Judicial Magistrate. Yes, but this is the possession notice.
My lord, this is the order passed under section 14.
No.
Possession notice has been given, my lord, prior.
No, this is page 51 is the possession notice.
No, page 51, my lord.
Oh, page 51.
As the
order, my lord, that
No, this is the court beliefs or notice. That
Yes.
is the order of the CJM.
my lord, CGM order, that is page impugn order, I annexed. Page 50, my lord, once I annexed and then
Page
again.
50.
Page 50, from 50.
No,
That is
50.
position notice.
No, position notice is the notice issued by
Yes,
the.
then my lord, to bottom, copy of the order dated 29/3/2025.
So where is that order? 29.
That is the 51. My lord, order dated 29/3/2025.
No.
51.
Page 51.
Yes, from top. Order dated 29/3/2025.
Okay. Order dated. Additional Chief Judicial Magistrate Alipur on 29/3/2025 in miscellaneous case 37 of 2025. Learned advocate submits that the learned magistrate erred in assuming jurisdiction under section 14 of the Surfacey Act. Stop. Learned advocate further submits that this order passed by the learned magistrate is not sustainable in law. Upon hearing the learned advocate and considering the order challenged, this court is of the view that this revisional application should be admitted. Thus, I admit this revisional application. Let notice be issued upon the opposite parties within 1 week after vacation. Let this matter appear 3 weeks after vacation. Pending hearing of this application, let there be a stay of further proceedings. Let there be a stay of the order dated 29/3/2025, passed in criminal miss case number 37 of 2025 by learned additional Chief Judicial Magistrate Alipur under section 14 of the Surfacey Act for a period of 4 weeks from the date of reopening after vacation.
And my lord, stayed all the further proceedings.
Yes. So far the miss case is concerned.
Grateful, my lord. My lord, with permission, may I submit one thing, my lord?
Yes.
Item number 41 and application for anticipatory bail. Matter is adjourned as the advocate for the state was not present, my lord. He is present.
So now I cannot take it up because I have taken up this division. Okay. Whatever I have to take, whatever you do it before the regular bench. আচ্ছা এটা আর বাকি আছে 90 হয়ে গেল আচ্ছা 97 টা দেখে দিন
Lordship, I bow down. I am
Your,
appearing.
your Lordship, I am the de facto complainant, Your Lordship.
Lordship,
This
I am
should
the
have
revisional
appeared.
applicant. Let me
This has been
submit,
appearing in
Lordship.
the
This is my
regular
application,
list of
Lordship.
the
Your
Honorable
Lordship,
High
please
Court, Your
admit
Lordship.
Lordship,
He should have.
kindly
He
hear
has
the matter,
not
Lordship.
mentioned
This is
this
a short
matter.
matter.
for the past 6 months.
Yes, Lordship,
Your
I am the
Lordship,
applicant. I am the applicant there. This is my
Your
application,
Lordship,
and
Your
I am the
Lordship.
revisional applicant, Lordship.
This is a
Kindly
misleading
let me
matter,
submit,
Your
Lordship.
Lordship.
Page number
He has
112 of my
not
CRAN
mentioned
application,
this
Lordship.
matter.
Yes, item 97. Who is appearing?
I am appearing for
I
as
am
a de
applicant.
facto, Your Lordship.
Lordship, I am the revisional applicant. This is my petition, Lordship.
Your Lordship, this is
Let me
pending
submit
since
first, Lordship.
October last year,
Lordship, kindly
and
see
it was
page
heard
number
by Honorable
112.
Justice Shubhra Ghosh. He is avoiding the regular
100,
bench, Your Lordship,
112.
and he is
Lordship,
misleading
he is
each and
accusing,
every
he is
court,
misleading. He has
including the
submitted false
learned
affidavit
magistrate
before the
CMA.
learned court in the name of High Court, Lordship. Your Lordship order
Yes,
has
item
been deviated.
97.
Yes, Lordship, kindly see page number 112, Lordship.
And I have not received a copy of the CRAN, Your Lordship.
What is this CRAN for? What is this CRAN application for?
I do not know, Your Lordship, because the
No, I am asking
revisional
you,
application
what is
itself
this
has
CRAN?
become
Lordship, page number
infractious.
Lordship, let me submit
No.
first. What kind of submissions he is doing? Lordship,
what
I
is
am
this?
appearing for application. Lordship, I am telling the CRAN is for stay as because the revision application was admitted and your Lordship had given liberty to me for praying adjournment before the learned court below as the matter is sub judice before this honorable court. That was your order, page number 112, Lordship. Kindly see.
Your
112,
Lordship.
113, Lordship. Kindly see, let me submit.
Your Lordship, he is
advocate,
submitting.
kindly let me submit.
When is the next date fixed?
Yes, Your Lordship, on 18, Your Lordship, on the next month, Honorable Justice
before the
Shubhra
court.
Ghosh
Kindly
set
see
aside this
122.
interim.
He has said that no adjournment has been given by your Lordship. He is
Your Lordship,
misrepresenting this court order.
misleading. Your Lordship
Kindly
is
see
misleading
122 page number.
because an order
Page
has
number
been passed by the
122, Lordship.
learned MM
He is
on
submitting
29th.
false before the
When is
court.
the next? When is the
Your
next?
Lordship, Your Lordship, on 18th, 14/11/2024, Your Lordship, the order may be seen, Your Lordship. The Honorable Justice Shubhra Ghosh had not given any interim
Every time
relief,
she
nor
discussed
it
this.
was extended. Although he had
Lordship,
been
that was
misleading,
the no
although
interim
he
order
had
has
been
been
misleading,
granted,
and
Lordship.
finally the question which has
Every
been
time she
raised in the
does this,
revisional
Lordship,
application has been
disrupts the court procedure.
already
She does not
decided
let
by
me
the
submit.
learned MM on 29th of March
He is disrupting my
2025.
submission, Lordship.
Now, your lordship, he has come before this honorable court, avoiding the
Lordship,
regular bench
kindly allow me to
because
submit,
it has
Lordship. This is my
become
application.
infructuous. I may be allowed to read out the order passed by the Honorable Learned MM Bankshal Court dated 29th March
Lordship,
2025.
despite
Your lordship,
adjournment
where
liberty
it
given
has
by your
been
Lordship,
clearly
Learned
mentioned
Trial Court has proceeded with the case and has fixed for evidence. Learned Court has not been
because
allowing my adjournment petition,
no,
despite
because
your
he has
Lordship has
been
granted me
misleading.
liberty.
He has been misleading the court and
Where
has
is
been
that
taking
order refusing
adjournment
that?
for the last 6
That
months.
order.
Your lordship.
Yes, please.
Order
read
is
the order.
I may be read out.
Learned
I may be allowed to
advocate
read
for the
out.
petitioner and learned advocate for the de facto complainant is present.
Lordship,
Learned
kindly grant a short stay,
No,
Lordship.
your lordship.
Let the
They
revision
have been
application be heard
issued
out.
warrant of arrest, and they are the
learned advocate for the de facto complainant submits that although there was a direction by this court that the petitioner, that the parties will be at liberty to pray for adjournment, but no such adjournment is granted. As no such refusal order is annexed to this petition, the petitioner is granted liberty to annex copy of the order where adjournment was refused for further consideration of this application. Let this matter appear on 10/6/2025.
Grateful, Lordship, grateful.
Yes. এটা দিকে এটা তো motion. Yes.
Milord, I am for the petitioner.
No. What is
Here
the order? What was the order passed?
Milord, order passed on 22nd May that he was arrested and
No, you are challenging 25/2025 order.
No, Milord, I am challenging 22/5.
Yes.
Milord, when he was in custody till 31st May, a put-up application was made by the said petitioner wife in a plea that if he was released on 31st May, he will flee away. Milord, on hearing a consecutive detention in civil prison is not allowed when there is a scope of OP may flee and would not pay anything, whereas the petitioner has to remain in the same destitute condition. Milord, in a maintenance case, the maximum detention of the warrant is 30 days. There is no cognizable offense for increase of the detention period consecutively in a
Learned advocate for the petitioner is present. The petitioner, learned advocate for the petitioner submits that although by order dated 2/5/2025, the petitioner was to be released from civil prison on 31/5/2025, but the said order is extended by the learned magistrate on 22/5/2025. It is further submitted that once an order has reached its finality, that cannot be modified or recalled. Upon hearing this, learned advocates, and considering the facts, this court is of the view that this application should be admitted. Let notice be issued upon the opposite parties. Within 1 week after vacation, an affidavit of service be filed. And let this matter appear 3 weeks after vacation. No, let this matter appear 2 weeks after vacation. The petitioner, in terms of the order dated 2/5/2025, shall be released for a period of 2 weeks upon furnishing of certain conditions before the learned magistrate. Let this matter appear on 2 weeks after vacation. আচ্ছা আর আছে এইটার মধ্যে এগুলো ডেকে দিন আর কি 101 on Monday.
Lordship 102.
102, yes. When next date fixed?
Next date is fixed on 7 June, which is Saturday. For execution and possession will be taken tomorrow, Lordship. So I'll take 5 minutes of your Lordship's time.
Okay, 102 টা দেখি
101 also the possession will be
No, you can wait. 10th is the next date, you can wait.
My lord, 103 is that very urgent matter is that.
Yes.
What urgency? My application under Order 22 Rule 10 is pending since 2021.
So expeditious disposal.
Yes, my lord. Nothing more. Expeditious.
103.
103.
Acha. 103. Acha. Hard learned advocates. Upon hearing the learned advocates, this court is of the view that the service of the opposite party may be dispensed with. Let this matter appear for orders on 11/6/2025.
Four. And next 4, my lord, similar, my lord. My application under Order 1.
Okay, 4 also.
4 also, Order 1.
11/6, same order.
And my lord, 5, my lord. 2 applications are pending. One for Order 39 Rule 1 and 2. And the application
only for expeditious disposal.
Expeditious, my lord.
Okay, 105 also same order. Yes, 102.
Lordship. Lordship, this is I'm appearing for the petitioner IOCL. Lordship, I am a lessee in respect of a property.
What is what is the order under challenge? Let me see.
Lordship, this is order. Lordship will find in page number 72.
Mention করা ছিল। আচ্ছা কপি।
আচ্ছা extra we have an extra copy of the
Yes, give the copy.
Lordship, the impugned order.
Let me see. Hey, ওই কপিটা নিন তো একটু। Yes.
Page 72, Lordship.
So this is the okay.
I'll just indicate them. I has happened.
Yes, just learned advocate for the petitioner is present. Learned advocate submits that the date for issuance of writ is fixed on 7/6/2025. Stop. And there is urgency in this matter. Considering that urgency, let this matter appear on 11/6/2025. As this matter is sub judice before this court, the petitioner may seek necessary adjournments on the date fixed, which may be considered. Opportunity to make a pray for adjournment.
Lordship,
just a minute. Let no steps be taken by as the matter is sub judice before this court, let no steps be taken for a period of 1 week. Let this matter appear on 11/6/2025.
I'm good.
My lord, my 3 matters expeditious disposal order.
Yes, I shall pass necessary orders on the next date. I have reserved it for orders. Okay, on 12/6 I shall pass necessary orders.